Wish I could say I was finally over you, but that's not the truth. Everyone always keep falling in love again. What's wrong with them? I don't understand. Maybe it will pass by, someone save me. Before I pass out, I'm too lonely to be done, I'ma drink at this place. Yeah. Why am I the only one who's left in the rain with nobody to hold on to? Why am I the only one who's feeling this pain when there should be two of us? And yeah, I know we both wanted different things, but letting go just comes easy and you don't. Why am I the only one who's left in the rain? If I had an option to be someone else, I would. And like all of you, I know that I'm obvious, forget I'm made this way, but why didn't I stay when I had the chance? Maybe it will pass by, someone save me. Before I pass out, I'm too lonely to be done, I'ma drink at this pace. Yeah. Why am I the only one who's left in the rain with nobody to hold on to? Why am I the only one who's feeling this pain when there should be two of us? And yeah, I know we both wanted different things, but letting go just comes easy and you don't. Why am I the only one who's left in the rain? The only one that's left in the rain. The only one that's left in the rain. Am I the only one? 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 Wish I could say I was finally over you, but that's not the truth.
Don't think that you know I'm trying hard to show. These days it's hard to tell what's on your mind. Why don't you stop pretend like this is what we planned? I can see the end is coming down. And if I don't look back, will you let me get away? If I turn my back and walk, will you stay? I have waited for you. I have waited for you. And
It's late here. It's actually, I've been up all night. It's actually almost 5 a.m. and I'm drinking coffee and recording. I had a thought. I wanted to do something on the James Crumbley trial because I know a lot of you guys that followed me in the Jennifer Crumbley trial were like, Kerry, what the hey? You just dropped it like a hot potato. And I'm going to tell you why I did that, because I kind of figured what happened was going to happen. That freaking trial, you guys, is almost a duplicate. Well, let me put it this way. The trial, the representation from the prosecution is a duplicate. The defense, on the other hand, completely different. Not completely. Well, it's pretty different. It's pretty different. I haven't watched it yet. I just know it is because I've seen a couple of clips here and there. And also, I thought the best way to kind of review this with you guys is to watch the opening statements, both of them, the prosecution and the defense. Then we'll go back and watch just the defense cross. Because if you watch the other piece of it with me, if you watch Jennifer Crumbley trial, you know what the prosecution did. You know what their cross was or whatever their examination was of the people. So then we'll just do the defense side. And then at the end, we'll do closing arguments. How does that sound? Okay. Spoiler alert. They had said that they were going to bring some stuff in from Ethan's trial, or I saw something. I'm going to be honest with you guys. I've stayed away from this trial just because I had other things going on. But I saw something that was going to be different in this trial than the other one. It had something to do with information from Ethan or something Ethan said. Or at one point, I even thought I saw that he was going to testify. But I guess we'll find out here soon. If you know, drop it in the chat like it's hot. And then we'll see. We'll inform everyone. This is going to be put on YouTube as a premiere. So I will not be commentating live, but I will be in the chat with you possibly, more than likely. So let's watch the opening statements and go from there. Okay, I'm going to put up the Fox stream on this because I like the way they did this. I like the way they organized it on their playlist. So it's easier for me. So here is the prosecution opening remarks.
November the 30th, 2021, James Crumbley's 15-year-old son walked out of the boys' bathroom in Oxford High School holding a 9mm handgun. James Crumbley's son walked out, he pointed, he aimed that 9mm and fired it 32 times over the course of the next 9 minutes. He fired that weapon at teachers and students. He killed 4, wounded 7, and terrorized the entire community. James Crumbley bought that gun that his son used to kill as a gift for his son 4 days before the attack. James Crumbley failed to secure that gun in a way to prevent his son from accessing it. Anna was 14 years old. Madison Baldwin, she was 17. Tate Muir, he was 16. Justin Schilling, 17 years old. These are the 4 students who never made it home that day. What happened inside that school was truly a nightmare come to life. But it didn't have to. That nightmare was preventable. There are 3 people in this world who are criminally responsible for the deaths of Hannah, Madison, Tate, and Justin. The shooter who committed murder, no doubt he's responsible. But so are his parents. But not for murder. They're responsible for their gross negligence, for involuntary manslaughter. Because that nightmare was preventable and it was foreseeable. The shooter's case is done. The shooter's mother, Jennifer Crumbley, her case is done. You're here to decide the level of gross negligence of James Crumbley. And you will learn throughout this trial that he was the adult out of anyone in the world in the best position to prevent these kids' deaths. You're going to learn that those kids would still be alive today had James Crumbley seized any one of the tragically small and easy opportunities given to him to prevent his son from committing murder. Any one of them. These were opportunities that were literally given to him, yet he disregarded. During this trial, you're going to hear about events from the spring of 2021 through December of 2021.
He seemed kind of like a hands-off dad, didn't he? Well, I don't know. Maybe I'm saying that wrong. Not like a hands-off dad, but kind of like you could tell that Jennifer ran the show in the house. I picked up that vibe from it all. Did you guys pick that up?
November of 21 is the critical time period, especially November the 30th. But that earlier evidence is going to give you some context into the family life in the Crumbley household. It's going to give you some context to learn that the shooting didn't just happen out of the blue. The shooter didn't snap. What happened was foreseeable, especially to his father. I'm going to talk to you about some of the evidence that you're going to see through this trial. And we'll start with this. This is a 6-hour 9mm handgun. This was a firearm purchased by James Crumbley as a gift for his son on November the 26th, 2021. Found on his phone the day that gun was brought home. This is an Instagram post from the defendant's son. The next day, November the 27th, 2021. That's after his mom took their son to the shooting range to practice with that gun. Took my new SIG out to the range today. Definitely need to get used to new sights, LOL. This is a post from Jennifer Crumbley, the shooter's mother, the defendant's wife. That same day, November the 27th of 2021. Mom and son day testing out his new Christmas present. My first time shooting a 9mm. I hit the bullseye. You're going to learn that it wasn't just those 2 extra magazines for the handgun in the plastic case that came with it when James Crumbley made that purchase. You see, he was given the tools to make that firearm safe. He was provided a cable lock. It was provided by the manufacturer, by Sig Sauer. It went to the firearm dealer who sold it to James Crumbley. It was for that gun. This is what it looked like the day the gun was purchased, November the 26th, 2021. This is what it looks like now. Still in its original packaging, still with both keys in the lock. It was never used. The decision that James Crumbley made to buy that gun as a gift for his son was made even though he knew that his son was in the midst of total and complete social isolation and had been in a downward spiral of distress that had been going on for some time. You'll see evidence that as early as spring of 2021, the shooter had expressed to his one and only friend that he had asked his father for help. He told him to suck it up. That was in April of 2021. You'll learn that instead of receiving help or intervention of any kind, James Crumbley instead began to take his son to the shooting range, even buying himself a .22 caliber Kel-Tec semi-automatic pistol, and his son a different gun, .22 caliber 2-shot Derringer. That was June of 2021. They would go to the range together on a consistent basis over the next few months. We have evidence of a number of trips, and you'll see some of that. Some of this background is going to shed light on what happened in November of 2021. This is a pivotal month in the Crumbley home. As I said, the shooter had one and only one friend. That was no secret. James knew about that. You're going to see evidence that the shooter and this friend would communicate with each other throughout the day and throughout the night. The level of data on that text message conversation alone dwarfs everything else on the shooter's phone. You'll hear evidence that there were over 22,000 text messages in just 1 year than the shooter and his friend. Those two shared quite a bit with each other. This is the friend that the shooter confided in when he asked his father for help. That friend was taken from the shooter at the end of October 21. He didn't just move schools and go to another town. He was taken out of state without warning, without notice, and without a way to communicate. The impact on the defendant's son was severe. His entire social connection was severed, and James was there to know about it. You see, he wasn't working at that time. From November the 1st to November 9th, he didn't have a job. And when he did work before that, it was from home. When he did get a job on November the 10th, it was for DoorDash, where he could set his own schedule and decide when he did work and when he didn't work. It was also during this month of November that the defendant's son began to write in a journal. Some of that is going to be permitted to be shown to you, and Judge Matthews decides what you see and what you don't see. The portions you'll see is that the defendant's son wrote about how he was begging his parents for help, how he's begging for a more powerful 9mm handgun to commit the school shooting, and how he was able to obtain access to the murder weapon. Again, this evidence is important for you as background to what happened on November the 30th, but it also gives you a glimpse into the level of knowledge possessed by James Crumbley when he made the decision to buy that 6-hour 9mm handgun for his son on November the 26th, and then, just as importantly, what he decided not to do the morning of the shooting. You see, James Crumbley was afforded what might have been the easiest, the most glaring opportunity shooting, a full 3.5 hours on November 30th before the first shot was ever fired. Because he was shown this. This is a math worksheet. These are drawings and writings from the defendant's son, November 30th, 2021. One of his teachers saw him doing this, took a picture of that, and sent it to the shooter's counselor. The counselor came down and took the shooter out of class, brought him to his office to find out what was going on. You will learn it took that counselor all of 20 minutes to decide that immediate parental intervention was required. He made that decision even though he had about a fraction of the knowledge possessed by James Crumbley. You see, this drawing, as well as an altered version created by the shooter, were both sent from that counselor to Jennifer Crumbley, who shared it immediately with James Crumbley before they arrived at the school. The severity of the situation wasn't lost on James and Jennifer Crumbley either. They expressed their concern about what they see here, the words "help me," blood everywhere, a picture drawing of a gun, of a person with 2 bullet holes in blood. They expressed their concern about that drawing to themselves in Facebook messages. This is Jennifer Crumbley, she's in blue. Call now, all caps, emergency. This is November the 30th, 2021 at 9:33 in the morning. Followed simply with emergency. Then she sends her husband, James, the defendant, both the original drawing as well as the altered version of it that the shooter created. That's at 9:38 in the morning. James Crumbley's response, "My God, WTF." And then he says what he was actually doing that morning. "Vet not here. It's McElmurray's for Kira's horse. Still waiting on the vet." You see, James and Jennifer Crumbley spent quite a bit of time away from the home, tending to their horses. That's what he was doing the morning of the shooting. Jennifer Crumbley, he said he was distraught about last night. "James, we talked about it this morning." "You talked to him?" "Jennifer, can you call?" "I'm heading to his school. I'm very concerned." That was at 10:04 in the morning. Unfortunately for everyone, they kept that private concern to themselves. They didn't share it with the school counselor. Despite what they knew, despite what they thought, James Crumbley and his wife, neither one of them, mentioned anything about the gun being purchased for him 4 days before the shooting. James Crumbley didn't say a word about how that picture of the gun that his son drew looked identical, that you will see, of the 6 Sauer 9mm. They didn't say anything about the prior request for help. James Crumbley didn't mention anything about the severity, the real circumstances of the shooter's friend being taken from him. They didn't just fail to inform in that meeting note. They also failed to act. It was recommended at that meeting that James and Jennifer Crumbley get help for their son then, immediately, that day. And they were provided with a list of resources with mental health providers that would fit any budget, any insurance plan, or even no insurance at all. But they didn't. James Crumbley didn't do anything. Jennifer Crumbley didn't do anything. Neither one of them called. They didn't take him home. The reason given to the counselors that they had to work. But James didn't mention that as a DoorDash driver, he set his own schedule. He didn't mention that he hadn't even signed in for the day for DoorDash yet. He was at the vet. Or that as a DoorDash driver, he was able to just put his son next to him in the car. It was one of those glaringly missed opportunities. But instead of seizing that incredible opportunity that was before him, James Crumbley spent the next 2 hours driving around town making deliveries, never once bothering to stop by his house, which was just a mile away, to check on the whereabouts of the gun that his son drew. Even when he drove by the house to do so, never once, he kept unsecured. That is until after the Oxford School District sent out an email blast to all district parents of an active shooter situation. You'll learn that that email reached James Crumbley about 1:10 p.m. And by pure happenstance, James Crumbley was at the exact location that parents of Oxford high school students were told to go in case of emergencies. Their reunification point is the Meyer on Ray Road next to the high school, directly adjacent to it. By pure coincidence, he happened to be at the exact location where hundreds of people were scrambling to get to. But he didn't stay. That's when he went home. That's when he went home to look for the gun. And that's because he knew. You will hear that there was one and only one person who called the police that day to identify their kid as the suspected shooter. It was James Crumbley. This nightmare, these murders, were preventable by him, foreseeable by him. During this trial, you're going to hear from between 15 and 20 witnesses. I do need to tell you that you won't hear from the shooter. Neither side is entitled to call him to the stand. You won't hear from Jennifer Crumbley. Again, neither side is entitled to call her to the stand. But you will hear a lot about what happened in the days, the weeks, the months before the shooting, specifically November the 26th and November the 30th. Again, those are the critical days. What happened from the 30th, from the time of the meeting to the time that first shot was fired. You're going to learn that throughout the investigation, investigators obtained information from social media accounts, from cell phone forensic analysis. They obtained banking records. They obtained GPS pings. So you're going to be able to put together a bit of a digital footprint of the Crumbley life. You're also going to learn what James and Jennifer Crumbley did after the shooting. Evidence would be presented to you to show that the defendant and his wife withdrew as much cash as they could, and they tried to liquidate their assets. They were found hiding from the police in the city of Detroit in an art studio on December the 4th, 2021. That's after they were charged with these crimes. Which you will never hear, and I want to make sure this is clear, you will never hear any allegation that James Crumbley knew what his son was going to do on November the 5th, that he bought the gun knowing what his son was going to do. If he bought a gun knowing his son was going to commit mass murder, then he'd be charged with murder. There is no claim that James Crumbley gave his son that firearm hoping he would murder 4 students. So then the question becomes, how is it that a father can be held responsible for the intentional acts of a teenage son? And the answer to that question is twofold. There's 2 reasons. First, it's important to remember that James Crumbley is not charged with murder. He's charged with involuntary manslaughter. Murder, or aiding and abetting murder, is an intentional crime. Involuntary manslaughter is rooted in negligence. It is by definition, causation, an unintentional killing. Second, it's because it takes a rare and specific set of circumstances to rise to the level of involuntary manslaughter when there are multiple causes of death. A rare set of circumstances. Those rare circumstances you will find present in this case. It takes gross negligence. It takes causation of death. And it takes that other person's acts to be reasonably foreseeable. Those are the three elements that must be proved. And that's what Judge Matthews is going to tell you. You will learn that the law says that in this situation, there are actually two different ways to find this defendant guilty of involuntary manslaughter. You're able to pick either because the law allows you to do so. Involuntary manslaughter is committed when someone's actions or inactions are grossly negligent, or their failure to perform their legal duty as a parent was grossly negligent. That gross negligence caused death, and not the cause. It was a cause of death. And that's important because the judge is going to tell you that there may be more than one cause of death, such as this situation, as long as that other cause was reasonably foreseeable to him, to the defendant. Not to everyone else in the world, but to him. The father who bought the gun, the father who raised the shooter, the father who knew what was going on in his life, the father who suspected him as a school shooter, well before his name was made public, well before anyone from the police department told him it was his son. The law allows multiple people to be held responsible in this case. And that's going to come to you from Judge Matthews. Gross negligence is the failure to use ordinary care to avoid a known danger, even though it was apparent to a reasonable person that serious injury would result. It's the willful disregard of danger. And that, ladies and gentlemen, is why we were here. James Crumbley's willful disregard of danger and his failure to use just ordinary care, when he was the one who knew the background, he was the one that knew the origins of this drawing. Him sitting in that counselor's office, looking at this drawing, and then not only staying silent, but then his failure to act, right there is his willful disregard of danger, right there. You're going to hear a lot of evidence and arguments in this case. It's important that we all understand that you're not here to decide on parenting. This case isn't about parenting. It's not illegal to be a bad parent. It's not kids doing kids things. We're here to talk about a preventable mass murder. No one will ever suggest to you that every parent can or should be held responsible for everything their teenager does. That's not the law. No one will ever suggest that to you. But in a situation where the father was in a position to reasonably foresee what the son was going to do, because the father armed him 4 days before and was shown a clear statement of intent of what the son was going to do. That is when that rare set of circumstances is present in these specific set of facts. James Crumbley is in charge with what his son did on November the 30th. James Crumbley is charged with what he did and what he didn't do on November the 30th. That is a very important distinction. That is what the law allows. That is what we were asking you to do. This case is not about guns. It's not about even how all guns should be stored in the home. It's not about gun laws. This case is about this gun for this kid with these issues, not secured, when shown this picture. That's what this case is about. when this kid was begging for a more deadly weapon. That's why we're here. I ask that you listen to the testimony, you review the evidence, and you follow the law. If you do that, you will undoubtedly reach a fair and just verdict. If you do that, you will find that James Crumbley was one of the 3 people in this world criminally responsible for what happened on November the 30th, 2021. And you will find him guilty as charged. Thank you.
Okay.
The events of November 30th of 2021 undeniably changed people's lives in ways that most people could never imagine.
See, it's so good. It just goes right into it. But okay, so here's the defense opening.
4 children lost their lives. Families were destroyed, and a community was terrorized. But this case is not about what happened inside of Oxford High School. This case is about what happened outside of Oxford High School. The prosecution alleges that James Crumbley was aware that his son was a danger to others, and that he failed to protect other people from his son. The prosecution alleges that James Crumbley had knowledge that his son could and would hurt other people, and that he failed to protect those people, that he failed to take steps to protect others. And ladies and gentlemen, that simply is not true. You will hear evidence in this case of what occurred inside of Oxford High School. You will hear the prosecution's version of what they claim James Crumbley may have known. You will hear that a gun was purchased on November 26th of 2021 by James Crumbley. You will hear what kind of a gun it was. It was a handgun. You will hear how it was stored. You may hear where it was stored. You will hear whether or not Mr. Crumbley's son knew where that firearm was. Pay attention also to what you don't hear. Pay attention to that you won't hear that James Crumbley knew that his son knew where that firearm was. Ladies and gentlemen, James Crumbley was not aware that his son had access to that firearm. You will hear testimony that access was not allowed in James Crumbley's mind. Ladies and gentlemen, you will not hear that James Crumbley knew what his son was going to do. You will not hear that James Crumbley even suspected that his son was a danger. That math homework that the prosecution is putting up on the screen, you're going to hear about that. You're going to hear about what other people thought about that. People at the school, including James Crumbley. There's going to be probably quite a bit of discussion about that piece of math homework, ladies and gentlemen, and you're going to hear all about it. Ladies and gentlemen, James Crumbley did not know what his son was going to do. He did not know that his son could potentially harm other people. He did not know what his son was planning. He did not purchase that gun with the knowledge that his son may use it against other people. You will not hear that he did that. The prosecution told you that. The prosecution just told you you're not going to hear that. You're not going to hear that James Crumbley purchased that gun with the knowledge that his son was going to go harm other people. But what the prosecution wants you to believe, the part that's not true, is that James Crumbley knew what his son was going to do and knew that he had a duty to protect other people from his son. Ladies and gentlemen, that's not true. He didn't know. You're going to hear about James Crumbley's relationship with his son. There may be other witnesses who testify about that, about how James interacted with his son, including on the day when that math homework was shown. You're going to hear from other people. They're going to tell you, in their own words, what they observed about James Crumbley and his son, about what they observed about his son, about any concerns they may have had. Other people, not just James Crumbley, but other people with additional education, additional training to evaluate situations like this and evaluate individuals. You're going to hear from those people probably. And they're going to tell you in their own words what they thought about the math homework, about Mr. Crumbley's son, about Mr. Crumbley's interactions with his son. Yes, James Crumbley was a DoorDash driver. We all know that. It's been said multiple times. Ladies and gentlemen, being a DoorDash driver doesn't mean that your job is any less important to you or other people than any other job. It doesn't mean that you don't feel that you have a duty to go to work. And ladies and gentlemen, when you're not aware of an immediate, imminent danger, why would you do anything different than what you normally do? You wouldn't, because you don't have any reason to think you need to. So ladies and gentlemen, you're going to hear the evidence. You've heard a lot of questions in the last couple of days from both the prosecution and myself. You probably have an idea where each side lands on these issues. But you're going to hear the evidence. You're going to hear from people other than us. And you're going to be able to hear in their words what they thought about those days from November 26th to November 30th of 2021. And their feelings, what they observed, any concerns that they may or may not have had. The prosecution has asked you repeatedly to follow the law. I'm going to ask you to do the same thing. Please do follow the law. And I'm confident, we are confident, that if you do that, if you follow the law, that you will find James Crumbley not guilty. Thank you.
Okay. Well, there you have it. I do feel like there were some differences, I guess, in the prosecution's opening, but I just don't see. I mean, the witnesses' testimonies are going to be the witnesses' testimonies. They're going to have to show this jury the same thing they showed the jury. So let's now move forward to the first witness, and we're going to fast forward to the defense questioning the first witness. Okay, first witness is the teacher that was shot but survived. She tells a harrowing story about what she went through that day. You might want to re-listen to it if you've forgotten her testimony. It's just trigger warning. It's sensitive. But when it was time for her to be done, defense did not cross-examine her. I don't think the other defense attorney cross-examined her either. They were just kind of like, yeah, you've been through enough. It was a good call. It was a good call on their part, right? All right, moving on to the next witness.
Good afternoon, Your Honor. David Williams.
Good afternoon. Will we call him? Is that?
Judge, I think it is. It's an oral motion.
Your Honor, before we get started, I'm just going to place my objection on the record that this is being handled.
That this is being handled?
Yes, especially in front of the media in the middle of a trial, when this is obviously very likely going to be put out in the public, Your Honor.
Well, I do have a concern about that.
Judge, I was not certainly asking for it to be in front of the media, but I don't know how to make a record without that.
Well, we've learned that. It's called 8.119, but...
May I, Judge?
Well, I guess I'm wondering, during the course of the trial, if there's any kind of a stipulation that could be agreed to.
Certainly, I'm happy to discuss what my request is, Judge.
Well, Ms. Lehman, would you be willing to have a discussion with the prosecutor's office? I can't, I have to hold the public courtroom.
Correct, Your Honor.
I do not want to impact your client or your case in any way by doing so, so I'm weighing the rights of the parties, so.
I would be more than happy to speak with the prosecutor's office about this.
Judge, I'm going to be very brief.
I think the situation could be temporarily taken care of with a stipulated order, but I don't know if that's satisfactory or not. I'm reluctant to impact the rights of the parties during the jury trial.
I mean, Judge, my request is pretty straightforward, and it's pretty time limited.
Well, I know what your request is, but I'm concerned about statements that might be placed on the record, right? Aren't I concerned about that?
I am, Your Honor.
I mean, Judge, I think it's appropriate for the record, and obviously the jury's not present, that's why they're not here. But I understand what the court's raising. I'm not.
All right. Well, I know you do. I know you do. I know you understand my concern as well.
I do. Hold on just 1 second, Judge.
I'm asking if there's another method during the duration of the trial, which is next week or so.
That's exactly it, Judge.
Okay, so I'm asking if you and defense counsel
I
could
provided
enter into
a draft order, Judge.
There was a draft order provided, Your Honor. It is not time specific. It appears to be kind of a blanket
So,
time period.
Judge,
I can set this for a motion, the second here is incorrect, right?
You
Judge,
could, Your Honor.
in fact, Judge, I think we'd be willing to have the order expire by its own terms upon a verdict. We're just talking about during the pendency of the trial.
Okay. If I'm shaking his head, I would like to. In theory, I can ask the prosecutor to file a written motion, but that doesn't help you either.
And Judge, I'm happy to do that.
Okay, Your Honor, my client is not willing to agree to the order.
Okay, so you...
It's basically restricting his ability to speak to people, Judge. I mean, it's
Well,
a complete revocation, except for counsel.
I'm most concerned about him being able to talk to you.
Right, and absolutely that's not part of what we're asking. I mean, Judge, if the order gets entered, we're asking that the communications be limited to only counsel in legitimate clergy during the rest of the trial. That's my request. We're talking 7 or 8 days. You can talk to his attorney, you can talk to legitimate clergy.
Okay, so if he doesn't agree to it, then the prosecutor is going to make the motion. Right?
And I have advised Mr. Crumbley of that, Your Honor. I would propose that there could be a different order with a restriction and not a complete revocation. Obviously, the prosecutor's office is reviewing communications. They would know whether or not the order was violated, and at that point, if the court needed to take action, then the court could take action.
Judge, it's not just about violations going forward, it's about the conduct that's already happened.
Well, I understand that. I understand that. It's so hard to understand because there's a big old sign right there, right?
It's on every pendency of the trial.
Okay. If I'm shaking his head, I would like to... In theory, I can ask the prosecutor to file a written motion, but that doesn't help you either.
And Judge, I'm happy to do that.
Okay, Your Honor, my client is not willing to agree to the order.
Okay, so you...
It's basically restricting his ability to speak to people, Judge. I mean, it's a complete revocation, except for counsel.
I'm most concerned about him being able to talk to you.
Right, and absolutely that's not part of what we're asking. I mean, Judge, if the order gets entered, we're asking that the communications be limited to only counsel in legitimate clergy during the rest of the trial. That's my request. We're talking 7 or 8 days. You can talk to his attorney, you can talk to legitimate clergy.
Okay, so if he doesn't agree to it, then the prosecutor is going to make the motion. Right?
And I have advised Mr. Crumbley of that, Your Honor. I would propose that there could be a different order with a restriction and not a complete revocation. Obviously, the prosecutor's office is reviewing communications. They would know whether or not the order was violated, and at that point, if the court needed to take action, then the court could take action.
Judge, it's not just about violations going forward, it's about the conduct that's already happened.
Well, I understand that. I understand that. It's so hard to understand because there's a big old sign right there, right?
It's on every call. Every single call.
Yeah,
Judge, if there's not an agreement, I'd like to just make my motion. It's fairly brief, Judge.
So Ms. Langer, what's his position?
Your Honor, he is
Okay,
not agreeing to the order.
Okay, well, does he know that in 10 minutes, there's going to be an article about it? Does he know that in 10, maybe 8? I can't, I'm not permitted to have a closed courtroom unless we're proceeding with a closed hearing under 8.119, and as I sit here right now, I don't know if this qualifies, so.
I just remembered this guy specialized in one of the arguments they had earlier, and I can't remember what it was. Was it about Ethan's portion? So when I go to edit
May I
this,
speak?
I'm going to turn it up and see if we can't tell what he was saying. But he is pissed. They're trying to say he can't talk to anybody other than his attorney and clergy until the end of the trial, which is only a few days. But I don't understand. I don't understand why they would say that, unless there's been some phone calls that they've been listening to, which is that's got to be what's going on. Oh, okay, I see what it is. I'm gonna tell y'all. Hang on. This is why they're gagging it. So let me read you guys what happened. Following the first day of James' trial, his phone and electronic messaging access is now restricted due to threatening statements he made while in jail. No details were provided on who James was threatening. You know what I'm thinking? I'm thinking he was either threatening a juror, probably just shooting off at the mouth is what I'm thinking. You know what I mean? But remember, all these calls are recorded, and that's what they're doing at the DA's office is they're listening in. So he probably ranting about a juror, the way they looked, or possibly a victim's parent that's in the courtroom that's maybe making him feel uncomfortable, something like that. That's what I'm thinking,
Judge, I think we read
but I could be wrong.
That's good.
I'll research. If I find out differently, I'll let you know
Judge,
before
I
the
think
end of
I
this
can just briefly
video.
make a record. This is obviously, the order is going to become public. The agreement is going to be that Mr. Crumbley's communications will be revoked, but not his ability to do research or otherwise participate in his own defense. So not just communicating with counsel, but his ability to read or get other information.
Okay.
Simply communications.
And
So-
that's going to be a stipulated order between you and Ms. Langer.
Correct.
All right, and did you say that order would expire upon a verdict?
Yes, Judge.
Okay.
And
And
perhaps
what-
it should
what
go
if there
without
isn't
saying.
one? What if there isn't one?
Well, I think,
Would you
I
like?
mean, we can address it at the time.
Okay.
I think the issue is, once there's a verdict, a lot of the issues just fall away.
Okay.
And Judge, it should go without saying, but I hope the court will encourage Mr. Crumbley that the conduct that got us here
I think I already did through his attorney.
Okay,
on several
thank you.
occasions, both in private meetings that we conducted. When I say private, I mean with both the prosecution and the defense.
And for the record, I've also addressed you here.
I know you have. So I gave out free legal advice, Mr. Lynn. So someone can take it or not take it, right? So I'll sign the stipulated order.
Yeah, okay.
Good? I didn't sign it.
May I approach the clerk, Your Honor?
Sure. All right, my staff is going to e-file the order, all right?
Thank you, Your Honor.
Thank you, Your Honor.
Isn't your email? All right, so we'll start right at 9 o'clock tomorrow with your cross.
So let's move on to day 2. And I have a feeling it's going to be this same guy. I don't think they finished his testimony. Yeah, I don't know how they've gotten to mess with their audio, but it's like this happened with Jennifer's trial. You could hear what her and her attorney were talking about, and that should not be happening. I mean, that right there opens up the door to major appeal, in my opinion, down the road. They should have their privacy. I mean, it's obviously I'm all for the media being involved, or else I wouldn't be here watching this with you guys. But I mean, come on. This is a little bit more important. Their privacy is. Not to say that they're, not guilty. I didn't say they weren't guilty. I'm just saying give them the rights that they are due. I thought he was kind of a wuss from looking at previous videos and stuff of him because I'd never heard him talk. But after seeing him here, I kind of thought maybe he's not a wuss. Maybe he's not as much of a wuss as I thought he was. He didn't do a lot of talking, before his trial started. You never heard anything from him. Well, you never heard anything from Jennifer either, but I was surprised Jennifer had such a deep voice. I wonder if he's seen her since she gained all that weight. I'm sure he saw like her part of her trial. I wonder if he got to see her trial at all. They would have let him watch, right? Well, if he had access to internet in the jail. Either way, I'm sure his attorney has kept him up to date on what's going on. I don't see why there would be any kind of reason why she wouldn't be able to tell him what was going on in his wife's trial. She's the one with all the strategy in this game anyway. If she knows, that's the most important thing. So if anyone here watched this trial all the way through and you're catching something or picking up on something that I'm missing, will you please let me know in the comments so that we can talk about it when we go back to revisit the verdict? Because I probably will do that one other video. Who knows? If the verdict comes in tomorrow, I don't think it'll come in tomorrow. Jennifer's was out, 2 days or a day and a half? I don't even remember. And it wasn't even that long ago. Also, while you're here, drop it in the chat. Were you surprised when Jennifer's verdict came in? I was. I didn't think they'd find her guilty. I just didn't. Wouldn't that be crazy if his jury found him not guilty and then she's got to go to jail?
I want you to know that none of us slept in and we weren't sitting around drinking coffee. Here.
I might need it on your honor, yes.
Oh, see, I just got a really continuing flashing of this one, so I think I'll send it to
I didn't train.
Okay, so we're going to start off with this digital forensic agent who is now a secret service agent. Kudos to him. And we're just doing the defense cross-examination.
Edward Wogrowski,
So let's go from here.
EBWARD, last name WAG, ROWSKI.
Thank you, Your Honor. Good morning, how are you?
Good, how you doing, ma'am?
I'm well, thank you. I may or may not use the screen, so I might bring up a paper exhibit to you if I need to.
Yeah, this one doesn't appear
Yeah,
to
let
be,
me
it's
stop you a
something's
second.
going on there.
The issue I mentioned to you a minute ago, this screen is flashing.
You know what, Your Honor, why don't you turn it off? I have the exhibits
Yes.
printed out, so if I need
Okay.
Mr. Wegorowski to look at it, I can walk up to
All
him.
right, we can let RIT know. Okay.
Thank you, Your Honor. Mr. Wegorowski, in November of 2021, you were employed by the Oakland County Sheriff's Office,
Yes, that's correct.
and you were employed in their computer crimes division.
Correct.
You testified yesterday that the main objective of your position was to obtain evidence for criminal prosecutions.
I'm sorry, main objective
Of your position was to obtain evidence against someone accused of a crime.
on that day of November 30th,
No, as your role with the computer crimes division.
we were looking for evidence if a crime was committed, yes,
And you reviewed electronics,
correct,
social media accounts,
that's correct,
other similar sources of electronic data,
correct.
and the goal was to obtain evidence against a person accused of a crime. Is that fair?
Attempting to see if a crime was committed, correct.
Your goal was not to obtain any exculpatory information that would clear someone from a crime. You were looking to see if somebody committed a crime. Is that correct?
That's not true. No, if we find evidence like that, obviously it would be relevant to look further into that, yes.
And you did the same thing in this case. You reviewed the electronics, the social media accounts, and other sources of electronic data.
Correct,
You reviewed cell phones that belonged to James Crumbley.
that's correct,
You identified that there were 3 cell phones, if I recall correctly, from the prosecution's PowerPoint.
correct.
2 of them had the same phone number.
That is correct,
So there were 2 Android phones that had the same
She
phone
talks
number.
fast.
correct,
And then there was a 3rd phone, which you called a burner phone. Or I'm sorry, excuse me. The prosecution called it a burner phone and you agreed.
correct,
That's a phone that you buy at, I think you said Walmart or Meijer or a store like that, a track phone, something along those lines.
correct, yes, something that's, yeah, you can just buy and activate yourself.
And if you know, James Crumbley and his wife were told to get a second phone because they gave their phones to the police that day.
I was not told that, no.
You're not aware if that happened?
I'm not aware of that happening, no.
While you were in the process of obtaining surveillance footage, you were not aware of the identity of the shooter at Oxford High School.
Not immediately,
And at that point, you don't recall anyone at that point, meaning while you were reviewing the footage at the school, you don't recall anyone saying, oh, it's so-and-so, until at some point later.
later within, it was probably, I'd say 25, maybe 30 minutes. We were looking at the video and then someone said his name.
Okay. So, and I'm not going to ask you to say his name. The judge has made orders regarding that. But it wasn't initially anyone at the school was like, we know who it was this person. Is that accurate?
I believe the person was identified by the deputies that took him into custody, but that wasn't related to us. We were I was in the security room at whatever time it was, and we were just looking for the person that came out with the black zipped up hoodie on.
Okay. For Exhibit 61, and if you need me to pull the exhibit for you, I will.
Yes.
I'll tell you what it is. Exhibit 61 is a Facebook conversation between James Crumbley and his wife. Did you want to look at it?
Yes, please.
Okay, may I approach, Your Honor?
Sure.
Do you recall reviewing that yesterday?
Yes, I do.
Okay. And that exchange is about James Crumbley's son.
Correct.
You don't know the context of the messages, is that fair?
The context of what was being said, the words speak for, I don't understand.
Right, the words speak for themselves, right? You know what's on the page.
Correct.
You don't know anything beyond what's on that page.
That's correct.
You talked about texts. May I approach again, Your Honor, to get the exhibit?
Sure.
Thank you. Thank you. Mr. Wegorowski. You talked yesterday about text messages between Mr. Crumbley's son and his friend.
Correct.
You talked about the amount of text messages that there were.
That's correct.
20,000 texts in 11 months, I believe is what you said.
Yes.
Now, are you familiar with how often teenagers text each other?
I have 2 of my own, so yes.
You know that teenagers text a lot?
Yes, they do.
Young people text a lot?
I'm sorry, what?
Young people text a
people?
lot?
Yes.
You don't know whether or not 20,000 texts is an abnormal text between 2 teenage friends, or if it's an abnormal amount. Is that fair?
No, I've done teenage cell phones before, and that 20,000 is a lot for that time span.
In April 4th of 2021, you identified a text message between Mr. Crumbley's son and his friend, claiming that his dad told him, his dad being James Crumbley, told him to suck it up and gave him pills. Do you recall reviewing that text yesterday?
Yes.
Now, in that text, you don't know what Mr. Crumbley's son was talking about, that his dad told him to suck up. Is that fair?
Because I believe he told that he was not feeling well, or if you have the exhibit, I can look at it. I thought there was more context to it prior to suck it up, but then Phil just handed him some pills.
Right. You don't know what the pills were?
I don't know.
Could have been Tylenol.
They talked about Xanax before James and his wife did.
Not in that communication, correct?
No.
The one on April 4th of 2021.
Correct.
There was also a talk about melatonin.
Yes, there was.
So it's fair to say that you don't know what necessarily was being discussed between Mr. Crumbley's son and his friend on April 4th of 2021.
Again, I thought there was more context before the suck it up, but I don't know exactly what they were.
Let me see if I can pull that. I'll pull the exhibit and we'll come back to it.
Okay.
And the same thing on April 5th of 2021 with the friends. You don't know what the context of the conversation was. You just know what you're reading on a page. Is that fair?
What were they talking about on April 5th?
We'll pull that exhibit and I'll come back to
Okay.
it. I was going to do it on the screen, but it's not working
You can do
today.
it on the screen if you want. This one was flashing, but we can try it now.
It's okay, Judge. We'll move on.
I think you can probably see it from either one of these angles anyway.
You talked about in Exhibit 70 and 71, and I will pull those for you right now. Well, one is it's a placeholder because it was a video, if you recall. Coach, Your Honor.
Thank you.
You're welcome. Exhibit 70 and 71 were a video sent from Mr. Crumbley's son to his friend, correct?
Correct.
And that was a video at 9:31 p.m.
That's correct.
on August 19th of 2021.
Correct.
We saw the video yesterday. It was of Mr. Crumbley's son handling a firearm.
Correct.
You hear the clicking. You hear it clicking in the video, if you recall.
After you loaded the magazine into it, yes.
You don't hear any voices.
No.
No other sounds.
No.
In Exhibit 74, you identified that was a GPS location showing that James Crumbley was at the home
Correct.
at the time that around the time that this video was taken.
That's correct.
Now, from the video that we saw, you don't know if James Crumbley is standing next to his son, correct?
No, I do not.
You don't know if he was standing across from his son, correct?
I do not.
You don't know if he was in a different room and had no idea that his son was handling the firearm. Is that correct?
I can't say that because when you rack around into a gun, that slide going forward makes a loud noise. And in a small house, you probably hear it.
Probably, but you don't know.
For sure, with him, no, I don't. But it's
And you don't know just by looking at that exhibit what the surrounding circumstances are of that video. Is that fair?
What was going on around it outside the video? No, I do not.
You know what that video shows.
Correct.
And that video shows Mr. Crumbley's son handling a firearm and loading a magazine into it. Is that correct?
Correct.
Exhibit 72 and 73 are also, if you'd like to look at them, there was also a text message between Mr. Crumbley's son and his friend. Again, it's another placeholder because it was a video. May I approach, Your Honor? Sure. Thank you. And that was a video sent to Mr. Crumbley's son's friend at 8/20/21
Correct.
at approximately 12:30 a.m.
That's correct.
In the text, after the video was being sent, Mr. Crumbley's son said to his friend that his dad left a gun out.
Correct.
You don't know if that's true. Is that fair?
I mean, I don't know why he would lie to his friend that he talks to all the time.
You don't know if it's true, correct?
From this, it doesn't say that it's true or not, but I don't know why he would lie.
The words on the page are the words on the page. Is that
That's
accurate?
correct.
You can't go back in time and get the answer, correct? You can't go back to August 20th of 2021 and figure out were you telling the truth that day?
Go back to that day? No, I mean,
Correct.
you could ask the person that sent the text.
Right. Exhibit 76 shows that James Crumbley was at the home at that date and time. May I approach again, Henry? Sure. Thank you. Exhibit 76 is, again, another GPS location showing that James Crumbley was at the home on August 20th of 2021 at 12:30 a.m.
Correct.
And again, in the video that was shown, You can hear the clicking sound. I'm sorry, this was the loading of the magazine.
That's correct,
The other
yes.
one was something else.
And just, yes, recorded it.
Exhibits 72 and 73 is Mr. Crumbley's son loading the magazine into the firearm,
Correct,
and you hear that,
yes,
and you see it on the video.
correct.
You can hear kind of like a whirring, maybe like a fan or something in the background, if you recall.
I don't recall that, but, okay.
You don't recall hearing voices?
Anybody talking at the time?
Correct.
No.
No other sounds other than the loading of the magazine.
And the slide going forward.
And again, you don't know whether James Crumbley was standing there or not.
Correct, I did not.
You don't know if James Crumbley was in another room.
The GPS says he was in the vicinity
And
of
the
the house.
residence, correct?
Yes.
You don't know if he was maybe standing outside. You don't know, is my point.
I don't, the video is just limits to the gun, correct, but the GPS puts him at the house at 12:30 at night.
If you were to say, well, this is what I think, and you said that similar to some questions a little bit earlier, well, the sound of the slide moving forward is loud and you would hear it in a house that size, that's an assumption that you're making, correct?
I've loaded a gun several times and it does make a loud noise. Like,
You don't know
You
whether
would
or
know
not
what's
anyone
happening.
is, I'm sorry, I interrupted
no,
you.
it's okay. You would know what's happening. And I mean, if you have a house that's large on the second floor, then you probably wouldn't. But in a smaller house, it does, you get metal banging together. It makes a loud sound.
You don't know, based on those exhibits that have been admitted, whether or not James Crumbley heard that sound.
Whether he heard it, no.
You don't know whether or not he was aware of it.
No.
You don't know if he was aware of it and standing right there.
Correct.
You don't know.
I know the GPS puts him at the house.
Exhibit 79 was a chain of text messages. May I approach, Your Honor?
Sure.
Thank you.
Thank you.
You're welcome. Is a chain of text messages between James Crumbley and his son's friend's father. Do you recall reviewing that yesterday?
Correct, yes.
James Crumbley's son's friend's father.
Yes, I want to get, yes.
You reviewed the text during your investigation in this case.
Correct.
You looked at them yesterday.
That's correct.
This is the friend that Mr. Crumbley's son texted with so much, the 20,000 texts.
That is correct.
Mr. Crumbley was checking in on his son's friend. If you, and
Yes,
you can
correct,
look.
yep.
Okay.
That's correct.
He was concerned because it had been brought to his attention by his son that he hadn't heard from his friend, if you recall.
Yes, correct.
If you recall from the text messages, the son's friend's father asked Mr. Crumbley not to say anything about the whereabouts of his son.
Until he went to the hospital?
Correct.
Correct, yes.
And he said, wait and let's see how my son wants to handle it.
Correct.
In the conversation at that point between Mr. Crumbley and his son's friend's father, there was no expression, if you recall from reviewing the exhibit, there was no expression of mutual concern about Mr. Crumbley's son or sharing any information like, yeah, my son's been having a hard time. Or, there was nothing like that in that exhibit. And you can look through the pages that you have.
No, there was not.
Okay. On November 30th of 2021, in that same text thread, the friend's father texted Mr. Crumbley and said that he was praying that his son made it home okay.
What, in here?
Yes, November 30th of 2021.
Correct, yes.
And that was after the shooting at the high school.
That's correct.
So this friend, the father of this friend that Mr. Crumbley's son had texted with so much, 20,000 texts that they had talked about, his own son had mental health issues, we see from the text. Even he did not suspect that Mr. Crumbley's son could have been the person responsible.
So this speculation, as counsel pointed out, this witness can testify. Thank you, sir.
May I approach?
Yes.
Thank you. You talked a little bit yesterday about cache data. You said that cache data is saved after a person views something on their device.
Correct.
You went through exhibits 82 through 86, which I can pull if you'd like, but I'll just remind you, they were photos of a screenshot that Mr. Crumbley's son had taken of a screenshot of a handgun that was for sale,
Correct.
a 9mm handgun. And then the exhibits were also the data behind that, showing that the images were stored in both Mr. Crumbley's son's cache data and Mr. Crumbley's cache data.
That's correct.
Did you want to review them again?
I would please.
May I approach, Your Honor?
Sure.
This is 82 through 86.
I like that she moves fast. She keeps things going. Totally different attorney. Go ahead, Jennifer.
Okay.
Not that the other girl wasn't okay. She's all right.
Do you want to look at them? Just in case you need them?
Yes,
Sure.
yes, thank you.
So the screenshot was sent by Mr. Crumbley's son to Mr. Crumbley.
Sent to by,
Mr. Crumbley's son to Mr.
correct,
Crumbley.
yes,
The screenshot itself was taken by Mr. Crumbley's son.
correct.
Both of them, it appears from these exhibits, deleted the screenshot from their messages.
Correct.
People delete messages, right?
Yes, I do, yes.
You do?
Sure,
For any number of reasons.
correct,
Not necessarily because you're trying to hide anything.
correct.
In fact, there's also a way that you can delete the message and then also clear that cache so that whatever you're deleting is permanently erased from your phone, right?
It's possible, yes.
And if that happens, then you wouldn't have found anything in the cache data, correct?
Probably not, correct.
So it's fair to say that deleting a screenshot or a message is not necessarily, there's nothing wrong with it, right?
There's, again, speculation, bless you, speculations, that kind of questions for the jury to answer.
Well, Your Honor, what I'm asking is if just deleting a message is wrong.
Well, do you mean morally, legally, professionally, politically?
All of them?
He's here to testify as to what he was able to extract from devices.
You should be asking his opinion. So wouldn't you be asking his opinion?
I mean, he said he himself deletes things and he doesn't do it because he's doing anything wrong, trying to hide anything.
Right. I mean, the witness was responding to counsel's question in a conversational tone. He can't provide opinions on why somebody might delete things or why not. He can testify it was deleted. Thank you, Judge.
In this instance, you did not see that anyone attempted to clear the cache data or anything like that from what you have in front of you.
The fact that it's there tells me that it didn't happen.
Okay, thank you. Mayor Kuchar?
Sure.
Thank you. We know that on June 26th of 2021, James Crumbley went to a firearms store where he bought a 6-hour 9mm handgun. And you talked a little bit about that yesterday, correct?
Correct.
What did I say? June. I'm sorry,
Yeah.
November 26th
Yeah,
of
I knew what you meant.
2021.
Yeah,
There's been no dispute that James Crumbley bought a handgun on November 26th of 2021, to your knowledge.
correct.
Exhibit 95 is an Instagram post made by Mr. Crumbley's son about the 6-hour handgun that was purchased by Mr. Crumbley earlier that day.
Correct.
Would you like to review Exhibit 95 again?
Please.
Mayor Pro Turner?
Sure.
Thank you.
Thank you.
In that post, Mr. Crumbley's son claims that the 6-hour is his handgun. In the post made by Mr. Crumbley's son in Exhibit
Correct,
95.
yes. I didn't hear something, sorry.
That's okay. He posted photos.
Correct.
And again, from what you have in that exhibit, you don't know anything about what's going on outside of the frame of that photo other than what's in that photo. Is that correct?
That's correct.
And you know that based on Exhibit 88, which is a GPS location, that Mr. Crumbley was at or near his house around the time that his son took and posted those photos. And if you'd like to see Exhibit 88, I can give it to you.
Please, I always, yes, thank you very
May I
much.
approach, Your Honor?
Sure.
Thank you.
So reviewing Exhibit 88, you would agree that that exhibit shows that Mr. Crumbley was at or near his home at the time that, and if you need 95 back, I can give it to you, at the time that the post was made.
That's correct.
May I approach?
Sure.
Exhibit 92 is Cellbrite data showing that Mr. Crumbley follows, Mr. Crumbley's social media account follows his son's social media account. Would you like to review that?
I'm good with that.
You're good with this?
Yes.
Okay. So you agree that that's what that shows?
Correct.
It doesn't show whether or not they interact. Exhibit 92 doesn't show whether or not they interact on social media. Is that accurate?
That particular, no, it does not.
Correct. Exhibit 92 doesn't show whether or not Mr. Crumbley saw any of his son's social media posts. Is that correct?
It would not indicate that, no.
Exhibit 96 is a video that was found on Mr. Crumbley's son's phone at on November 26, 2021 at 6:39 p.m. And again, it's a placeholder, but if you recall, it's a video of the phone camera looking down the barrel of a firearm.
Yes,
You do not see in that video, if you recall, you don't recall seeing a round in the chamber, correct? You didn't
No,
see
you
a
saw-
brass,
you saw the firing pin
the firing pin, which means
down the
that
barrel,
there's nothing there.
correct.
You do not know from that video if Mr. Crumbley's son is holding the firearm in front of him with his camera, or if it's like this, or you don't know what's going on. You just know what that video shows, and it's the barrel of the firearm.
Correct.
Exhibit 98 is a GPS location showing that Mr. Crumbley was at the home at the time that this video was taken. Did you want to look at Exhibit 98?
No, I'm good. I remember that one.
And you would agree that Exhibit 98 shows that Mr. Crumbley was at the home.
Correct.
And again, you don't know whether Mr. Crumbley was aware that his son was handling the firearm in this way, correct?
That's correct.
I will say her paperwork seems to be a little bit more organized.
Exhibits 100 and 101 are similar photos. If you recall, they are social media posts by both Mr. Crumbley's son and Mr. Crumbley's wife. If you would like to review them.
Please.
May I approach, Your Honor?
Sure.
Both 100 and 101.
We can continue to approach that.
Thank you, Your Honor.
It is open to anybody.
Thank you, Your Honor. Okay. So those are posts by Mr. Crumbley's wife and his son, and they're shooting range targets.
Correct.
And it looks like they were shooting range targets that they used based on the posts.
Based on, yes,
There's nothing illegal or improper to your knowledge about taking your child to a shooting range, correct?
that's correct.
And letting them shoot at a target.
Correct.
There's nothing illegal and improper to your knowledge about posting photos of the target that you used.
Correct.
Exhibits 104 through 107 are from November 27th of 2021, showing that James Crumbley was doing DoorDash deliveries. Do you recall reviewing those?
Yes, I do.
Do you need to see them?
Just in case, yes, please.
Okay. (104) through 107.
Okay.
Now those deliveries are over a period of time.
Correct.
And we know that James Crumbley worked for DoorDash. We talked about that yesterday.
Correct.
It hasn't been disputed to your knowledge.
No,
DoorDash was his job at the time.
that's correct.
There's nothing wrong with working at DoorDash, correct?
No.
There's nothing wrong with leaving your 15-year-old son at home while you're working for DoorDash.
Correct.
In and of itself, there's nothing wrong with that.
Correct.
And
I just want to say something. I love my DoorDash driver. I don't know why they make such a big deal out of driving for DoorDash, like it's some kind of horrible thing. If you're running your own schedule, you're making money doing it. What's so bad about being a DoorDash driver?
when you were looking at exhibits
I didn't
yesterday, and just if you recall, you don't recall there being any posts about or exhibits about concerning behavior or concerning text messages or videos or anything like that during the hours from exhibits 104 to 107.
During this time, no.
Can I tell y'all a story real quick? I'm sorry. I feel the need to share. So where I live, we're like way out in the country, and I do not get DoorDash or any Uber or Eats or we don't get it. I don't even think we have Uber out here. Seriously, we were out in the country. And where I lived before I moved here, I was spoiled rotten because I did a lot of DoorDashing. And so what I do now is my sister works in town. So what I do is when I want something from DoorDash or something like that, I have it sent to her work. Like right before she gets off. And then she has to bring it home to me because we live like right next door to each other. Well, actually, I live in her backyard, but you know what I mean? So anyway, I thought that was funny. Yeah, thanks for listening.
We talked about the horse barn yesterday, if you recall.
Yes,
You talked about the messages between James Crumbley and his wife about the horse barn.
correct.
In fact, you recalled that James Crumbley and his wife mentioned or talked about the horse barn 86 times in their messages that you reviewed.
Going to a yes, correct.
And you said specifically from January of 2021 through November of 2021, they had talked about going to the horse barn 86 times.
That's correct.
Now, if we do the math quickly, there's 333 days between January 1st of 2021 to November 30th of 2021, if you know. I don't know if you're, I'm not great at math,
I
but
don't know that.
okay. So let's just assume that's the number we come up with. 86 out of 333 is 25.8%. Again, I'm not going to ask you to, I'm not going to hold you to the number.
Okay,
But assuming 86 is correct, assuming 333 is correct, that means that a quarter of the time they're discussing the horse barn.
and really didn't discuss much more than going to work and stuff like that.
On November 28th of 2021, yesterday, you testified that Mr. Crumbley was away from the house approximately 5 hours. There were screenshots or GPS locations. You remember talking about that yesterday?
What day was this?
November 28th of 2021.
Okay, yes,
There's nothing wrong with being away from home for 5 hours, correct?
correct,
In and of itself, there's nothing wrong with that.
correct.
Exhibit 115, and I am going to bring this up to you, is a Facebook thread between James Crumbley and his wife on November 29th of 2021 from 8:23 a.m. to 1 o'clock p.m.
Okay,
They are discussing issues with their horse. We
correct,
talked about it yesterday. We also learned in that time between 8:23 a.m. and 1 o'clock p.m. that Pamela Fine from Oxford High School called Jennifer Crumbley.
correct.
She left her a voicemail. Pamela Fine left Jennifer Crumbley a voicemail.
That's correct.
There was another exhibit showing that Jennifer Crumbley accessed that voicemail at approximately 11:49 a.m.
Correct.
In Exhibit 115, there's no discussion between James Crumbley and Jennifer Crumbley about that voicemail.
There was not in this right here, no, but there was a conversation where Jennifer asked James, did he tell you what happened at school today?
And I'm going to get to that in just a second.
Okay.
But in that thread, there isn't anything, especially around 11:49 or even before 1 o'clock p.m., where it's mentioned, I got a voicemail from the school, this is what it was about. Is that fair?
That's fair.
In fact, it wasn't until Exhibit 119 at approximately 3:19 p.m. that Jennifer Crumbley mentioned anything to James Crumbley about something going on with Ethan at school.
Correct.
And
Can I ask you a question?
yes, Your Honor.
Can you turn up the microphone?
I am really liking how fast she moves. I mean, she's got, I have to say, she's really doing a better job than Jennifer's did. Her point that she's making is, scratch that.
Their son talked about what happened at school.
Correct.
Now, there's an assumption that Mrs. Crumbley is asking Mr. Crumbley about the incident that led to the voicemail. Is that fair? There's an assumption.
Nothing else to base that on happened that was the school called them about.
And that's my point, right?
Correct.
And there was no conversation between James Crumbley and Jennifer Crumbley about that voicemail beyond what we see in that message, in the messages in 119, correct?
Correct.
Exhibit 131, another Facebook thread between James and Jennifer Crumbley. From November 30th of 2021. Oh, you know what? I'm sorry. I'm going to go back to 122. You can keep 131 with you.
Okay.
Exhibit 122 is surveillance video of Mr. Crumbley dropping his son off at school.
Correct.
And then I believe you also testified that there was additional exhibit showing that Mr. Crumbley went to the horse barn that day.
Correct.
That would be November 30th of 2021.
That's correct.
He was waiting for a vet.
Correct.
And that was consistent with the conversation from the day before about one of the horses having some medical issues.
Correct.
So exhibit 131, you see that Jennifer Crumbley sent James Crumbley a picture of the math assignment that was sent to her by the school.
Correct.
And we've talked about this math assignment, and I'm sure that we'll talk about it more, but there were two versions that were sent, correct?
Correct.
And in that thread, there were two versions that were sent, from what you can see.
Correct.
James obviously expressed some concern.
In one text, yes.
In fact, he said, "My God, WTF."
Correct.
And we don't have to say what that means, but WTF. Jennifer says that their son was upset, and she used the word, quote unquote, distraught about the night before.
Correct.
James says in response that he talked about it, assuming he means the night before, with their son. Correct?
We talked about it. I'm sorry. What?
In referring to it, we can presume that they're talking about the night before based on the response to Mrs. Crumbley's text. And if you don't want to presume that, you don't have to.
Yeah, I don't.
Okay.
I can't, yeah.
So James Crumbley says, we talked about it this morning.
That's what he said, yes.
Yes. There's no conversation after that about Mr. Crumbley saying, based on that conversation with his son, that he has concerns.
Correct.
In fact, I believe the next message is, did you talk to him?
That's correct.
We know that on November 30th of 2021, James and Jennifer Crumbley went to Oxford High School.
That's correct.
They met at the school around 10:30 a.m.
A little after that, but yes.
The prosecutor asked you if Mr. Crumbley went to the house before going to the school, and you said no.
Correct.
We know that Mr. Crumbley was at the horse barn. He left there and went directly to the school.
Correct.
And that was based on the exhibit that you looked at yesterday.
That's correct.
On his way there, he spoke to his wife.
Correct.
Mr. Crumbley and his wife met with Sean Hopkins at Oxford High School for approximately 13 minutes.
I think it was a little less than that, but yes.
Their son was in the meeting for about 12 of the 13 minutes.
Yeah, almost 12.
James left the school parking lot at 10:57 a.m.,
Okay.
if you recall.
I don't recall the exact time he left, but it sounds about right because they left the counselor's office before that.
You testified that at 11 a.m., Mr. Crumbley logged into his DoorDash app
That's correct.
from the Meyer parking lot on Gray Road.
Yes.
That his first pickup and delivery was from 11 a.m. to 11:19 a.m., if you recall.
Sounds about right. Yes, correct.
So he left the school and started working right away,
Correct.
within 3 minutes. Is that fair?
Yes, correct.
The prosecutor asked you if he stopped by his house during that first DoorDash, and you said no.
That's correct.
To your knowledge, on November 30th of 2021, from 11 a.m. to 11:19 a.m., Mr. Crumbley didn't have any reason to stop by his house. That you know of. That you know of.
If you know, do you know what I?
Was he told? I don't understand the question. I apologize.
No. Are you aware of any reason that Mr. Crumbley may have known that he needed to go to his house from between 11 to 11:19 on November 30th of 21?
Just, I think perhaps their objection would be called for a legal conclusion, because that's central to the theme of the prosecution, that he did have reason to stop. That's what the jury's being asked of.
I guess I don't know how he would know that.
It's based upon his level of knowledge from the last months of the life, Judge. That's what the evidence is showing.
I can move on, Judge.
Thank you,
I
Judge.
just don't know how he would know that.
You identified Exhibit 147 as an email that was sent. Would you like to review it?
I believe that's fine. Thank you.
As an email that was sent from Oxford High School to James Crumbley.
Correct.
That was sent at sometime around 1 p.m.
1:09 p.m., but yes,
That was after, actually, the shooting had ended.
correct.
In fact, you testified yesterday that the shooting was from 12:51 p.m. to 1300,
Yes, correct,
to 1 o'clock.
correct, yes.
That email doesn't show whether or not Mr. Crumbley received it. Is that fair?
That right there doesn't tell me anything, other than it was sent to him.
All that tells you is that there was an email sent from the high school to Mr. Crumbley
Correct,
at that email address
correct,
and at that time.
correct.
You know that from 12:33 p.m. to 1:01 p.m., Mr. Crumbley was on a different DoorDash delivery.
Correct,
You know that Exhibit 148 shows that Mr. Crumbley went to the Meyer on Ray Road.
at what time?
Sorry, I was muted. Do you guys see where she's going with this? I'm starting to pick up what she's laying down. If he wasn't worried, why would he stop? If he wasn't worried, he's not liable or whatever. That's what I'm thinking. I don't know what just happened. Hang on. I'm going to go back just a little bit.
To the Meyer on Ray Road,
At what time?
1:11 p.m.
Correct.
Did you want to look at the exhibit?
Nope,
Okay. So at 1:11 p.m., Mr. Crumbley was at the Meyer on Ray Road. You don't recall any exhibits yesterday showing that Mr. Crumbley was picking up a DoorDash order around 1:11 p.m., correct?
correct,
You know that Mr. Crumbley called his son based on Exhibit 136, which is his phone log. Mr. Crumbley called his son at 1:13 p.m.
correct.
Would you like to look at the phone log to get the time?
That's about the right time.
Okay.
Correct, yes,
And you know that Mr. Crumbley remained at the Meyer, which was the reunification point after the Oxford High School shooting. Mr. Crumbley remained there from 1:11 p.m. to 1:17 p.m.
correct,
So Mr. Crumbley called his son from the parking lot of the Meyer, which was the reunification point, at 1:13 p.m.
correct,
He also called his son at 1:17 p.m.,
correct,
which is right around the same time that he left the Meyer parking lot.
that's correct.
You know that there was a phone call, which was approximately less than 1 minute. And again, if you want to look at it, I can bring it.
Just to make sure, yes, please, thank you.
There was a phone call at approximately 1:17 p.m. 1:16 p.m. between Mr. Crumbley and his wife, which lasted less than 1 minute.
Correct,
Mr. Crumbley called his son at 1:17 p.m.
that's correct,
He left the Meyer at approximately 1:17 p.m.
that's correct,
Called his son again at 1:18 p.m.
that's correct,
and again at 1:18 p.m. There were two phone calls at 1:18 p.m. seconds apart.
correct,
Neither of them were answered.
correct,
You also know, based on your involvement in this case, that his son was already in custody at that point.
that's correct,
He'd been taken into custody at 1 o'clock.
correct,
You know that, again, based on 136, Mr. Crumbley's wife called him after he'd left the Meyer parking lot.
at 1:19 p.m., is that what you're referring to?
Yes.
Yes,
Mr. Crumbley was home at approximately 1:20 p.m. based on the exhibits, if you recall.
correct,
He was home while he was on the phone with his wife.
that's correct,
You know that during the time that he was at home, he called 911.
correct,
He called 911 because he discovered that the Sig Sauer and the ammunition for the Sig Sauer were both missing.
Speculation as to why he called 911, Judge.
He said in the phone call why he called 911.
Well, I guess that's a different question. You don't know why he called 911, but you did hear him. And you did hear the 911 call that.
correct, yes,
In that 911 call, Mr. Crumbley told the dispatcher that he saw and heard the sirens, if you remember the call.
correct,
He said that he went to the Meyer after hearing and seeing the sirens,
correct,
that his son was a student at Oxford High School,
that's correct,
that he heard that there was a shooting,
correct,
that he discovered that his gun was missing,
that's correct,
that he didn't know if his son took the gun,
correct,
and that he was freaking out.
That's correct.
After that phone call to 911, you know that James Crumbley received a phone call from law enforcement and he and his wife went to the substation in Oxford.
Correct.
They returned home around 2:30 p.m.
Correct.
There was some indication and some questioning yesterday from the prosecution about the white paper that had changed hands between James and Jennifer Crumbley at the school.
Correct.
Remember that? And the prosecution asked you if there was any indication that James Crumbley had made phone calls to doctors, hospitals, or physicians, correct?
I remember that, correct.
To your knowledge, and if you don't know, it's okay to tell me you don't know if there was anything requiring James to make those phone calls, correct?
I know nothing about the meeting.
And you know that the meeting was at approximately, ended around, I think we said 10:53 a.m.
Correct.
And the shooting occurred at began at 12:51 p.m.
That's
It was
correct.
approximately 2 hours later. You also know that in those 2 hours, I'll withdraw that question. You testified about messages between Jennifer Crumbley and a person named Brian Malash.
Correct.
You have no idea whether Mr. Crumbley knew about those messages?
They were together at the time. Other than that, I don't know.
Okay. You don't know if Mr. Crumbley knew what Jennifer Crumbley was saying to Brian Malash?
I do not know.
You know that at some point, Mr. Crumbley's son's name was made public.
Correct.
And it was fairly shortly after the shooting occurred, if you recall.
I don't recall when it was.
Were you aware that Mr. Crumbley and his wife began receiving threats to their safety as a result of what their son did at the high school?
I know in some chat threads there was talk of that, yes.
Were you aware that Mr. Crumbley and his wife had been made aware of some of those threats?
Yes.
Were you aware that there were concerns for Mr. Crumbley and his wife's safety as a result of some of those threats?
Oh, I'm sorry. I was aware. Who was aware?
That there were concerns for Mr. Crumbley and his wife's safety as a result of some of those threats?
I know
I
they
have to
received
object
threats.
to the characterization of what a threat is and what a threat is not. It's, as we know, Judge, it's very subjective.
Okay, so can you be more specific?
Really?
I can move on, Your Honor. My question was mainly if he knew that this occurred, and he said that he did hear something about some threats. I can move on from it, Your Honor. As a result of your involvement in this case, you were aware that Mr. Crumbley's son was criminally charged on December 1st of 2021.
That's correct.
That on December 2nd of 2021, there was an announcement from the prosecutor's office that Mr. Crumbley and his wife may be charged, if you recall the date.
I don't recall that.
On December 3rd, 2021, in the afternoon, that Mr. Crumbley and his wife were criminally charged for their son's actions, if you recall the date.
I'm sorry. I don't recall the dates all that happened.
I have no further questions, Your Honor.
Redirect.
Thank you, Judge. Let's see if I can get this to work.
Could you? I'm not positive it's going to work.
Okay, looks like it's working.
So
Sir,
this
This one's
was
just flashing
like,
it. This keeps flashing the screen.
strobe light.
can you see the other screens?
Yeah.
I can see that fairly well, yes.
Okay.
If you can't see it, you can give you a copy of these, so we're going to have some.
I have them printed if you need them.
That's right. I can-
Okay, that's like flashing.
Yeah.
Okay. May I-
Go ahead.
Sir, you were asked about the shooter and his friend in that conversation that they had. Do you recall those questions?
Yes.
Okay, and then yesterday we had a discussion about that, specifically the amount of text in that conversation, the content of the conversation.
Correct, yes.
Okay. Now, from November the 30th of 2021 up until the time that the shooter was arrested October the 30th of 21 to November the 30th of 21 when he was arrested, were there any responsive text from the friend to the shooter?
No, there was not.
Okay. In that conversation, We talked about in April how the shooter expressed to that friend that he had asked his father for help.
Correct.
And you were asked about some context, and I think your answer was that there was more context to it, you just couldn't recall. So I'm going to show it to you. So we'll go through the entire exhibit. It's exhibit 67. This is the shooter. Like I hear people talking to me and see someone in the distance. That's April 4th of 21.
Correct.
And then right after the shooter wrote, I actually asked my dad to take the doctor yesterday, but he just gave me some pills and told me to, quote, suck it up.
That's correct, yes.
Okay. And then he wrote, like, it's at the point that I'm asking to go to the doctor. And then my mom laughed when I told her.
That's correct.
Okay. The next text is April the 5th, just after midnight, but I'm having bad insomnia. RN. What does RN mean?
Right now.
You know? Okay, right now. I'm paranoid. I need
Right.
help. I was thinking I'm calling 911 so I could go to the hospital.
That's correct.
And he wrote, but then my parents would be really pissed. That's April 5th, 21 at 12:12 in the morning.
That's correct.
I'm going to ask my parents to the doctors tomorrow or Tuesday again. That's April 5th, 21 at 12:38 a.m.
Correct.
And then, but this time I'm going to tell them about the voices. April 5th, 21 at 12:38 a.m. And then the last text is like I am mentally and physically dying. That's April the 5th, 21 at 12:39 in the morning.
That's correct.
Okay, so that's in the same conversation.
Correct, yes.
Okay, is that the context you're referring to?
Yes, I do remember that now, yes. That's what I'm referring to.
And in this conversation, you're saying, this is in August, between the shooter and his friend, you were asked about these videos. I'm going to play this one. This is August 20th at 12:30 in the morning. Okay, is that the noise you were referring to? The noise that it makes when you...
Yeah, the metal is slamming together and putting the magazine and slamming on the table.
Now you were asked about the horse barn, and I'm just going to use council's math here. So if that math is correct, that means 25% of all, so a quarter of the year, they were discussing meeting at the barn?
Correct.
Okay. Any indication in any of those conversations that they were taking their son with them?
No, it was not.
Now I want to ask you about Exhibit 30. And you were asking questions about November the 30th, 2000, they were called to the school. So we talked yesterday about James when he started door dashing on November the 30th. You recall that?
Yes.
Okay. So earlier in the morning, just to get the timeline correct, we had 7:46 a.m. James Crumbley dropped his son off at Oxford High School.
That's correct.
He's back at home at 8:04 a.m.
Correct.
And then he's at the barn after that.
Correct.
Okay. And we went through that Facebook conversation between James and Jennifer Crumbley when she showed him this picture, Exhibit 1. This is Exhibit 128. And I'm going to go to the original one as well, which is 1:30. So we saw that Facebook conversation November the 30th, approximately 9:30 in the morning, when Jennifer Crumbley sent this to James Crumbley.
Correct.
Okay. So based upon the location history and what you were able to determine, he was at the barn at that point?
That's correct.
Okay, so he had not checked in for the day and began working that day?
Correct.
Okay. So it was not until after he saw this, and that's when he signed on to DoorDash?
Correct, after the meeting.
Okay. So you were asked, did he have any reason to stop home? But I want to talk about after he saw this, if he ever stopped home at all. Okay?
Okay.
So November 30th, 2021 at 11 a.m., that's when he first signed on to accept his first order for DoorDash. Is that right?
That is, oh, yes.
Okay. And we went through some of those maps. We went through a little bit quickly yesterday. So I want to make sure that we're on the same page. When he was accepting these orders and making deliveries, it wasn't outside of Oakland County, was it?
No, it was not.
In fact, where was it?
All local within Oxford.
Within Oxford, okay. And he actually drove by his house at least 4 times from the point that he saw this to the point the shooting started.
That's correct.
And never once did he stop home.
No, he did not.
Now, yesterday you mentioned how you responded to the scene and you went to the mire first.
Yes,
And that's the mire that James Crumbley was at when he received the alert of the active shooting at Oxford High School.
that's correct.
And you were helping parents find their kids when you were there?
Yes,
You talked a little bit about the school buses and what you saw. How many parents were there?
dozens, of just standing around in the cold.
Were more coming when you went to
Yes.
school?
Yes, cars kept on coming.
And based upon what we know from the timeline you're able to put together with the data locations, we know that 1:10 p.m. James Crumbley got the email. We know with a certainty that he was at the Meijer parking lot at least by 1:11.
Correct.
He made phone calls in that period of time, and he didn't leave, and he left at 1:17 p.m. So he was in the parking lot where everybody else went to for at least 6 minutes, and then he went home.
Correct.
Okay. And he got home at 1:20 p.m.
Correct.
He was on the phone with his wife for a 10-minute phone call, we said.
Correct.
Okay. And it wasn't for another 14 minutes that he called 911.
Correct.
And it wasn't just parents at that Meijer parking lot. There were students there as well.
Hundreds of them, yes.
Okay. You know, there's 1,700 students at Oxford High School.
I did not know that, but it was a big school.
From what you saw there, the scene that you saw when you pulled up in that white minivan you told us about, and you saw the school buses with kids looking for parents.
Your Honor, I'm going to object. The prosecution's testifying.
Yeah, okay.
Okay. It seemed like it was that number of students at Oxford High School. But paint us the picture of what you saw when you got there.
Again,
I would also object to relevance about what he saw when he got to the Meijer, Your Honor.
It's important because counsel made a point in her cross-examination to suggest that there's no reason for James Crumbley to go home. And I think this witness has established yesterday and today that James Crumbley was actually at the location where everybody else was going to. So it's important for the jury to understand what he was observing when he sped from Pontiac to that location.
Your Honor, I don't understand what Mr. Ragorowski observed at the Meijer is relevant to whether or not James Crumbley felt that he needed to go home. I don't know how the two are connected, Your Honor.
I'm at a loss myself. Maybe I'm missing something.
Okay. Did all the other parents you saw, did they leave or did they stay?
They stayed.
Thank you, Councilman President.
You can step down here.
Your Honor, very brief recross?
Okay.
Very brief, thank you. I believe I only have 3 questions.
Okay.
4, can I get my exhibit back? Thank you. In April of 21, you testified about Mr. Crumbley's son telling his friend, I'm going to ask my parents to go to the doctor, right?
Correct.
You don't know what doctor that was?
We was talking about hearing voices in the distance and stuff like that, but
You don't know what doctor that was, is that accurate? In reviewing the exhibit that we have, we don't know what doctor he was asking to see.
From the word prior to that, where he's hearing voices and he feels like he's dying inside, I do not know the doctor.
You don't know. You don't know if he ever did ask.
He mentioned it in a couple different conversations that he was going to try to ask.
Going to try. You don't know if he ever did.
I do not.
One moment. Okay, you no further questions here.
Judge, I just have to redirect because I have to correct something that was just said in that exhibit. Just one question on that, April.
Okay. I mean, it's where he could be recalled, so. I'm sure you can get to that too. So.
Okay, so we went, this is exhibit 67. We went through this part like I hear people talking to me. The next slide. I actually asked my dad to take to the doctor yesterday.
Correct, yes.
Okay, Is that your recollection?
Yes.
as well?
Correct.
Thank you, Judge.
One question. Sure you know what it is. You don't know what doctor that was, right?
Other than the context of the information prior to that.
That's the answer,
Yeah,
Judge.
he has to answer. He said he doesn't know. He said he doesn't know.
Thanks, Judge.
Okay, so I'm gonna let you step down. Pay your excuse.
Okay, thank you, ma'am.
Yeah, I don't know why I feel like I want the defense to do well. I just feel like they're bad parents. They just suck as parents. It's like they're I don't know. It seems like he has more emotions than she does. She was very emotionless. I just think that we have to be careful. What are we getting ourselves into? Are we going to let the government decide everything about our parenting? So every time a kid gets into a traffic accident, we can go off and sue their parents. Let's say a kid goes out and drinking and driving, because kids that, younger kids shouldn't even barely get a license, and they're drinking and driving. They injure someone. Are we gonna take put parents in jail because of it? You know what you see what I don't know. I don't know where I'm going with it. I just feel like, I don't know. See, I know somebody's going to totally just rib me out in the comment section for that. But I'm not a parent. But at the same time, I just feel like there's parents out there that suck as parents. They're horrible, horrible parents. They're not paying attention to their children. They're not doing anything for society, and they're raising kids that aren't doing anything for society. But then you have something like this where, they were taking care of his basic needs. It didn't seem very emotional with him, but they were taking care of his basic needs. We don't know for a fact that they knew what was going on in his head, and they knew that he was not right. They could have been totally oblivious to it. But that doesn't make them. So we want them to go to jail for that? You know what I mean? I just think it's a fine line. It's just such a fine line. Okay, I'm going to shut up. I'm going to get off my soapbox now. All right, let's move on to the next witness, which is at 1:45. So I forgot what this cop did. This is a cop.
Sir, did you process the men's bathroom in the 200 hallway that was from classroom 233?
Yes, I believe it was either 233 or 231. It was in the same general area.
Oh, he's the one that found the backpack.
The person is asking when they can resume.
After the next picture, Judge. Okay. This is exhibit 26. So what do we see here?
This is a photograph taken outside of that bathroom that we're talking of, outside or across from 231. You can start to see inside the bathroom, there's a black backpack. Along with there's I believe it's a live round or a cartridge as we call it, just found outside of the bathroom. And then you can start to see that there's a large pool of blood inside of that bathroom area. And this is just the entrance to the bathroom itself from the exterior of the hallway.
Did you come to learn this is where Justin Schilling was killed?
Yes, I was.
Did you also recover a fired shell or fired cartridge in this area as well?
Yes, a fire cartridge case was located in this bathroom.
Is that included in the count of 18 you described earlier?
Yes, it is.
Sir, you mentioned earlier the firearm was recovered. This is exhibit 27. Is this a photograph right outside of that bathroom that we just saw?
Yes, it was not taken by me because the firearm had been collected by the on-scene deputies when the suspect was apprehended.
Okay. But that is the firearm that you collected?
That is correct.
That's a 6-hour 9mm handgun?
Correct.
Now, based upon your crime scene investigation, how many times did the shooter fire that weapon inside Oxford High School on November the 30th?
32 times.
And how many unfired rounds, how many bullets were recovered, either from that magazine or elsewhere?
18.
So a total of 50 rounds of 9mm ammunition was taken to Oxford High School?
That is correct.
Thank you. Nothing further, Judge.
Should we go to break right now? Does that make sense to you? Should we go to break? Yes.
Oh, so they're taking a break. I thought they were gonna.
Either or. I mean, we'll need a longer break to fix the monitors as well, Judge. I don't know how long else will take this witness.
No
Might make
cross
sense.
No problem.
No cross runner.
Oh.
Oh, they're not gonna cross him. Okay.
Okay.
All right. Then the next person that came up was the lady that sold the gun to them.
Good, Your Honor. Thank you. Good afternoon, Ms. Beck. We know that you were working on November 26th of 2021.
Yes,
You were involved in the sale of the 6-hour 9mm to James Crumbley.
yes,
In fact, you just testified about the beginning of that sale, correct?
yes,
That you came out of the office,
yes,
that you approached a different customer,
yes,
then you approached Mr. Crumbley,
yes,
who was standing at the counter.
yes,
You testified that Mr. Crumbley knew which firearm he wanted.
yes.
You recall that you had some conversation with Mr. Crumbley,
I did not have a conversation with him.
standing at the counter.
I approached him and asked if he need help.
And did you converse with him? Did you talk with him at all?
No, I did not.
You asked Mr. Crumbley which firearm he wanted to purchase, or if he
I
wanted to see anything,
asked if he need help and he said, yes, I want to see that.
and he indicated that, or I'm sorry, you indicated that you recognized Mr. Crumbley from prior purchases, correct?
Yes,
So you knew he'd been to the store before.
right,
He knew which handgun he wanted, and he indicated to you that it was based on prior visits, if you recall.
no. He said he had his eye on that gun for a while, so that means he could have been in the shop looking at it, could have been online looking at it. I don't know, I didn't inquire that.
You testified previously in this case?
Yes,
Specifically, you testified on February 24th of 2022.
yes,
Do you recall your testimony on that day?
yes,
Would it help to refresh your recollection to know exactly what you testified on that day as it relates to this question?
sure.
Page 94. May I approach, Your Honor? Thank you. You can review the highlighted lines. You can look before and after if you'd like as well, and just look up when you're done reviewing it, please.
Is this what I'm saying?
Correct.
So this is saying what I just said?
May I approach?
Sure.
Thank you. And the question was, you do recall, however, that he was very clear that he wanted one handgun based on his prior visits to the store. Your answer was yes.
Yes.
Hold on a second, Judge. Counsel didn't read the question before that.
Okay, well, I guess we can follow up.
I'll do a redirect. That's fine.
There was also some discussion, if you recall, you testified that Mr. Crumbley said, you testified on February 24th of 2022 that Mr. Crumbley said he had his eye on that firearm for a few days, if you recall.
He didn't say a few days, he said quite some time.
Your testimony was that he said that he had his eye on it for a few days, if you recall that testimony.
Which page, Counsel?
Yes, page 88, specifically lines 3 through 4.
She's tough. Specifically.
He purchased the handgun that he pointed at and looked at, correct? The
Yes.
6-hour?
Yes,
You had no reason to believe that Mr. Crumbley was buying the firearm for anybody else.
no,
In fact, you said that you called him the younger guy who was there, was standing behind
yes,
Mr. Crumbley, I'm sorry.
yes,
You didn't see Mr. Crumbley having any conversations with that younger guy prior to approaching them at the counter, correct?
no,
At some point, you handed the sale off to, I think you said Chris.
yes,
If you recall, you didn't see any conversations between Mr. Crumbley and that younger guy about the purchase of that firearm after you handed off the sale,
I
correct?
did not.
You didn't hear Mr. Crumbley say anything to the individual that he was standing with about buying the handgun for him?
No,
And we identified, you later learned that the individual with him was his son.
yes,
You didn't hear or see his son say anything to Mr. Crumbley about, that's the one I want.
no,
In fact, you saw no exchange between them whatsoever.
none.
You testified that provided with the sale of firearms at your store is also an ATF handgun notice, correct?
Yes,
And in that ATF handgun notice, are you familiar with that pamphlet, the safety notice?
yes,
We can see it in the picture, correct?
yes.
You've reviewed that previously? Not
Yes.
necessarily in connection with
Yes.
this case, but as part of your employment?
Yes,
And in general, it's unlawful for a minor to possess a firearm, is that correct?
yes,
There are certain circumstances where it is not unlawful, correct?
correct.
And specifically 18 USC 922X sub 3 sub A sub I, which is in that pamphlet, says that a minor can temporarily possess a handgun under certain conditions. Do you know
I'm
that?
just going to object to the form of the question to this witness. We do have a special agent from the ATF testifying later in this trial. I don't think this witness is equipped to testify to the content of the pamphlet, only that it was actually given.
Well, the pamphlet is an evidence.
It will be. It's not yet, but it will be.
Okay. So, well, I mean, I get you, have you seen that excerpt in that pamphlet?
I mean, not all the numbers, I mean, I couldn't recall all the,
May asking Ms. Beck to recall the specific site from the United States Code is a little bit difficult for her.
I'll ask you for the content then, Your Honor. I was trying to be complete in my question, but I'll just ask her if she recalls the content. You know that pamphlet directs that a minor can temporarily possess a handgun under certain conditions, correct?
Are you familiar with that part of the pamphlet?
sorry, read that.
Yes, that a minor can temporarily possess a handgun under certain conditions.
Yes,
Included in that is target practice, correct?
yes,
To your knowledge, and this is just your knowledge, I'm not asking you about anything that you may know about anything after they left the store. But while they were in the store, to your knowledge, you never saw Mr. Crumbley allow his son to possess that Sig Sauer without his permission.
No.
Or his supervision.
no,
Based on your knowledge of the law, and this is just your knowledge of the law, it is not illegal for Mr. Crumbley to allow his son to use that Sig Sauer or any handgun at a shooting range.
no,
Or for Mr. Crumbley's son to handle the firearm while at home if Mr. Crumbley is supervising him.
As an object to the form of the question is, she's talking about, that's two different things.
Yeah, well, you can't ask her if it's legal or illegal, but you can ask her if she's familiar with what is in the pamphlet. If that's in the pamphlet, she's familiar with it, she can testify.
Correct, Your Honor. That was a continued question of based on your knowledge of the law. I'm asking her about her knowledge.
Okay, now I'm going to object to the relevance, Judge. She's an office manager for the store that sold the firearm. Asking her what her knowledge of the law is not appropriate, Judge. It's an improper question.
When it comes to guns, it should be.
Her knowledge of that law, why is that relevant?
Your Honor, I would think that as somebody who's an office manager of a firearms store, that she would have knowledge of firearms laws.
Okay, but she might, but why is it relevant to these proceedings? I think you have an ATF.
I can ask him as well, Judge.
Okay. Yeah, her knowledge of the pamphlet, because she reviewed it, gave it to Mr. Crumbley, would be relevant, but I don't think her knowledge of the law is relevant to these proceedings.
Thank you, Judge.
Regarding the trigger lock statement, that was, which exhibit was that? You had a few of them, but we'll look at exhibit 40. See if I made it work. Exhibit 40 is the trigger lock statement. This was the one specifically from November 26th of 2021, correct?
yes,
The trigger lock statement simply in bold, right above purchaser dealer. In bold, that statement indicates that signing of that form just shows that that sale was done in compliance with the law, correct?
yes,
That a cable lock or a locking box or a storage box was provided, correct?
yes,
There's nothing on there that's an acknowledgement that the purchaser is going to use the cable lock, correct?
correct,
There's nothing directing that the purchaser has to use the cable lock, is that correct?
correct,
There's nothing on that form
Yeah, but come
indicating
on.
that you are required to do anything as the dealer other than provide the cable lock, the trigger lock, or the case, correct?
correct.
This is the part where, okay, this was wrong. This is the
In
part
fact,
where,
in November of 2021, there were no laws governing whether somebody had to use a cable lock or a case or a safe or anything like that, if you know.
There's relevance. There's no
I
relevance.
did not agree with them buying him a gun.
If she knows, Your Honor.
But it's not just personal knowledge, it's relevance.
Are you asking her if she knew of any law?
Correct, Your Honor.
Okay, well, I do know, I'm already familiar with anything like that. She doesn't know.
Thank you. Exhibit 36, which is the firearm transaction record. I believe this was for the Caltech. You indicated on direct examination that Mr. Crumbley did not receive the firearm the same day that he purchased the firearm, the Caltech.
Correct.
And this is the firearm transaction record. This is page 2 of that form, correct?
Yes.
And you indicated on direct that you didn't know if it was delayed or if there was some other reason. It could have just been taking a long time with the federal government. Is that accurate?
Yes.
Now, if the sale was delayed, there would be a box checked on this page 2, correct?
Yes.
In fact, it would be toward here, toward the bottom, where in 27C, correct?
Yes.
And this says proceed.
Yes.
So that sale was not delayed by the federal government, other than maybe it was just taking a long time. Is that fair?
Yes.
I want to go back to the purchase of the Sig Sauer 9mm. Exhibit 37 is the receipt. And I will put it up on the screen for you. This is the receipt of the Sig Sauer purchase on November 26th of 2021, correct?
Yes.
And on there, we see that the firearm is listed. It says 1 Sig Sauer SP2 2022.
Yes.
There's a serial number, SN/, and then it has numbers and letters.
Yes.
Has a price,
Yes.
Mr. Crumbley's contact information,
Yes.
his driver's license,
Yes.
shows it was paid, correct?
Yes.
Mr. Crumbley's signature, the
Yes.
stock number,
Yes.
the tax amount.
Yes.
There's no ammunition listed, correct?
I'm sorry?
There's no ammunition listed, correct?
Correct.
To your knowledge, James Crumbley did not purchase ammunition with the Sig Sauer on November 26th of 2021, correct? If he had, you would have had a receipt for it at your store, correct?
Yes.
I have no further questions, Your Honor.
Briefly.
I don't know what that proves, though.
It's back. If the defendant's son would have walked in with the defendant and pointed at that 9mm and said, "Hey, Dad, that's the one I want," would you have sold it to him?
No.
Okay. And in fact, in your store, there's information posted that says, "Don't buy it for somebody else."
Correct.
Okay. Now that the trigger lock statement, that is to ensure that the firearm dealer provides the tool to make it safe to the buyer of the gun. Is that right?
Yes.
Whose
Okay.
responsibility it is to actually make the gun safe?
The buyer.
Thank you. Nothing further.
Okay,
All right, I'm
touche.
gonna allow you to
He's
step
right.
out. Can you excuse?
Thank you.
Thank you.
That right there is the whole trial. That piece right there is the entire trial. All this other crap,
Ask you to come back at 1:00. Is 1:00 okay? That's enough time.
nothing to do with it.
Discuss the case with each other or anyone else.
Okay, we're on
During
day.
years as a high school counselor, how many times have you had to
Victoria, I
call a
think.
parent in and tell the either mom or dad or guardian that you identified suicidal ideation in their child?
15 to 20, over a dozen.
And did the parent fail to take your child home?
I can't think of any, no.
Now, you indicated this was a confirming responses from James and Jennifer Crumbley. In those other meetings, were parents sharing information?
Oftentimes, yes. Oftentimes parents would come in and want to paint a more complete picture of their student, of their situation. Oftentimes, all the time, I feel parents know their kids better than I do. I have, if all I ever did was meet with students, I might have 2 hours a year with each student.
Do you rely upon the parent for that information?
Absolutely.
I've got nothing further. Thank you.
Yes, Your Honor.
Okay.
Thank you.
Okay, we're at day 3 now. we have the school counselor testifying. So again, we're just going to watch the cross-examination.
Good morning, Mr. Watkins.
Good morning.
I'm going to go back to your first interactions with Mr. Crumbley's son. I'm not going to use his name, so if for some reason the way that I'm referring to his son confuses you, just let me know. If we're using too many he's, does that make sense?
Okay, I will do that.
Thank you. So your first interactions with Mr. Crumbley's son were in the fall of 2020.
Well, fall of 2020. No, it would have been spring of 2021.
Okay, so it would have been before the 2021 school year.
Yes.
And that was for planning his class schedule, is that correct?
That would have been the main reason that we would have met with every freshman. And then I had that email that was displayed earlier from his English teacher.
The May of 2021 email.
Yes.
And after that May of 2021 email, you didn't specifically recall having a meeting with Mr. Crumbley's son.
I don't have memory of that meeting, no.
You went back and reviewed your records and determined that there appears to have been a phone call. That you called him down to your office?
I called into his class and called him down to my office.
Okay, but you don't remember ever meeting with him?
I don't remember the meeting.
You did not contact Mr. Crumbley or his wife after that May of 2021 email?
That is correct.
So other than discussing Mr. Crumbley's son's class schedule with him, and then maybe meeting with him in May of 2021 about that email, you don't recall any additional interactions with Mr. Crumbley's son before November 10th of 2021?
That is correct.
In September of 2021, you received another email from a teacher, which was displayed, I believe it was exhibit 199, which would be an email from a teacher talking about a poem. Am I understanding that correctly?
Yes, that he had a class assignment of writing an autobiography poem.
And he had said to that teacher, he'd made some concerning statements in that poem.
Yeah, so if I can give a little more context to this was actually a Spanish class. So the poem wouldn't have even been in English.
Okay, so he used words in Spanish?
That is my understanding after talking to the teacher.
And the Spanish teacher had concerns about the Spanish words that he used?
That is my understanding based on the email. I also followed up with the teacher and gained further context about it.
Right, and as a result of gaining further context, you were not concerned?
Because the teacher lowered the level of concern for me, yes.
So even though your response that you were going to catch up with Mr. Crumbley's son, even though that's in the email, you didn't actually meet with him because you had the conversation with the teacher?
That is correct.
Again, you didn't notify James Crumbley or his wife about the teacher's concern in September of 2021?
No, I did not.
And you didn't forward them the email?
No.
And that was because in your mind, based on the information that you had, there was nothing to be concerned about?
Well, I just gained further context from the teacher and made the decision based off of that information.
And had no concerns?
I think that you're putting those words in to make it a little more extreme. But what I would say is I gained context and made a decision based off of that.
And if you had been concerned, if you had sufficient concern, you would have reached out to Mr. Crumbley or his wife?
If it had raised the level of concern where I felt I needed to, I would have, yes.
So then on November 10th of 2021, you received another email from a different teacher?
From the same teacher.
Oh, thank you for correcting me. It was the same teacher. She asked you to check in with Mr. Crumbley's son on November 10th.
She said he might need to speak with you.
And she said that she believed he was having a hard time?
She said he's having a rough time right now. He might need to speak with you.
The next day, you responded and indicated that you would check in with him.
Later that evening, after the school day was over, I responded, I believe.
So you obviously couldn't have met with him that day because the school day was over, correct?
She sent the email at the end of the school day, and I responded approximately 2 hours after the end of the school day.
So you couldn't have met with him that day because the school day was over. Is that fair?
He would not have been there.
So you would have met with him the next day.
Yes.
And do you believe that you did meet with him on November 11th?
Yes.
You spoke with him in the hallway?
Yes, I caught him in between classes.
You simply told him that you were available if he needed to talk?
Yes.
There was no further discussion with him at that time?
No, because the way the email was to speak with you. So I just wanted to let him know that there was an opening if he wanted to speak with me.
And having a rough time, like the teacher indicated in her email on November 10th, having a rough time isn't necessarily something that raises red flags. Is that fair?
I didn't have any other context as to what was going on. And I just wanted to offer a chance for the student to speak if he needed to do so.
And his response, if you recall, was something along the lines of, okay, thanks, okay. And I'm not asking you to quote him because I don't know if you remember, but it was not an uncommon response. Does that make sense?
Yeah, it was a normal response given the situation.
You did not email James Crumbley or his wife about that November 10th email, correct?
I did not email them, no.
Or the November 11th brief meeting with their son?
Correct.
You did not forward that email to Mr. Crumbley or his wife?
I did not.
So then the next interaction that you had with Mr. Crumbley's son was on November 29th of 2021, and that was a Monday, if you recall?
Yes, that would have been a Monday.
You were forwarded another email that was sent to Nicholas Ejak and Pamela Fine. Is that correct?
Yes, I was.
And this third email, this is the third email you've received from a teacher since this school year began, if you recall.
Yes, it would have been.
September of 21, November 10th of 2021, and now November 29th of 2021. The email advised that Mr. Crumbley's son was looking at bullets on his phone at the end of class.
Could I see the email?
Yes. Exhibit 201.
This is just the forward, so it doesn't have the actual email in it.
You were advised that that was the concern, was that Mr. Crumbley's son was looking at bullets on his phone.
I believe that to be true, but this email you have on the screen isn't the one that says that.
Correct. The email doesn't say it, but you were aware that that's why the teacher was concerned, and
Could I
that's why
see
the
that
teacher was
email?
emailing. I don't know if that's in the email.
That email was displayed earlier, I think. It was sent to Mr. Ejak and Ms. Fine.
That was the one.
It's at
Unless
the
it's-
bottom.
oh, there we go.
it is.
There we go. Thank you.
Yes, so this is the email I was forwarded. And it just was at the end of the hour. The teacher didn't get a chance to really find out what was going on, but it just glanced at it and had seen that.
And I'll leave that up in case you need to look at it.
Thank you.
So you were aware that on November 29th of 2021, at the time you received this forwarded email, that Mr. Crumbley's son was looking at bullets on his phone in class.
Yes, after reading this email, I was aware.
At some point, well, let me go in order. Shortly after this email, you then met with Mr. Crumbley's son and Pamela Fine.
Yes,
And you met in your office or Ms. Fine's office?
it was in Ms. Fine's office.
And you were there just as support, but Ms. Fine did most of the talking. Is that fair?
Yes, I would say that was fair.
And Ms. Fine talked to Mr. Crumbley's son about looking at bullets on his phone?
She did. She actually asked him to describe why would a teacher be contacting you right now? And the student was forthcoming in what had happened in class.
He was forthcoming. He was honest, to your knowledge,
To
right?
our knowledge, he shared what we had in the email.
He told you what class he was in looking at bullets. He said he was looking at bullets, and he even explained why he was looking at bullets, if you recall.
He said that he and mom had been at the shooting range over the weekend and he was researching what they had done.
And if you recall, Ms. Fine acknowledged that what Mr. Crumbley's son was doing may not have been appropriate, but there really didn't seem a lot of concern. Would you agree with that?
Well, the concern was that it wasn't appropriate, and that the concern was then expressed by placing a phone call home.
So the concern was the appropriateness of the behavior in class.
Yes,
And at that point, a voicemail was left for Jennifer Crumbley.
yes.
You said that, if you recall, Mr. Crumbley's son was understanding during the meeting. He didn't fight with you about it. He listened, and eventually he went back to class.
Yes, I would agree with that.
Later in the day, you received an email from the same teacher who expressed that some of Mr. Crumbley's son's prior work may have been a little violent.
No, that was in the same email.
It's in the same email?
It is.
Or was it in an email sent later in the day?
No, it's in the same email from that morning. It was up on the screen. It's at the bottom of it.
The one that was originally sent to Mr. Ejak and Ms. Fine?
Yes.
That was later forwarded to you?
Yes.
You didn't see any of those assignments prior to meeting with Mr. Crumbley's son?
That is correct.
If you had seen those assignments, it probably wouldn't have changed your approach to the meeting, correct? Because the approach was really more about the appropriateness of the behavior. Is that fair?
I mean, it's a hypothetical of what we would have done. We acted on the information we had.
And the information that you had was that he was looking at bullets in class.
Yes.
And looking at bullets is not necessarily something that is in itself concerning to you, correct?
I think you're kind of trying to put it in like a pigeonhole. We were trying to gain context of what was going on in the situation. Because a student looking at something on their phone at the end of the hour is different than a student brazenly doing it throughout the entirety of the class. But our conversation was, is this school appropriate or not?
And in fact, if you recall, your position was at the time, it wasn't necessarily concerning because he was honest about it. It seemed kind of a commonplace thing given the Oxford community and the gun culture in the Oxford community and things of that nature that you took into a factor.
We took a lot of things into a factor, including the fact that we conversed of how it was not school appropriate. And that's why a phone call was placed home.
As I just indicated, the Oxford area was and may still be a hunting community if you know.
Okay.
I'm asking.
People hunt who live in Oxford.
In 2021, you would classify it as a hunting community.
I would say that there are people who are hunting. Yes.
Activities with guns were a common hobby in 2021, if you know.
I mean, there were people who had guns as a hobby, yes.
It was common for students to be interested in guns
I'm sure there are students who are interested in guns.
and to go to the shooting range.
Yes, students would go to the shooting range.
So I'm just going to object to make sure that the witness is speaking with personal knowledge. It appears counsel is asking him to give general speculation.
Well, if you know, if you know, you're not familiar with guns yourself, it sounds like. So just if you know.
Okay.
Students going to the shooting range isn't viewed as unusual or concerning in and of itself. Is that correct?
I think that you've got to have context with all of these.
Right, and I'm just asking, in and of itself, a student going to the gun range, the shooting range, is not concerning in and of itself.
It depends on the context, because the student weightlifting is not concerning in and of itself unless they're doing it inappropriately, right? So you're taking something that's a broad statement that can have a wide context.
And on November 29th of 2021, Mr. Crumbley's son told you and Ms. Fine that he'd gone to the shooting range with his mom the weekend before.
Correct.
That in itself is not concerning to you.
He did it in a way that was appropriate.
You would agree, and can you refresh my memory, how long were you in the Oxford School District as of 2021?
7 years.
And in that 7 years, you learned that many households had firearms in the household. Would you agree with that, if you know?
What is many? There are people
More
who
than
own
10?
guns. There are people who own guns.
Okay, and you as a counselor at the school, you were aware of that?
Yes.
It wasn't completely unheard of?
No.
It was also relevant when looking at the situation, it was also relevant for you to note the fact that Mr. Crumbley's son was not hiding that he was looking at the bullets, or didn't hide it from you when he spoke with you and Ms. Fine.
Well, he didn't lie about what had happened.
And that was important to you.
Yes.
As a result of the meeting with Ms. Fine, with you and Ms. Fine, Mr. Crumbley's son was not disciplined.
To my knowledge, no.
There was a phone call placed to his mother, which we've talked about. There was a voicemail left. You did not yourself call Mr. Crumbley.
I did not.
You did not forward him the emails that you received.
I did not.
You don't know if that voicemail was ever shared with Mr. Crumbley. Is that fair?
Well, we talked about it in our meeting the next day.
Okay. On the 29th, you don't know if Mr. Crumbley was ever made aware.
I would have no way of knowing that.
Right, you wouldn't know. You responded to the situation of Mr. Crumbley's son looking at bullets on November 29th on his phone with the information that you had.
I did.
And from what you knew at the time, other than the behavior being inappropriate for school, you didn't see anything else that might have been concerning.
Well, and I want to make clear, I wouldn't be the one doing discipline in this situation. So.
And I'm asking, and let me clarify, I'm just asking from a counselor's perspective. I'm not asking for discipline. You clarified that Mr. Eject did discipline in this
Okay. So could you repeat your question? Please?
Yes. As a counselor, on November 29th of 2021, you didn't see anything overly concerning about what we've just talked about with looking at bullets on the phone. That the focus was more that looking at bullets on his phone was inappropriate for school.
So are you asking from a mental health standpoint, did I see anything concerning?
Not really. I don't know that you're a mental health professional. I mean, you're a school counselor and you do have some training and education in that. I'm not asking for you to go anywhere outside of your education and experience. Just as a high school counselor, sitting in Ms. Fine's office with the information that you had, you didn't see a bunch of red flags. We've talked about, and let me give you some, let me go over it a little bit. You've discussed that you know that there are households in Oxford that have firearms in them, right?
Yes, there are.
You know that people in Oxford hunt.
Some do, yes.
You know that students are interested in guns.
Some can be, yes.
You know that students look at bullets.
We had one student who did that in that situation, yes.
You know that student, Mr. Crumbley's son, was honest about looking at the bullets when he was asked about it.
To the extent of our knowledge, yes, he was.
He told you that he'd gone to the shooting range with his mom.
Yes.
The weekend before. Yes. Those things were not concerning to you.
Taking those things in a vacuum is why we called home. That's why Ms. Fine called home.
And she said, we had this meeting. We told him it's not appropriate. He understands. No need to call back unless you have questions, right?
I don't remember the exact voicemail that was left.
The voicemail was not, we need you to come to school right now.
To my memory, it was not, but again, I don't remember the exact voicemail that was left.
On November 30th of 2021, you received another email. It's this one, Exhibit 202, which was from another teacher who was talking about Mr. Crumbley's son looking at a video of a guy gunning people down. Correct?
Yeah, so this teacher was a co-teacher in that same first hour class.
From the day before?
Yes.
Okay. You reviewed that email on November 30th of 2021.
I did.
You made the decision I think you said you didn't see it for about 20 or 30 minutes.
I didn't. I was on the phone and I actually responded to it while I was on the phone. And then upon ending that conversation, was going to go meet with the student.
And this is the fourth email that you've received about Mr. Crumbley's son since the beginning of the 2021 school year.
Yes.
The third email in 2 days.
Is it?
You would have received
I think it's the second in 2 days.
the November 29th email about the bullets, and then do you recall receiving a follow-up email later that day?
It was a confirmation of that.
Okay.
Yeah, so this is the second one with additional information.
Okay. The second one on a different issue, is that
Yes.
fair? Okay.
Yes.
The teacher described the video as a movie scene, but not a real event.
Yeah, she said it looks like it's a movie scene and not security footage / a real event.
She expressed some concern based on, quote, some of his other behaviors.
Yeah, but definitely still concerning when taking into account some of his other behaviors. Yes.
You did not forward this email to Mr. Crumbley after you received it.
Well, no, but over an hour later, I called him into the school.
Right. And you decided after receiving this email that you were going to meet with Mr. Crumbley's son.
Yes.
Approximately an hour after receiving this email, Mr. Ejak advised you of another report made by a teacher about Mr. Crumbley's son.
Yes, as I was about to go and call down his son, Mr. Ejak actually came into my office with information about the math assignment.
And that there were some concerning comments and markings on the math assignment.
I didn't have any context about the math assignment. I just knew there was something about it.
At that point, you hadn't seen it. You were just
I
going
know.
off of what you were being told. Is that fair?
That is fair.
So you went to Mr. Crumbley's son's classroom.
I did.
You called him out of class.
I walked to his classroom.
Yeah, when I called out, I meant like at his classroom. You went and got him.
Yes.
Okay. While you were there, you also obtained a copy of the worksheet that we've seen.
I did.
And that would have been what I call the modified worksheet. That would be the one that had the things scratched out and the words added that you identified and things like that.
Yes.
You and Mr. Crumbley's son went back to your office where Nicholas Ejak was waiting in your office, if you recall.
Yes, that is correct.
It was at that point or shortly thereafter that you called Mr. Crumbley's wife.
Approximately 20 minutes into our meeting, yes.
So you met with Mr. Crumbley's son for about 20 minutes.
Yes.
It was during that meeting that Mr. Crumbley's son told you about his family member passing away,
He did?
about his dog passing away,
Yes.
about his friend moving away,
Yes.
talked about COVID being hard on him.
Yes.
He had a hard time with virtual school, if you remember.
He did say that, yes.
And you asked about the drawings and the markings and the things on the assignment that you had in front of you.
Yes, I asked him to clarify what was going on in the assignment, but I also talked about the email I had received, and I had also talked about in context of the conversation we had yesterday.
Okay. So some of the meeting was about inappropriate behavior. Is that fair?
It started off with a conversation about that because I didn't know what was on the phone. So I asked him what he was watching.
Okay.
And then we talked about, look, we just had a conversation yesterday about appropriate behavior in class. This feels like the same thing that we're dealing with here. And after we had talked about that for a few minutes, I brought the math sheet out and asked him to start explaining to me what was on there.
And when the prosecutor was asking you questions, you said initially when you got that email around it would have been 8:30 when you saw the email from the teacher, initially you were frustrated. In fact, you used the word frustrated.
I was frustrated.
And it was kind of like, we just talked about this yesterday. Does that kind of explain what you were feeling at the time?
Yes, I would say that we just had a conversation about this. Why am I hearing about something similar again?
So you talked a little bit about that, and then you talked about the homework, or the math assignment or the math paper that we saw, and you asked for some more context about what was on the paper.
Well, initially I asked him to just describe what was on the paper, and he started talking about how it was a video game, that he liked designing them, like drawing them. And then I asked for him to explain the words on it because I didn't feel those were as easily explained by simply stating, well, it's a video game.
And in fact, you said that you didn't want to give context to his words. You didn't want to assume what he meant. You wanted to hear from him what those words meant.
Yes.
And he gave context.
He did. That's when his demeanor changed from kind of being like, what do I have to say to get out of here and just not get in trouble, to he became sad.
And you used the word appropriate to describe his level of sadness based on what he was telling you.
The way he was acting matched what he was saying. To me, it's sad if a family dog dies or a family pet dies. It's sad if a relative dies or a friend moves away. So his demeanor matched what he was saying.
And again, in and of itself, being sad is something that you talked about you saw an increase of after COVID in your students. Do you recall that?
Yes.
And
we
that
did.
and that was not, again, in and of itself. And I'm not asking you to, I'm not trying to trick you by asking these questions. I'm not trying to give meaning to something that isn't there. I'm asking you, based on the information that you had at the time, you felt that his sadness was an appropriate level of sadness, not overly concerning. We'll talk about it a little bit more, but the sadness itself was not necessarily overly concerning beyond wanting him to talk to someone.
Appropriate and concerning are two different things.
Okay.
When I say appropriate, I mean it matched with what he was saying. Something can be an appropriate response, but also be heavily concerning, right? Like, I don't know a good example off the top of my head, but what I'm saying is his demeanor matched with what he was saying, but to me it was concerning, which is why I called parents.
Right, exactly why you called parents. So if he had been sitting in front of you and talked about these losses and was kind of like, yeah, it's no big deal, it's not a big deal, that could also be concerning.
It would be a different type of concern, yes.
If he said, I lost the top to my pen and was crumbling in pieces and falling into a puddle of tears on your floor, that would be concerning, but for different reasons.
It would be memorable and concerning, yes.
So the losses that he experienced, you agree, I think we can all agree, were significant.
I think when taken in totality, yeah.
And he was showing you that he was sad.
Yes.
He was also expressing during this meeting that he had concerns about missing class, if you recall.
He did, especially as after classes changed, which is a normal thing. He expressed that he was worried about missing his chemistry class, which was his next class after the math class. So during that time, Mr. Ejak went and retrieved his belongings and went to go get homework for his chemistry class.
And I'm going to go over that in just a second too, but if you recall, and I don't know if you pay close attention to your students' attendance, but if you recall, Mr. Crumbley's son had pretty good attendance.
He did.
He didn't miss school a lot.
No, he did not.
If you recall, his grades weren't great.
No, but he was on track for graduation. He was passing. I believe he was failing one class at the time, and it was not by much.
So he was close to passing all of his classes. One of them he was failing, but close to passing.
Yes.
So his attendance and his grades obviously were not overly concerning to you.
I wouldn't say overly concerning, but a student who cares about class and wants to, he had expressed an argument the night before and wanted to go to class, had expressed, frustration of missing school during COVID and just that entirety. So it wasn't strange at that point to have a student not want to miss class.
Right. That wasn't odd to you at all, given his history. Now, if he were somebody who missed school all the time and was failing all of his classes, he's like, I really want to be in school. I really want to do my homework. You might feel a little differently. Is that fair?
I would say it was in line based with the information I had.
Okay. And you said that after Mr. Crumbley's son expressed these concerns about missing class, that Mr. Ejak went to his first hour class to get the backpack?
It would have been in his second hour class where his belongings were, yes.
So he went, Mr. Ejak went to his second hour class to get his belongings and brought his belongings back to your office.
Yes, this would have been after we had confirmed parents were coming, probably a little after 10 a.m.
He, if you recall, began working on schoolwork, waiting for his parents to get there.
That is my recollection, yes.
Also, if you remember, while you were waiting for his parents, you also began watching some videos with him.
Yep, so he had expressed different things he wanted to do after high school. And he had expressed wanting to go into video game design. I know that when students are waiting for parents, it can be high anxiety time for them. So I wanted to try and engage him as best as I could. So we actually watched videos from the OTEC, the Technical Center campus, where they had programs that were centered around what he wanted to do. So we talked about what it would look like to do an application for them because he was a sophomore and he would be able to apply for the next school year. And so I did that, one, to kind of just bridge that time that could be high anxiety, and two, if you have any inkling that a student may potentially be displaying any signs of suicide or suicidal ideation, getting a gauge of future plans is crucial. So I wanted to get that gauge as well.
And he did that, and he picked out some videos to watch, is that fair? And you picked some out?
Yeah.
You also asked him during that time if he was a threat to himself or anyone else.
I asked him that earlier.
And that is part of your assessment of the situation, is that fair?
Well, it was a question I felt needed to be asked based on what I had.
And based on your education, your experience, and your training, you know that that's an important question to ask.
In that situation, yes.
And he basically said, I know this looks bad, but I'm not going to do anything.
Yeah, it wasn't said as flippantly, but it was, he understood, like, I can see why this looks bad. I'm not going to do anything.
Okay. So, although you had concerns, you also had the student in front of you reassuring you that he was not going to hurt himself or anyone else.
Based on what he told me, yes.
Mr. Crumbley and his wife arrived at approximately 10:30. I think that there was some time lag between them getting to the school and actually getting into your office of about 10 minutes, if you recall.
Okay, I don't know when they arrived at the school. I know when they arrived to my office.
Their son was in your office when they got there.
Yes.
Mr. Ejak came into the office after Mr. Crumbley and his wife came into your office.
Yes.
Okay. Because at some point he'd left while you were sitting with Mr. Crumbley's son.
He left once we had confirmed that parents were coming.
Mr. Ejak comes back in. When Mr. Crumbley and his wife walk in, I just want to lay the room out a little bit. So there's your desk. You're on one side. On the other side was Mr. Crumbley's son.
Yes.
There was a second chair in front of your desk.
Yes.
Mr. Crumbley sat in the second chair next to his son.
Yes.
And then Mr. sat in a third chair that was available in was it behind Mr. Crumbley a little bit?
So there were two across from my desk, and then there was one that was kind of off on a corner,
Okay.
and that's where she sat.
Your office was not the size of this room. Is that fair?
Yeah, that is fair.
Okay. Fairly small.
It's not small. It's a decent sized office, but it had space where there were two seats across from me, one seat kind of on the kitty corner, a door, some space kind of off to what would have been my right as I was sitting in my office.
And Mr. Ejak would have been kind of off to your right. Is that fair?
Yes.
Okay. So he wasn't sitting in one of the 3 or 4 chairs with your chair. He was kind of off to the side.
That is correct.
You testified when the prosecutor was asking you questions that while you were talking with Mrs. Crumbley, that you recall Mr. Crumbley was interacting with his son.
I do.
You said that Mr. Crumbley looked at the math assignment, the modified math assignment, because that's the one that you had, that he looked at the modified math assignment with his son.
That is correct.
They looked at it together and that he showed concern for his son.
Yeah, it felt like he was interacting with his son and that he mentioned some things that were available for his son.
And we'll talk about that in just a minute. You felt that Mr. Crumbley's interactions with his son, that he was showing the appropriate level of care and caring for him at that point in your office.
Yes, I'm a surface level. Yes.
You confirmed that Mr. Crumbley's son had gone to the shooting range the weekend before.
I did.
You confirmed that he'd had those losses. He lost a family member, his family dog, and a friend who moved away, that he experienced all those things in the year of 2021.
I also asked, and he had mentioned an argument the night before as well.
And they told you about the argument.
They confirmed that there had been a disagreement. Yes.
It's not uncommon for 15-year-olds to argue with their parents. Is that fair?
In a surface level statement, yes, that can happen.
Mrs. Crumbley also confirmed that her son had struggled with virtual school during COVID.
She did.
And that confirms what Mr. Crumbley's son had also told you about not liking virtual school.
Yes.
You told Mr. Crumbley and his wife that, well, let me back up a little bit. You told the prosecutor that your hope was that Mr. Crumbley and his wife would take their son out of school, either get him to see someone to talk to, or to go have a really fun day.
My words to them were, I'd like him to get help as soon as possible today, if possible.
And so you expressed to them that you wanted him to get help as soon as possible today, if possible.
Yes.
And Mrs. Crumbley said, we can't do today, we have to go back to work.
Yes.
They assured you, though, or at least you felt assured, that they were going to get him help.
They were not against it, and they made it seem as if it would be something that they would be willing to do.
Okay. So you handed these 3 sheets of paper to one of them. They didn't toss it in the garbage, right?
Not in front of me, no.
Right. They didn't scoff about it and say, we're not doing this.
They took the paper.
Right. So you had no reason to believe that they weren't going to get their help, either at some point, get their son help, either some point that day or as soon as possible.
Based on the conversation, no, but that's also why I planned the follow-up meeting with the student the next day, was to ensure that there was some movement.
And you planned the follow-up meeting kind of in, and I don't mean this in a disrespectful way, but you kind of planned that in your head, like this is my next step.
Yes.
Okay. You didn't express that during the meeting.
No.
In the meeting, you expressed that you were going to follow up in about 48 hours.
Well, because when mom said that today wasn't an option, I said 48 hours, then I'll be following up.
Okay. So in your mind, you had some kind of timing that you were going to follow up to make sure that things were being followed through on. Obviously, we know that first check-in point didn't come. But you told them within 48 hours you wanted something done by the next morning. And based on your meeting, you didn't have any reason to think that Mr. Crumbley or his wife were not going to follow up.
I would agree.
Essentially, you wanted to ensure, and I believe that you expressed this to Mr. Crumbley and his wife, wanted to ensure that their son's situation and his sadness didn't get worse.
Right. I wanted to ensure that we had something that, if left unchecked, could get worse.
Right. So sitting in the meeting, you weren't concerned necessarily that that day, or even by the next morning, that their son was going to harm himself.
Based on what he had told me, I did not believe him to be actively harming himself, no.
Or anyone else.
Based on what he had told me, no.
Mr. Crumbley's son expressed that he wanted to stay in school.
He did.
He wanted to stay in school for some of the reasons we've discussed. He didn't like virtual school. He wanted to make sure he could stay up with school. He didn't want to miss class. These are some of the reasons that he gave you.
Yes, those were some of the reasons. He really just said that I struggled with virtual school. I want to make sure I'm staying on top of what I am.
And that wasn't concerning to you, that he wanted to stay in school?
No.
Obviously, it's not concerning, right?
In that situation, no. It's not, but given the context of what I was hoping, you take the kid's desires into consideration, but at the end of the day, you want a team making that decision.
And if you recall, you had just had 2 virtual days of school, I think the week before.
Yes, leading up to Thanksgiving, we did have days that were virtual.
And we talked about this a little while ago. To your knowledge, if you recall, and if you don't, just please tell me, he'd only missed 1 day of school that school year.
I know he had good attendance. I don't remember the exact days.
Didn't have that many alarm bells really on that,
Mrs.
other than
Crumbley
the
expressing
drawing.
that she and Mr. Crumbley had to return to work that day, and Mr. Crumbley's son expressing a desire to stay in school, you felt that it was okay for Mr. Crumbley's son to remain in school.
I felt that I was not given full options at that point, because really what I was left trying to decide between is I have parents saying they have to return to work. I have a student that I don't want left alone. And so that's when I asked Mr. Ejak, is there anything from a discipline standpoint? Is there any reason he can't stay in school? Is there anything you need to do? And then I made the decision, I made a judgment call based on what I had, is I didn't want a student potentially home alone.
So based on the information that you had, you decided that it was okay for him to remain in school.
I decided that that was the best decision I thought I could make on the information.
Okay. Based on that meeting, Mr. Crumbley's son, to your knowledge, was not contemplating suicide. You said that he had suicidal ideations, but that's different than being actively suicidal.
It is. The student stated that he was not actively suicidal.
You knew that he had been to the gun range with his mom the weekend prior.
Yes,
You knew at a minimum that he had access to a firearm the weekend before because he went to the gun range.
I knew that he had been to a gun range and that he used a firearm at a gun range, yes.
You did not ask him on November 30th of 2021 if he had access to a firearm.
I did not.
You had no reason to look into whether or not he had access to a firearm. Would you agree with that? Based on the information you had?
It's easy to go in hindsight on a lot of things. Based on what my concerns were, I was concerned about student well-being.
And again, you said it's easy to go in hindsight. So we know what happened within a couple hours of this meeting.
Sure.
We all in this courtroom know what happened. For us to look and say that different decisions could have been made, right?
I made the decisions I made based on the information I had
At the time.
at the time.
You don't have the benefit of hindsight at 10:40 or 10:50 a.m. on November 30th of 2021. Is that fair?
I had 90 minutes of information.
You suggested that his parents find a therapist for him to talk to or evaluate him.
I did.
You have had experience with parents who have refused to provide mental health treatment to their child. Is that accurate? Do you recall that?
Off the top of my head, I'm not recalling a specific instance of that.
If it occurred, do you remember testifying previously about that?
I don't know.
Okay. Would reviewing your testimony on that help to refresh your recollection?
If we want to bring it up, sure.
May I approach your honor?
Sure.
Thank you.
If you would like to read the highlighted portions. Thank you.
You can just read that to yourself and let us know if it refreshes your recollection. All right?
Thank you, Your Honor.
Yeah, so I had asked, like, if it's occurred, and I say it's not overly common, but I'm sure it does happen. But I'm giving a for instance of what we would do in that type of situation if it were to happen.
May I approach your honor?
Sure.
Thank you. So reviewing, based on what you just said, reviewing the transcript has helped to refresh your recollection.
Well, what I'm stating in the transcript is in a situation where that could happen, that what we would do is involve CPS and make sure that the student is receiving ordinary care.
In fact, the question was,
You told the jury it's CPS.
Protective services would be involved if that situation were to occur.
in fact, the question was, thank you, okay. Had you ever dealt with a kid at school who felt needed psychiatric care and yet the parents didn't provide it in some fashion or another? Your answer was yes, that had occurred.
And then I go on to explain what would happen in that type of situation.
Right. You said it's not overly common. It does happen. If it did happen, this is what we would do. Correct?
Correct.
And I know I've asked this a couple of times, but you didn't have any reason to believe on November 30th of 2021 that James Crumbley or his wife were not going to follow through and obtain a therapist for their child to talk to.
I didn't have enough time to know if that would happen or not. Given our context of our conversation, no, I didn't have reason to believe that at that time.
If you recall, the meeting with Mr. Crumbley and his wife and their son concluded at approximately 10:50 in the morning.
That sounds about right, yes.
Their son left the room first, if you recall, and went back to class.
You know, I wonder if this guy carries a really heavy burden on himself over what happened. I kind of feel bad for him.
Yes.
The shooting occurred began at approximately 12:51 p.m. that day. After you heard that there was a shooter at the school, you did not immediately suspect that it was Mr. Crumbley's son, if you remember.
I did not.
In fact, you didn't suspect that it was Mr. Crumbley's son until you looked into his attendance after the shooting.
Correct.
This is also after Mr. Crumbley's son had already been arrested.
Quite a bit after, yes.
I'm going to talk about just a few things. Just go back to your direct testimony with the prosecutor. Said that calling a parent in is a high level of concern.
Yes.
And a concern for appropriate behavior.
It could be, yes.
It could be a concern for the student's well-being.
It could be.
It could be a concern that the student needs immediate care or help.
Yes.
It could be for any number of reasons. A high level of concern is dependent on the situation. Is that fair?
Yes, I would agree.
You're concerned with going to Mr. Crumbley's son's class on November 30th of 2021 is you specifically mentioned that you went because it doesn't basically raise concern or red flags if a counselor goes down to get a student out of class.
Yes, that is true. And I had very little information at that point as to what was going on. So I wanted to make sure to do it. And I knew that the dean wanted me involved in the conversation. So I knew that student support was at least a potential plan at that point.
When you were discussing, you said that you told Mr. Crumbley's son while you were meeting with him before his parents got there that you wanted his parents to get him help. Do you remember discussing that with the prosecution?
I do.
At that time, Mr. Crumbley's son didn't say, "Thank goodness, I've been begging my parents for help and they haven't given it to me."
I'm not sure many students would.
He didn't say, "I'm glad you're going to ask them because I've asked them and they didn't listen."
He did not say that, no.
He didn't say, I really need this and I'm really glad that you're doing this for me."
He did not.
He didn't say any of that.
No, which also would not be, it's not uncommon for students to not have a big response to something like that.
If he had things, obviously your reaction would be different when Mr. Crumbley and his wife got to the school.
It would be different information that I did not have, yes.
And when Mr. Crumbley and his wife were at the school, they also didn't say anything about, or Mr. Crumbley didn't say anything specifically about, wow, son, you really did need some help. You've been asking me for it, right?
No.
The discussion was simply looking at the math assignment, the modified math assignment, and then Mr. Crumbley expressing to his son, you know you have people to talk to, right?
That was a piece of it over the 10 minutes, yes.
That they've talked. Mr. Crumbley and his son have spoken.
He did say that they talked.
When discussing the impact of Mr. Crumbley's son's friend leaving, you don't know that Mr. Crumbley's son had ever expressed how significant that impact was on him. Is that fair? Until sitting in your office.
I had very little context, even when he was in my office, over what that was. All I knew is that a friend had left recently and moved, and that was hard.
You indicated on your direct testimony with Mr. Keese that Mr. Crumbley mentioned you have people you can talk to, we talk, and then mentioned something. Your testimony was that said that calling a parent in is a high level of concern.
Yes,
And that could be a concern for appropriate behavior.
it could be, yes.
It could be a concern for the student's well-being.
It could be.
It could be a concern that the student needs immediate care or help.
Yes,
It could be for any number of reasons. A high level of concern is dependent on the situation. Is that fair?
yes, I would agree.
You're concerned with going to Mr. Crumbley's son's class on November 30th of 2021 is you specifically mentioned that you went because it doesn't basically raise concern or red flags if a counselor goes down to get a student out of class.
Yes, that is true. And I had very little information at that point as to what was going on. So I wanted to make sure to do it. And I knew that the dean wanted me involved in a conversation. So I knew that student support was at least a potential plan at that point.
When you were discussing, you said that you told Mr. Crumbley's son while you were meeting with him before his parents got there that you wanted his parents to get him help. Do you remember discussing that with the prosecution?
I do.
At that time, Mr. Crumbley's son didn't say, "Thank goodness, I've been begging my parents for help and they haven't given it to me."
I'm not sure many students would.
He didn't say, "I'm glad you're going to ask them because I've asked them and they didn't listen."
He did not say that, no.
He didn't say, I really need this and I'm really glad that you're doing this for me."
He did not.
He didn't say any of that.
No, which also would not be, it's not uncommon for students to not have a big response to something like that.
If he had said any of those things, obviously your reaction would be different when Mr. Crumbley and his wife got to the school.
It would be different information that I did not have, yes.
And when Mr. Crumbley and his wife were at the school, they also didn't say anything about, or Mr. Crumbley didn't say anything specifically about, wow, son, you really did need some help. You've been asking me for it, right?
No.
The discussion was simply looking at the math assignment, the modified math assignment, and then Mr. Crumbley expressing to his son, you know you have people to talk to, right?
That was a piece of it over the 10 minutes, yes.
That they've talked. Mr. Crumbley and his son have spoken.
He did say that they talked.
When discussing the impact of Mr. Crumbley's son's friend leaving, you don't know that Mr. Crumbley's son had ever expressed how significant that impact was on him. Is that fair? Until sitting in your office.
I had very little context, even when he was in my office, over what that was. All I knew was that a friend had left recently, had moved, and that was hard.
You indicated on your direct testimony with Mr. Keese that Mr. Crumbley mentioned you have people you can talk to, we talk, and then mentioned something, your testimony was that his son mentioned something about a journal, or I'm sorry, that Mr. Crumbley mentioned something about a journal.
Mr. Crumbley's statement to my recollection was, you have your counselor, you have your journal, we talk.
Mr. Crumbley didn't say your journal, you know, the one. He didn't say the one that you always keep with you.
No.
He didn't say a color.
No.
He didn't describe it at all.
No.
So to your knowledge, based on that conversation, you can't say that Mr. Crumbley's son knew what his son's journal would look like if he had a journal, based on that conversation.
No, I had no knowledge beyond that there was an existence of some sort of journal.
One moment, Your Honor.
Sure.
Mr. Hopkins, You made decisions on November 30th of 2021 based on your education, your training, and your experience, correct?
That was a piece of it.
Also based on the information that you had in front of you,
That was a majority of it.
which included 4 emails from teachers in approximately 2 months regarding Mr. Crumbley's son,
That was a part of it, yes.
concerns that those teachers had raised,
Yes, that was a part of it.
much of which you did not share with Mr. Crumbley prior to that November 30th meeting. Is that fair?
Correct. It was shared during the meeting.
Based on all of these things, you did not believe that Mr. Crumbley's son was an immediate danger to himself,
I did not believe that, no.
nor did you believe that he was a danger to anyone else.
Based on the information I had, no.
I have no further questions.
Read that.
Thank you. Mr. Hopkins, it appears that information and context would be important to you in these kinds of meetings.
Yes, it would.
Okay. Now, did James Crumbley tell you that November 30th wasn't the first time that his son asked for help?
No.
Did James Crumbley tell you that his son asked for help in April of 2021?
No.
Did James Crumbley tell you that despite that, never once was an appointment with a medical health provider set up?
No.
Did James Crumbley ever tell you that as early as June of 2021, his son had obtained his own firearm?
No.
Did James Crumbley tell you that his son had been begging for a 9mm firearm?
No.
Did James Crumbley tell you that his son actually sent him a screenshot of a 9mm for sale a few weeks before the meeting?
No.
Did James Crumbley tell you that his son actually obtained a 9mm just 4 days before this meeting?
No.
Did James Crumbley tell you that the 9mm he obtained looked identical to the 9mm that he drew right here on this picture?
No.
Did James Crumbley tell you that he worked for DoorDash, he hadn't begun work that day, and he could have taken the son?
No.
Did he tell you that when his son was talking about his friend leaving, it was actually his only friend?
No.
So you took what you learned from the defendant's son, you described those losses he felt as
Hey,
significant,
come back.
I did.
and that's without knowing all of that information.
Yes.
You mentioned that you would hope that a decision about a student would be made by a team.
I did.
Who's on the team?
The student, the parents, and any caring adult at the school.
And did either James or Jennifer Crumbley share any information with you?
I did not.
Had they what would you have done?
Objection, Your Honor, speculation.
She asked the same question, I promise.
Did you ask that question?
She asked, what would you have done? Talking about calling CPS and such.
I know, actually, that was related to if they had,
She asked if they had not obtained treatment for their son
yes,
by the following day or within 48 hours.
if they had refused, actually, if they had refused to obtain mental health treatment, what would he have done? Not,
I'll rephrase, Judge, that's fine. Mr. Hopkins, you testified earlier that your plan was to call Child Protective Services within 48 hours.
Yes,
And that's based upon just the information that you learned from the defendant's son.
it is.
Would this meeting have ended differently had you known all the other information that we just went through?
objection, Your Honor, speculation.
I think it does call for speculation.
I believe he can offer a definitive answer here, Judge.
A definitive answer about what would have happened if they had not contacted a therapist. Is that what you mean?
No, Your Honor, he's asking about a definitive answer for what Mr. Hopkins would have done if there had been additional information. And Your Honor, can we approach, can we approach, please?
Okay, can you turn off the mic?
Whew. I'll tell you what, she's given them a run for their money, a lot more so than the other one did. And she's actually stumped him a couple of times, which I really like. Okay. Honestly, I'm not playing Switzerland. I am playing Switzerland. Well, used to be Switzerland. But I don't like this DA guy. I don't like him. I think he's cocky and arrogant, and I just don't like him. But at the same time, it's kind of funny because he knew how to push the other one's buttons. Shannon, I don't think he's got this chick's buttons. I think she's got his. I think she's just smarter than he is. So I don't know. This is going to be interesting. So put it in the chat, you guys. I mean, by the time we watch
Thank
this,
you, Mr. Hopkins.
are we
You
looking
were asked
guilty, not
on
guilty,
cross-examination that
or hung jury?
you didn't ask the shooter on November 30th if he had access to a gun. Do you remember that?
I do.
And your response was what?
I did not.
Okay, and did you have reason to ask him about that?
At that time, I didn't feel I did.
And you were asked about the shooter's recitation of what happened at the shooting range with his mother.
Are you stating I asked that?
No, you were asked that.
Oh, by cross.
Okay, so you learned on November the 29th and November the 30th that the defendant's son went to a shooting range with his mother that prior weekend.
I did.
Did James Crumbley tell you that the shooter actually shot his new gun?
No.
Thank you. I have nothing further.
You can step down.
All right, let's go on to the next one.
This
This is going on a lot longer than I thought it would. I'm going to be honest.
All right.
Hang on, let me find the dot that I had situated here. Oh, shoot. Hang on. Okay, so this is that one detective that went into the house and took all the photos.
And exhibit 295.
Yeah, same thing, just kind of the landing, just an outer picture of that. Once you go there, to the right is that door that leads you to the backyard, and if you went down and made a left,
And exhibit 295.
myself and Detective McPherson, and they were given to Detective Rogowski.
Nothing further. Thank you, Deb.
Cross.
Yes, Your Honor. One moment. Good morning.
Morning.
I'm going to take you back just to the beginning of your direct. In exhibit, I don't know if this is, oh, I got it. In exhibit 205. There we go. Exhibit 205 is the map that was drawn, excuse me, the map that was drawn of the Crumbley residence.
Correct.
And this is of the interior of the residence. You agree?
Correct.
Now, you also looked at the exterior of the residence because you went in the shed in the backyard, correct?
Correct.
And if you recall, it's a fairly deep lot.
Yeah, it's got a large backyard.
Okay, so what you see from the street, the house is closer to the street than closer to the back of the lot. Would that be fair?
That's fair.
Okay. So it's not like a small backyard. It's fairly deep, which means that there's a lot of space between the back of the backyard and the front of the house. Is that fair?
Yeah, so there was a fairly large fenced-in backyard. I don't know exactly how big, but yeah, I mean, it was large. There's a lot of space.
Thank you. When you first went into the home, you did the initial sweep to make sure that there were no other people in the house, correct?
Correct.
And that's common. That's common practice for executing a search warrant or securing a premises.
Correct.
And in the home, you noticed that there was an open Sig Sauer box with an empty box of 9mm ammunition in the master bedroom on the bed.
Yeah, correct. That was one of the first things I saw when I walked in the bedroom.
And the master bedroom you identified as James Crumbley's bedroom.
Correct.
And we'll look at, if you need to, we can look at the photo, but do you recall that box of ammunition was Patriot Defense 9mm ammunition?
That sounds correct.
Okay. We looked at exhibit 300, which was the first video from approximately 2:50 p.m. in the back of the patrol car. Do you recall reviewing that video?
I do.
You would agree that as James's wife is being placed in the patrol car with handcuffs, James is obviously distraught. He's asking questions like, why are you in handcuffs? Why is she in handcuffs?
I'm
Correct?
going to object to the form of the question of obviously distraught. I don't think he's able to give that sort of testimony.
Were you able to observe his demeanor?
Yeah, I mean, he was obviously wondering what was going on, asking questions. Yeah.
He was upset.
I mean, I don't really know him. I mean, he was asking a lot of questions. Yeah.
Trying to figure out what was going on.
Correct.
You watched the video more, and you reviewed that video prior to coming in today, correct?
The in-car video?
Yes, the exhibit 300.
I've seen the video before.
Okay. And the reason I'm asking that is because you wouldn't have seen this exchange unless you reviewed the video, which is why I'm asking. But there was a point in the video where James leans over to his wife and tells her he loves her. Do you remember seeing that?
Correct.
And if you recall, he comments, just in case anything happens, I love you, and he gives her a kiss.
Correct.
So you would agree that James had some concern that something bad might happen?
I believe at some point he states somewhere along the lines of that, so yeah, correct.
You said after that Exhibit 300 video, James was transported to the substation to be interviewed by law enforcement, correct?
Yeah, like I said, there was a lot going on. Initially, we were instructed to talk to him. Then after speaking with Sergeant Bryant, it was determined that he had already spoke with him, so he was brought back at that point.
Right. So either on the way or once you got to the substation, you learned that James had already spoken to Sergeant Bryant prior to you all arriving at his residence. And so you took him back to the residence.
Correct.
Exhibit 204 is at approximately 3:42 p.m. Oh, let me go back to Exhibit 300. There was a point in that video where James makes the comment to his wife about not talking without a lawyer. Do you remember seeing that?
Correct.
Okay. Now, you know that if somebody is being suspected of a crime, you've been a detective for a while. Is that fair?
Fair.
Okay. You know that if somebody's being suspected of a crime or suspected of doing something wrong, they have the right to counsel.
Correct.
Asking for a lawyer or wanting a lawyer doesn't mean anything other than I want a lawyer with me. Is that fair?
Fair.
Okay. Exhibit 204 is after that initial video with James and his wife in the back of the patrol car. You agree with that?
Is that the video where I was speaking with him?
Yes, at 3:42 p.m.
Correct.
At that point, you're waiting for the search warrant to be signed by the court.
I am.
And you talk to James and you have a couple of exchanges, and then you ask him if he's willing to tell you where the firearms are, correct?
Yep, I kind of explained to him that he could sit in the car, he could go sit in his car. He didn't have to say where he was when he was talking to me, and then after that, yeah, we had the exchange about where the weapons were in the house.
And he used the word absolutely, if he would be willing to tell you where those firearms were, correct?
Yeah, he was cooperative when I was speaking with him.
He told you that they were in a gun case?
Correct.
That was locked?
Correct.
That it was in the back of the house, the room in the back of the house?
Correct.
In the TV stand?
Correct.
He told you that it was the right cabinet door?
Correct.
That the gun safe contained a .22 Derringer and a .22 Talpac?
Correct.
And then he gave you the combination, but we would agree that he actually added a digit to the combination.
Yeah, he told me there was 4 zeros, and there was 3 zeros to get inside the safe.
And it's obvious by looking at the gun case, or I'm sorry, the gun safe, that there's only 3 numbers on it, right?
Yeah, the dial has 3 numbers on it.
So you couldn't have added a 4th number.
Correct.
You would agree that there was a lot going on at that moment?
There's a lot going on at that moment.
For both you and also Mr. Crumbley.
Correct.
Through your involvement in this case, you're not aware that anyone else in the house had knowledge of that combination. Is that fair? You don't know if anyone else had it.
Yeah, I don't know.
And James also made comments to you about being completely open and wants you to do whatever you have to do. Is that correct?
Correct.
And you said he was cooperative with you.
When I spoke with him, he was, yes.
In fact, he even commented and told you about that rifle-looking BB gun that was in his son's room and wanted to assure you that it wasn't what it looked like.
Yep, he told me before going in the house that there was going to be that rifle that was a BB gun sitting in the shooter's bedroom, correct?
There was some exchange, and it sounded like James was going to leave the premises with his wife, but said that he needed his phone back. At that point, you all had taken his phone, if you recall.
Yeah, so I at that point did not have his phones, and I honestly don't know who had the phones at that point, so I don't recall.
You knew at that point that he didn't have his phone, based on his statement to you.
Yeah, I knew that at that point his phone was not on this person.
And we'll get back to that in a minute, because you did talk about that a little bit more. In Exhibit 215, which is a photo of, I believe I think we call it the north bedroom. I'm sorry, the middle bedroom. There, you commented that there's a knife on the bed. It was a butter knife, correct?
Yeah, correct.
Exhibit 244, which is also in the middle bedroom, is a photo of the open desk drawer. And there's a notebook, colored pencils, and miscellaneous items.
Correct.
You didn't open that notebook to see what was in it, correct?
I personally did not.
You don't know if Mr. Crumbley knew what was in that notebook, is that correct?
I wouldn't be able to say.
You would have no way of knowing, is that right?
I don't know, yeah.
Exhibit 245 is a picture of the bed. I'm sorry, it's a picture of another notebook in the desk. It's a green notebook, correct?
Correct.
Same questions. You didn't open that notebook.
I personally did not open that notebook.
You don't know what's in it.
I did not know.
You don't know, you have no knowledge whether Mr. Crumbley knew.
I wouldn't be able to say one way or another.
246, it's a photo of an empty bottle of Canada House whiskey next to the bed.
Correct.
You don't know how that bottle got there.
That was there when we came in the house.
Right. You have no knowledge of how it got there, who had it, who put it there. You have no idea. You just know that it was there.
Correct.
Exhibit 220 is a picture, I believe, also of this is the second bedroom. So I believe this is the north bedroom. Exhibit 220 is a picture of the bed.
Mhm.
And that would be, is that a yes?
Yes.
Okay. And that would be Mr. Crumbley's son's second bedroom. That's what it's been referred to, correct?
Correct.
Exhibit 240, I believe it's 247, can't read my own writing, is a notebook that's open on the bed. You recall seeing that photo?
Correct.
And inside that notebook, there are photos of gun drawings.
Correct.
That notebook from 247, if you recall, is the same notebook from 220. If you'd like to see the photos, I can.
Yeah, so in all honesty, I didn't have a ton to do with those notebooks. I recall seeing those in there. I don't know where that one came from.
Okay.
Yeah.
Okay. If you recall from Exhibit 220, the notebook is closed or not displayed open, and it's under some items on the bed, if you recall.
Correct.
So you didn't open that notebook, you didn't go through that notebook, you have no knowledge of what was in that notebook other than what's in the photo.
Yeah, I didn't personally at that time go through the notebook.
And again, through your involvement in this case, you have no knowledge whether Mr. Crumbley was aware of what was in any of those notebooks.
Yeah, I don't know.
In Exhibit 235 that is the gun safe, or I'm sorry, that is after you've removed the gun safe from the TV stand in the cupboard.
Yeah, I saw a lot of, I don't know what picture you're referring to, I'm sorry. I saw a
Yes,
lot of
let me
pictures
see if
there.
I can find it.
Are you referring to the one that was recovered in the kitchen?
No, this is the actual gun safe that was recovered in the, actually, you know what? Let me do it this way. I
Yeah,
have a
let me see.
hard copy of it. It'll be easier for me to get to. May I approach, Your Honor?
Sure.
Thank you. I might also ask about 236, so I'm gonna bring them both to you. You're welcome.
Yeah, so 235 is the picture of the master bedroom. It's the dresser where the gun safe was recovered from. At this point, the gun safe had been removed. And all of this that you're seeing, the magazines, the gun holster, and the bullets in the background were below that safe that we took out from there.
And those magazines, the two magazines, those were empty.
They were.
When you say below, they're underneath or the lower shelf?
Yep, no, so the gun safe was recovered on top of all that. So at this point, this picture is showing once the gun safe had been taken out, and that's below that.
And 236, if you could look at 236, that's a picture of the magazines and the ammunition that was removed from that cupboard, correct?
Yeah, so at this point, everything was taken out and photographed on top of that TV stand there. It's the two magazines, the bullets inside of the bag, even the box that the ammunition was in.
And I just wanted to confirm that those were the same magazines that were inside the cabinet.
Yeah, correct.
So those were empty.
They were empty.
May I approach, Your Honor?
Sure.
Thank you. Thank you, Detective. When you were discussing Exhibit 256 with the prosecution specifically asked you if there were no other locking mechanisms found in the home. Do you remember that question?
I do.
You arrived at the home after, if you recall, after 2 p.m. on November 30th of 2021.
Yeah, it was short. It was around the time of the first video we saw. I don't know the exact time, but around the first time the video we saw. The first video.
So it's fair to say you have no knowledge of what was in that house prior to your arrival at approximately 2:50 on November 30th of 2021.
Yeah, I can only speak to what I saw when I went inside the residence. I don't know what was there prior.
You can't say whether or not there were any additional locking mechanisms in the house that morning. Is that fair? You have no knowledge of that.
Again, yeah, I can only speak to what I saw and what I found. I don't know what was there prior.
Exhibit 260. You went through some photos of video games. 257 was some video game, the gaming system. 258 were video games. 259 was more video games. 260, if you recall, and I can hand you the exhibit if you'd like, was Call of Duty and a game that you weren't familiar with, Attack on Titan.
Correct.
Did you need to look at that exhibit?
No,
Okay. Call of Duty, based on your testimony, it sounded like you were a little familiar with Call of Duty.
Yeah, I don't play video games, but obviously I'm familiar just with seeing commercials, and I'm aware of what Call of Duty is.
Okay. And on the front of on the cover, it has WW2 for World War II. Is that correct?
Correct.
Call of Duty, you would agree, is a type of military video game.
Correct.
It's what would be described as a first-person shooter video game.
Correct.
And if you know, and if you don't, please tell me you don't know. A person playing Call of Duty is a person holding a firearm in the video game and engaging in combat.
Honestly, I'm probably the last person to test about video games. I don't play video games.
But to your knowledge, it is a military video game, which is a first-person shooter military video game.
Correct.
At the end of your direct testimony, you discussed that the prosecutor asked you if James Crumbley's phone was seized, correct?
Correct.
Now, there are a couple of different ways that law enforcement can obtain somebody's cell phone. Would you agree with that?
Correct.
You can get a search warrant and take it from them, right?
Correct.
They can hand it to you, right?
Correct.
You can say something like, you can give it to me or we'll get a search warrant, and they can hand it to you, right?
Correct.
In this case, if you recall, at some point, Mr. Crumbley did not have his cell phone because he said, I need to get my cell phone back, correct? While in the back of a patrol car.
Correct.
At some point, he got his cell phone back.
I didn't have any exchange with him after that about the cell phones. Honestly, I don't know if he got it back.
Now, do you recall that, if you're not aware, just let me know. Are you aware that there was some conversation about James and his wife giving their phones to law enforcement and then having to obtain some sort of another phone to be able to communicate with their family?
Yeah, so at some point, Lieutenant Marsban showed up at 112 East Street, and he had a conversation with James and Jennifer about the cell phones. I don't know the specific language of the search warrant, but the phones were given to Marsban, who then he provided to me and my partner, and we took them back to the high school.
And if you recall, there was also some discussion about how James and Jennifer could obtain kind of a temporary phone so that they would be able to communicate with people while law enforcement had their phones, if you recall.
Yeah, that was a conversation I had with Lieutenant Marsban. I don't remember the specifics of the conversation, but I know they did have a conversation about the phones.
Okay, so you just know that there was a conversation that occurred where it was discussed with James and Jennifer how to obtain like a temporary phone, like a track phone or something like that.
I don't know the specifics of the conversation. I just know that they did have a conversation about it.
Okay, thank you. No further questions, Your Honor.
Just quickly, thank you. Detective, did James ever once tell you that the 6-hour 9mm used to commit the Oxford High School shooting was ever locked up?
He did not.
Okay. Nothing further.
I was not, no.
Were you given details by either James or Jennifer Crumbley about
Mr. Crumbley's son?
There was not. Yes.
Behavioral and academic intervention
Yes.
and issues with attendance.
Yes.
You had not had contact with Mr. Crumbley's son until November 30th of 2021.
That's correct.
So as far as you know, once you became employed by Oxford High School, there were no behavioral issues with Mr. Crumbley's son?
There was not.
No academic issues? No attendance issues?
No.
You learned on November 29th of 2021 that Mr. Crumbley's son was looking at bullets on his phone in class.
Yes, that is correct.
But once you had been made aware of it, or once you learned of it, you learned that that had already been handled by Mr. Hopkins and Ms. Fine. Is that correct?
That is correct.
So you didn't do anything with anything that day?
No.
Okay.
I didn't need to do anything further based on the fact that Ms. Fine and Mr. Hopkins did everything that I would have done in that.
So you didn't see any need for additional discipline or any additional intervention or anything like that, correct?
That's correct.
On November 30th of 2021, you were advised by one of Mr. Crumbley's son's teachers that he was writing inappropriate statements on his home on a math assignment.
Yes.
You were quickly shown a picture of the assignment on a cell phone, if you recall.
Yes.
You didn't look at it very well, correct?
No.
You saw that there were drawings,
Yes.
but you didn't see necessarily what all the drawings were. Is that fair?
That's fair. Yes.
You did see the words blood everywhere,
Yes.
but you didn't see much beyond that.
That's correct.
To you, the words on the page were more concerning than the drawings themselves, right?
I would agree with that. Yes.
And that's because sometimes kids in high school draw violent things.
Absolutely. Yes.
That's not abnormal.
That's not abnormal.
You felt that what was on the paper was not appropriate for school. Is that correct?
Yep. I would agree with that.
But that it wasn't in and of itself concerning.
Yes.
And that you didn't see it as a threat to anybody.
That is correct.
You didn't see a correlation of violence with the drawings on the paper?
I did not know.
Again, Mr. Crumbley's son had no prior disciplinary history,
He did not know.
no prior bad behavior.
He did not.
He was a pretty average student.
He was. Yes.
He'd only missed one class that year.
I can't speak to that.
You said you dealt with attendance, so that's why I was asking.
Sure.
So you're not aware of his attendance
I'm not
history?
aware of specifically his attendance.
Okay. He had none of the typical early indicators that there would be an issue of concern other than these isolated incidents from November 29th and November 30th that you were aware of.
Judge, I'm just going to object to the form of the question. Typical indicators. This witness can testify regarding code of conduct and discipline. That's it.
Yeah, unless he was able to testify about what a typical indicator would be, or by his experience.
And I can ask him that, Your Honor. Based on your experience dealing and your education and training with at-risk students and for your position as the Dean of Students, there are what you would consider early indicators of potentially concerning or threatening behavior. Is that fair?
I would say that's a fair statement.
Some of those include prior disciplinary history,
Yes.
prior bad behavior by the student,
Yes.
issues with grades,
Yes.
issues with attendance.
Yes.
Okay. So knowing all of that, none of those, what I'm calling early indicators, were present other than the two incidents that you were aware of on November 29th and November 30th of 2021.
As far as I was aware, yes.
You sat in on the conversation between Mr. Hopkins and Mr. Crumbley's son on November 30th of 2021.
Yes, I did.
And that was before his Mr. Crumbley and his wife got to the school.
That's correct.
Based on the information that you had at that time, you did not believe that Mr. Crumbley's son posed a threat to anyone.
That's a fair statement, yes.
You were even less concerned after you confirmed some of the information that you'd learned from Mr. Crumbley's son with Mr. Crumbley's wife.
Yes, after she had confirmed all the information he shared with us, my concern from a discipline standpoint was pretty much lowered all the way to none at that point.
Okay. And you said all of the information that he had shared with you. And we've heard some about that, but I just want to confirm. That was about the losses that he'd experienced in 2021, correct? The loss of a family member?
Yes.
The loss of his family dog?
Yes.
A friend had moved away?
Yes.
He'd struggled with COVID?
He did, yes.
He had a hard time with virtual school?
Yes.
Those were the things that you confirmed with his family, with his parents?
Along with his desire for graphic design and video games, and that they thought he should focus more on academics rather than that, which is what he had shared with us during the meeting.
Okay. When you say he had shared with us, are you referencing a discussion or an argument he had with his parents the night before that related to video game design and grades, or was this something separate?
Both. No, he had shared that he was interested in that and that he didn't feel his parents supported that, and that led to an argument the night before, but he didn't provide any context to that at all, and they had confirmed that, but they also didn't provide any context to that either.
So there was a confirmation that the student and Mr. Crumbley's son and Mr. Crumbley and his wife had an argument with their son the night before. It sounded to you like it may have related to video game design and grades, but you didn't have any context beyond what you believed it to be about.
That's correct, yes.
Now, obviously, during these meetings, you expect for a student's parents to give you information about things that they are concerned about, correct?
Typically in these meetings, parents come to them and they provide additional context, stuff they're seeing at home, a history of, if, you know, especially in a mental health situation, a history of any kind of counseling, and any issues they've had at other schools or whatever, but they usually provide additional information.
So you said specifically things that they see at home, things that they're concerned about. Obviously, in order for a parent to see something at home or be concerned about it, they have to be aware of it. Is that fair?
Speculation too, Judge.
I don't know how a parent could be concerned if they're not aware of something.
The Dean of Students can't testify as to how a parent would be aware of something at home in a meeting, not even specific to what we're talking about here.
Actually, my question was different, Your Honor. My question was, he would expect that, or it's his belief that if a parent is concerned about something, then they're aware of it.
But that's a lack of personal knowledge. Mr. Ejak was the Dean of Students in Oxford High School in November of 2021, in charge of discipline and code conduct issues, Judge. Mr. Hopkins was a counselor. He's already testified.
Okay. I think are you asking him if the parents aren't aware of something, they're not aware of it?
Kind of, Your Honor. Obviously, and I can ask my question differently and see if it makes it a little more simple.
Right.
Mr. Ejak, based on your experience, your education and your training, and just your knowledge in general of you're a human being, if someone doesn't have knowledge of something, they can't talk about it. Is that fair? Does that make sense to you?
I would say that's a fair statement.
So we can't talk about things we don't know about. Would you agree with that?
Yes.
Obviously, James Crumbley can't tell you about things he may not be aware of. I'm sorry.
Yes.
You weren't concerned on November 30th of 2021 by Mr. Crumbley's son looking at bullets or drawing guns. Is that fair?
I think there was a level of concern there, which is why we called the parents in for the meeting.
And if you recall, the level of concern was regarding the appropriateness of behavior in school.
Yes.
You didn't find his interest in guns or bullets concerning, especially in the Oxford community, if you remember.
Yes, that's correct.
You've had students draw guns on papers in the past.
Yes, that's correct.
In fact, students in Oxford, not all of them, I'm not saying all students in Oxford, but there are students in Oxford who have guns in their home.
Yes.
You know that there are students in Oxford who handle firearms.
That's a fair judge.
Okay. You would agree that it's not unusual?
No, it's not unusual.
In that community?
In that community, yes.
I'm not asking you to speak about any other community, but in that community, it's not unusual for students to handle guns.
That's correct.
When faced with a situation where a student has drawn guns on papers, you typically use your education and training to assess the risk.
As far as a discipline standpoint?
Discipline or otherwise, whatever your role is in that assessment.
Yeah, so my role would be to look for any violation of our code of conduct. And so that by itself, the drawings on the worksheet don't violate the code of conduct.
And a violation of the code of conduct would also encompass any sort of a threat to other people. Is that fair?
That's a fair statement.
So as part of your assessment, you're also determining whether or not there's a threat.
I'm determining whether or not I need to alert somebody to something that could potentially be a threat.
And in this situation, you didn't make that alert. Is that fair?
That is correct. There wasn't any information that led me to believe there would be a reason to alert somebody else.
And part of your assessment is, again, looking at those typical early indicators that we talked about, whether there's a history of violence, correct?
That's correct.
A history of discipline.
That is correct.
Bullying behavior.
That is correct.
You look to see if there's a threat.
That is correct.
If those things are not apparent, if those things are not present, then it's just a student who drew a gun. Is that accurate?
That's pretty accurate, yes.
You were part of the meeting after Mr. Crumbley and his wife arrived. And let me go back a little bit. So you sat in on the meeting between Mr. Hopkins and Mr. Crumbley's son, correct?
That is correct.
If you know, that meeting occurred, lasted approximately 90 minutes?
I don't remember.
Okay. You left that meeting at some point.
Yes.
Then you came back once Mr. Crumbley and his wife arrived.
So I left the meeting to retrieve his belongings, the students' belongings, and returned back to the office and then left again until the parents arrived.
Okay. You entered Mr. Hopkins' office after Mr. Crumbley and his wife arrived in Mr. Hopkins' office.
That's correct.
You saw that Mr. Crumbley was seated next to his son,
Yes.
which was
that's correct.
directly across the desk from Mr. Hopkins.
Yes,
It was your perception that Mr. Crumbley was showing care for his son,
yes,
that he reassured his son that he can always talk to him.
yes,
You mentioned something on direct with the prosecution about a journal,
yes,
and you seem to recall that Mr. Crumbley made reference to a journal.
he did, yes.
You don't recall Mr. Crumbley saying the one that you always keep with you?
I don't recall that, no.
He didn't say anything like the one that's in your backpack,
I don't recall.
specific colors,
I don't remember.
how long he's had it.
I don't remember.
There were no specifics about anything about a potential journal.
Not that I can recall.
So to your knowledge, you don't know if there was one journal or 15 journals. Is that fair?
I can't speak to that, no.
Right. You have no knowledge of that. Is that fair?
Yes,
After meeting with Mr. Crumbley and his wife, you felt that they were receptive of getting their son help, as was suggested by Mr. Hopkins.
yes,
You and Sean insist that it be done that day. Now, I'm going to clarify because I know that Mr. Hopkins indicated that he preferred that it would be done that day, but neither of you said you need to take him today and you need to go get him help right now. And if you don't, there's going to be a problem.
what Mr. Hopkins had stated was that they needed to find him some counseling as soon as possible that day, if possible.
And that he
And
was
that he
going,
would be following up within 48 hours to ensure there was something secured for the student.
and that was going to be my next question, that he was going to follow up in a couple of days, 48 hours.
Yes,
And in fact, you didn't feel in that meeting that Mr. Crumbley's son was in need of immediate care based on your education and training and perception and the knowledge that you had in that meeting.
I can't speak to that.
In no way did you feel that Mr. Crumbley was being neglectful of his son.
No, I did not.
You felt that Mr. Crumbley showed the appropriate level of emotion with his son in that meeting.
Objection is, he can't speculate as the appropriate level of emotion. He's the dean of students regarding code of conduct. November of 21. Speculation.
Is there anything odd about his interaction with his son?
I wouldn't say there was anything odd.
You also didn't find it strange that Mr. Crumbley and his wife did not take their son home that day because there was no reason for him to go home that day. Is that correct?
As far as the discipline goes, no.
During the meeting, you said that you retrieved Mr. Crumbley's son's backpack from his classroom and brought it back to Mr. Hopkins' office.
That's correct.
You indicated this backpack was heavy.
Yes, such as every other student in the school.
And let me clarify, that day, you didn't say that today. That day, November 30th of 2021, you commented to a teacher that the backpack was heavy.
Yes, I made a joke at how easily she picked it up. And then when she handed it off to me, my arm dropped down. So it was more of a joke at how strong she was compared to myself.
And if you recall, at the time, the students weren't using their lockers.
They were not using them.
So it was fairly common for a student's backpack to be heavy.
That's correct.
You didn't look in the backpack?
I did not know.
You didn't, and I think you said you didn't have reason to look in the
I didn't
backpack.
have reasonable suspicion.
You didn't ask Mr. Crumbley's son to look at his backpack?
I did not know.
You did not ask Mr. Crumbley or his wife to look in the backpack?
I did not know.
You didn't look yourself or ask anyone else to look because you didn't feel that there was a reason to look in the backpack. Is that fair?
There was nothing from our conversation or from anything that we had heard so far that would indicate it was enough to reach to that level, correct?
You've had numerous discussions about this case since November 30th of 2021.
Yes.
You've talked with various attorneys.
Sure. Yeah.
And I'm not asking you about what your communications were with your own attorneys. I'm not asking about that. I'm just asking if you've met with attorneys.
I've met with many different attorneys.
You've met with the prosecutor's office?
Yes.
On more than one occasion?
Yes.
And some of those meetings with the prosecutor's office were to prepare for testimony?
Yes.
Some were to get more information about what occurred on November 30th of 2021.
One was yes.
You learned through some of those meetings that there was no indication that there was a handgun in Mr. Crumbley's son's backpack.
Can you restate that?
Sure. You learned through some of the meetings with the prosecutor's office that there was no indication that there was a handgun in Mr. Crumbley's son's backpack while he was in Mr. Hopkins' office.
Object to the form of the question.
Yes. I will be more clear. Do you recall testifying in September
What
of...
are you referring to, counsel?
There was testimony in September 14th of 2022 that relates to this. If you'd like, we can approach it.
I think we should.
Whew. This testimony is going on a lot longer than I thought it would, you guys. I thought I was going to do a quick video this morning. I've been sitting here for over 8 hours editing this damn thing down. Why am I so anal about this stuff? I don't know. So what do you think? What are we thinking? Guilty? Hung jury? Not guilty? Hopefully I'll be able to get this out before the verdict comes out. And we can watch this on a verdict watch. I don't know. I do think she is putting up a much better fight for him than Jennifer ever had. And she's way more organized, and she doesn't let the prosecution get to her, and she's quick, and she gets it done.
Thank you,
She's
Your
like,
Honor.
bam, 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 let's go.
As you know, approximately 2 hours after the meeting, after this meeting with Mr. Hopkins, yourself, and Mr. Crumbley and his wife, Mr. Crumbley's son began the shooting.
Yes,
You saw the footage of the shooting.
I did, yes.
You were not aware that Mr. Crumbley's son was the shooter
Initially.
at the time.
When I saw all of the footage?
No, let me go back. So at some point early on the day of the shooting, you saw footage of the shooting.
Yes.
And that was while you were in the office of the school.
On the phone with the 911 operator?
Yes. And at that point, the thought didn't cross your mind that the shooter may be Mr. Crumbley's son.
That's a fair statement, yes.
In fact, you didn't know that it was Mr. Crumbley's son until you were told that it was him after the shooting.
I believe as the video footage continued to play and we were still on the phone, it wasn't confirmed, but I had a pretty good idea that that's who it was.
Okay. Even looking back, after you know what Mr. Crumbley's son did 2 hours after that meeting, his behaviors did not show a pattern of what he was planning to do 2 hours later.
Based on the information I knew, no.
It's fair to say that you had years of experience with at-risk students.
Yes, that's correct.
Years of experience with behavioral, academic, attendance, issues of that nature.
Yes,
You have education and training about concerning things to look for in students.
yes,
You knew that Mr. Crumbley's son was looking at bullets on his phone on November 29th of 2021.
yes,
You knew that he had drawn a gun and some concerning words on his math assignment.
yeah, that's correct.
You knew that he was at the shooting range with his mom the weekend before.
Yes, that's correct.
You confirmed that during the meeting with his parents, correct?
Yes,
You knew that he had experienced significant losses in the months before November 30th of 2021.
yes,
You knew that Mr. Hopkins was recommending that his parents have him talk to a therapist that day if possible.
that's correct.
You knew that his backpack was heavy and commented about the weight of it to a teacher.
That's correct.
You knew that firearms were not uncommon in homes in Oxford.
That's correct.
You knew that students at the high school handled firearms and that it wasn't uncommon.
We're asked and answered numbers.
You knew,
Yeah, he answered that.
you knew that the shooter was going to stay in school that day,
At the end of the,
partly because he wanted to,
yes,
and partly because his parents had to go to work.
that's what I was told, yes.
And with all of this, all of the knowledge that you had on November 30th of 2021 at approximately 10:52 a.m., you did not feel that he was a threat to anyone, and you didn't feel that you had reasonable suspicion to look in his backpack.
No, because you have to remember, I knew very little of what we all know today. So when we're looking at the big picture today, I knew a fraction of what we all know now.
And we talked about this a little bit with Mr. Hopkins as well. We all know what happened at 12:51 on November 30th of 2021. But the information that you had at 10:52 a.m. or approximately 10:50 a.m. when that meeting ended, is the information that you were going on.
Yes, and that does not rise to the level of suspension or other discipline. especially when you're considering mental health.
And it doesn't,
That supersedes any type of minor discipline or behavior violation.
so, and Mr. Hopkins talked about this a little bit. Looking in hindsight, there was more information.
Yes, we now know there's a lot more information.
You might look at things differently looking in hindsight.
I would 100% look at things differently.
But the information that you had on that day, at that time, is what led you to make the decisions that you made and feel the way that you felt about the situation that you were presented with in Mr. Hopkins' office.
That's a fair statement, yes.
No further questions, John.
Thank you. Briefly. Mr. Ejak, let's talk about the information not shared with you at 10:52 a.m. on November 30th, 2021. Okay, so you formed your belief that you did not have the requisite level of suspicion to search the shooter's backpack based upon what you were told. Is that right?
That is correct.
Okay. Did James Crumbley tell you that he had bought his son a 6-hour 9mm firearm 4 days before that meeting?
He did not.
Okay. Did anybody, either his son or his wife, tell you that?
No.
Did his son tell you that, or did James Crumbley tell you that his son had been begging for a 9mm handgun?
No.
Did James Crumbley tell you that he actually got him a different firearm in June of 2021?
No.
Did James Crumbley tell you that the details and severity of his son's friend being taken from him at the beginning of the month?
No.
Now, you indicated that as far as a discipline standpoint, your belief was that the mental health concerns would override.
Yes.
Tell me about that.
So when you have a student who is being seen for mental health, and there also are some minor violations, this being a second day of insubordination, essentially, the mental health concern is what takes precedence because you want to build that relationship with the student and let them know that it's a safe space, and you don't want to follow it up with some kind of a negative interaction such as a discipline.
Is that one of the reasons why Mr. Hopkins led the meeting?
Yes.
Did your lens ever change from mental health to discipline?
It never did, no.
And is that based upon the information that you learned that day?
Yes.
Did James Crumbley ever tell you that the 6-hour 9mm handgun that he bought for his son was kept unlocked in the home?
No.
You were asked about certain indicators in your experience when you consider discipline. Is access to an unlocked firearm, is that an indicator?
Yes.
Is that something to consider? Had you known that?
It would be something to consider.
Okay, but that information was not shared with you.
No, it was not.
But just so we're clear, sir, the information that you and Mr. Hopkins were told on November the 30th, that information wasn't shared with anybody else in administration. Is that correct?
That's correct.
I don't have any further questions. Thank you.
Very brief request, Your Honor. Very brief. Mr. Ejak, you don't know whether James Crumbley knew that his son had access to a firearm that was in the home. Is that correct? You don't know whether James Crumbley knew.
So the question was he told that?
I don't know how he would know what the defendant knew.
He
Unless
testified
he was told.
what he was not told, Judge. That was the question.
Yeah, he said he wasn't told, but I don't know how he would know what your client knew unless he had a conversation about that.
Thank you. You don't know whether Mr. Crumbley's son had expressed any sadness over his friend moving to his parents, based on the information that you had on November 30th.
Can you say
Yes,
that?
it was kind of a convoluted question.
Whether it was discussed in that meeting or
Whether Mr. Ejak knew that Mr. Crumbley's son had expressed any of this sadness that they had identified to his parents prior to that meeting. Do you know if he did?
I'm not sure what you're trying to ask. I'm sorry.
Yes. Do you know if James Crumbley was aware of this sadness that you all had identified during this meeting with Mr. Hopkins?
I do not know.
No further questions, Your Honor.
All right.
Was the
now we're gonna
information
switch-
that was shared from Sean Hopkins regarding the emails that he received?
Yes.
Okay. And he went through the drawing with James and Jennifer Crumbley?
Yes.
And at no point did James or Jennifer Crumbley ever say that the firearm purchased 4 days before mirrors the firearm drawn on that math worksheet?
They did not.
Thank you. Nothing.
I just realized we haven't heard from the female prosecutor. All right, now we're going to switch over to the gentlemen that were there when James and Jennifer were taken into custody where were they? They were in that little art studio. So this is one of the gentlemen, one of the investigators.
Other rooms, we did not have keys for, and we were forced to force our way into those rooms.
When you say force our way into the rooms, can you describe what that looks like?
Yeah, there are several tools that are used to what's called breach or force the door open. There's a long Halligan type pole like a fireman would use. You jam it into the door frame and pry the door back and get the lock to sometimes pop. If that doesn't work, we have a 35-pound battering ram, and we will batter the door lock mechanism until the door opens.
Okay. Is that a quiet endeavor or is that loud?
Oh, it's very noisy.
So specific to the 3 floors in what's the building depicted here in 307, which areas did you and your team search?
The 2nd and 3rd floor.
And was anybody located in those searches?
Not on the 2nd or 3rd floor.
Okay. At some point, were you made aware that James and his wife were found on the 1st floor?
Yes.
Were you involved in the actual breaching of that room and the arrest?
No, that was handled by the Detroit SWAT team, I believe, handled that door.
Okay, they had already been assigned to the 1st floor?
Yes, sir.
Okay. And tell us what happened after that occurred.
As soon as the SWAT team entered that room and searched it and discovered the Crumbleys in that room, they were taken into custody by Detroit, and then they were turned over to my team, who took custody of them and transported them back up here to Oakland Town.
Okay, do you recall the approximate time that occurred?
Probably 1:30, 1:15, somewhere. It was after 1 o'clock in the morning.
In the morning, so we're talking Saturday, December the 4th.
Yes, sir.
And is James Crumbley in court today?
He is.
Can you please point and describe something he's wearing today?
Gray suit and headphones.
Your Honor, would record reflect the identification of the defendant?
The record will still reflect.
Thank you. Nothing further.
Ross?
Yes, Your Honor, thank you. Good morning.
Good morning.
Your involvement began on December 2nd of 2021, is that correct?
Yes, ma'am.
You were out of town on November 30th. Is it safe to say you were aware of the shooting that occurred at Oxford High School on November 30th prior to your involvement?
Yes.
Now, your involvement was as the sergeant of the fugitive apprehension team.
Correct.
It's also called FAT, is that correct?
Correct.
You testified that unit is responsible for locating people with felony warrants or wanted for serious crimes.
Correct.
Your unit did not get involved in all felony warrant arrests, is that fair?
I'm not sure I understand.
Sure. All felony warrant arrests in Oakland County, your unit did not go and arrest everybody who has a felony warrant. Is that fair?
That's fair.
Okay. And your unit did not get involved with all crimes that people were arrested for. Is that fair?
That's fair.
What in the hell just happened?
And let me clarify. So we know, and we heard some testimony previously, that there was a warrant issued by the court, correct?
Correct.
In this case, correct? And based on your experience, you were a law enforcement officer for 34 years, you were a detective for a number of years. You know that somebody who's accused of a crime and charged can walk themselves into a court, correct?
Correct.
With or without an attorney, right?
Correct.
And that includes for felonies.
Correct.
Their attorney, you're aware that there have been times where their attorney has arranged, sometimes with the detectives, sometimes with the prosecutor's office, in various ways. Their attorney can arrange for them to be turned in to the court or the police department on a specific day and time. Is that fair?
Sure.
The other ways are involving your former unit.
Correct.
And that's done by law enforcement. The attorneys don't call you up and say, hey, can you come get my client? That's the police who say, go get this person.
Correct.
And then obviously other agencies can get involved with our other arrests as well. Is that fair?
Yes.
In this situation, your involvement was requested prior to Mr. Crumbley being charged.
Yes.
You testified that your involvement was December 2nd of 2021.
Yes.
You were contacted, and I don't know if this was clear, you were contacted by Lieutenant Willis.
Yes.
He contacted you on December 2nd of 2021 and asked you to locate James and Jennifer Crumbley.
Yes.
Now, did you learn as part of your involvement or as part of getting that initial information that there were some concerns? Well, let me go back. You're aware that after the Oxford High School shooting that people were scared. Is that fair? I'm talking people in general.
Possibly, I would assume.
Angry,
Sure,
upset.
sure.
It was very public what had happened on November 30th of 2021.
Yes,
The shooter's name became public shortly after the shooting.
yes.
If you recall, and you may not know, but if you don't know, please say you don't know, that Mr. and Mrs. Crumbley's residence was made public.
That I don't.
Did you learn during your involvement in this case that there were some concerns over the safety of James and Jennifer Crumbley because they were the parents of the Oxford High School shooter?
I was never made aware of that.
So all you were made aware of was that James and Jennifer Crumbley needed to be located.
Yes,
And the first place you went was their residence.
yes,
They weren't there.
correct.
You eventually determined and learned that they had been at a hotel in Auburn Hills from November 30th to December 3rd, the morning of December 3rd.
I'm not sure if they were there that entire time, but that's where we ended up finding the vehicle, was at that hotel.
And did you also learn through your involvement that they registered at that hotel in Jennifer Crumbley's name?
I don't specifically remember whose name it was.
So you began looking for James and Jennifer Crumbley before they were formally charged.
Correct.
I assume in your career you've been involved in what would be considered high profile or media cases, is that correct?
Yes,
And oftentimes in those cases, is it standard practice for your department to take someone into custody before the actual charges are announced?
depends on the crime and the circumstances surrounding it.
Your department often, and correct me if I'm wrong, but your department will often assume that a high profile case or a serious offense that somebody might run.
It is a possibility, people do.
You had no information that James Crumbley had indicated that he was going to run away or flee or anything like that. Is that fair? On December 2nd of 2021.
That's fair.
You were aware that James and Jennifer Crumbley did not have their phones after November 30th of 2021 because they had been either given to or taken by law enforcement, but law enforcement had them in their possession.
Yes,
Did you also learn during your early involvement in this case or at any point that James and Jennifer Crumbley had obtained track phones or pay-as-you-go phones or things like that?
yes,
And did you learn during your involvement in this case that those phones were obtained because James and Jennifer wanted to be able to contact family in the early days after the shooting?
I was not aware of the reason behind obtaining those phones.
Did you also learn during your involvement in this case that James and Jennifer Crumbley obtained additional phones in the same phone number of the phones that were given to law enforcement?
I did learn that, but I don't remember at what point in our investigation I learned.
Said that charges were formally announced at approximately noon on December 3rd of 2021.
That's my understanding.
You do not know whether or not James and Jennifer knew that those charges had been formally announced. Is that fair?
That's fair.
You said that you went to James and Jennifer's attorney's office and you talked to an attorney.
I did.
That was not me, correct?
It was not.
Some hours later, you were notified that that one of their vehicles was located in a business parking lot in Detroit.
Correct.
It was not a parking garage, is that fair?
Yes.
It was not underground parking.
No.
It was not indoor parking.
No.
It was a gated parking lot. We can see the fence in the photo, correct?
Correct.
There weren't boxes or branches or anything covering their vehicle. Their vehicle was in the parking lot.
Correct.
And at some point during your involvement between December 2nd and 3rd, were you also made aware that there were going to be some attempts to do an alternative to what we talked about earlier when it comes to turning somebody in, that Mr. Crumbley may be walking himself in to be arraigned on the warrant after he'd been made aware of it, if you recall those conversations?
I had conversations with an attorney, but I'm not sure what I can go in.
Yes, and I'm not asking you about the details of the conversation, just if you had some knowledge that there was an indication that Mr. Crumbley was not running, but that he was in fact going to turn himself in. Again, without giving.
Yeah.
Judge, I object to this whole line of questioning. I think it's getting close to speculating what the purpose of what a hearsay conversation would be, and it could open the door to other things.
Well, yeah, are you going to open the door to that?
I can move on, Judge. At no point during your involvement in this case were you told James Crumbley is absolutely avoiding these charges and will not be turning himself in. At no point were you told that.
There's the same question, same objection to the same question, just asked differently.
Well, and who is he being told that by?
It could be anybody, Your Honor. His involvement was requested by Lieutenant Willis. He had multiple police officers involved. There were multiple people involved in allegedly, or in locating Mr. Crumbley. I'm just asking if he was ever given knowledge that was going to happen.
Just as a response, he's testified to what his job was. He was given an assignment and he carried it out.
Well, I don't know, I guess you gotta be careful what you wish for, right?
Thank you, Judge.
Yeah, you know.
You indicated that the building where Mr. Crumbley's vehicle was a quote-unquote 3-story industrial building, you called it.
Yes.
That was exhibit 307, which is on the screen. In that building, obviously from the outside, it looks kind of like a warehouse. Would you agree with that?
Sure.
But you learned during your involvement that there were multiple tenants in that building.
Yes, multiple suites.
Right.
Or rooms.
Businesses,
Yes.
people who were regularly in and out of that building.
That I can't answer to. It was very late and there was nobody in and out when we were there.
Okay. Did you learn during your involvement that there were people in and out during the day that day?
Not at the time I was there.
Okay. And you may not be the right witness to ask these questions of. I'm just trying to determine what exactly you knew about this building.
Yeah, at that point, at that hour of the night, there was nobody coming in and out. And we wouldn't have allowed anybody to come in or out anyway.
And you learned in going into the building that there was an option for interior parking. Did you learn that?
I don't recall there being any interior parking, like a parking garage, if that's what you mean.
Right. Like a way to pull a vehicle in through a garage and park it inside instead of out in the lot.
There was a loading dock, so I guess technically you could have pulled a car inside of there, but I did not see, it was not a designated indoor parking structure.
Right. So not like a parking garage or those underground parking like we were talking about earlier.
Correct.
Okay. Your testimony was that it was obvious and apparent what was going on outside of and in that building during your search of the building, correct?
Yes.
Now, you can't say, because you really have no idea what James Crumbley heard or saw that night, correct? On December 3rd of 2021, or the early morning hours of December 4th of 2021.
I can only tell you what I saw and heard, and the commotion, the law enforcement officers, the flashing lights from the police cars, but specifically as to what he saw and heard, I can't tell you.
Right. You have no knowledge of whether or not he saw or heard any of that. Is that fair?
Yeah.
You were not part of the arrest of James Crumbley after entry was made by DPD's SRT unit, correct?
Correct.
I have no further questions, Your Honor.
Thank you. Sir, who were you given this assignment by?
Lieutenant Willis.
Okay. And you were asked to locate James Crumbley on December the 2nd, not arrest him on December the 2nd. Is that correct?
Correct.
And that's not uncommon for an officer in charge to contact the fugitive apprehension team to locate a suspect, is it?
No, that's not common at all.
And the goal as a member of the fugitive apprehension team is a peaceful surrender?
Yes,
Okay. Is that why you reached out to Mr. Crumbley's attorneys?
absolutely.
Okay. And there were no arrangements made to you to turn the defendant in on Friday, December the 3rd, were there?
No.
Nothing.
You can step down in your excuse.
Thank you.
Thank you.
Shoot, I'm talking and I was muted. This is the gentleman that talked about all of the guns, that knows all about the guns. He's an investigator, cop. And he was like one of the first ones called in the Jennifer Crumbley trial. So we're just going to play the defense cross on his time on the stand.
Thank you, Your Honor. Good afternoon, Agent Brendan.
Good afternoon.
I'm going to go back just a little bit and get just a little bit of background information. In November of 2021, you were employed by the ATF, and you also worked on was it a task force? Did I understand that correctly?
So at the time of the shooting, I wasn't on the task force yet. I was working on cases in Pontiac that which led into the creation of that task force.
In connection with this case, you reviewed a significant amount of information and data in the investigations related to the Oxford High School shooting.
Yes.
And that would be specific to Mr. Crumbley, some specific to Mrs. Crumbley, and some specific to their son.
Yes.
On September 25th of 2021, you testified that that James and his son went to a gun range in Clarkston,
September 25th, yes.
that they rented a 9mm handgun, if you recall, and I can pull the exhibit up if you'd like.
No, that's correct.
Okay. That they purchased 2 boxes of 9mm ammunition.
I believe that's the correct quantity, yes.
If you recall, the price of those boxes was $29.99 each.
I don't recall, but that wouldn't surprise me.
Okay. That sounds about right for a box of 9mm ammunition.
Yes.
There was also 22 caliber ammunition that was purchased.
Yes.
They fired a 22 caliber pistol,
I believe the video we have, yes.
and that was the Caltech that's owned by James Crumbley.
I believe that is the firearm that's depicted, yes.
Okay. And you also learned that they also fired a 9mm pistol,
Yes,
which is the one that they rented.
correct.
That was the HK.
Yes.
In October 3rd of 2021, they went to the gun range again, they being James Crumbley and his son.
Yes.
They purchased 22 caliber ammunition.
I don't recall the exact receipt for that day, but that sounds correct for that day, yes.
And in October of 2021, to your knowledge, based on your knowledge of the investigation, there were 2 pistols in the home, and that was there were BB guns as well. I'm not referring to those.
Sure.
There were 2 pistols. There was the Derringer, which you've been shown, and the Caltech.
Correct.
Okay. Those are both 22 caliber handguns.
Yes.
November 26th of 2021 is when the Sig Sauer 9mm was purchased.
Yes.
And that was done so by James Crumbley.
Yes.
And if you recall from the receipt, there was, it was a handwritten receipt.
Yes, the receipt was handwritten, yes.
And the receipt had the firearm listed,
Yes,
the serial number of the firearm,
correct.
prices, and things of that nature.
Yep.
Okay. On November 27th of 2021, James Crumbley's wife, Jennifer, took their son to the gun range.
I'm sorry, what date was that again?
November 27th of 2021.
Correct.
So that was the day after the 9mm was purchased.
Yes.
They purchased 2 boxes of Patriot Defense 9mm ammunition.
Yes.
Based on your investigation, you learned that they fired 1 full box of ammunition, or at least you believe that that occurred.
That's correct.
You recall that each box was approximately $23.99.
Yes.
That they left with 1 box of 50 rounds of ammunition.
Correct.
I'm going to get back to, you compared the handgun on the math assignment and also the handgun in the home. I'm going to get back to that in just a minute, but I do want to talk about keeping a handgun safe in a home. You would agree that there are a variety of ways to keep a handgun safe in home, and I'm going to give you some examples. One would be to store it in a safe.
I would say that's one way to. Are you saying when you said keeping a firearm safe? What does that mean exactly?
Sure. Well, just that. Keeping it safely stored, keeping it safe in the home.
Safe. I mean, I'm not trying to play a game. I'm just trying. So you're saying like keeping it safe from access or from a person? Like I'm trying to understand.
Sure. Safe from others, safe from accidents, safe from accidental discharge, safe from mishandling, safe from. Sure.
That's one way I think you could keep a firearm securely stored inside of a home.
You can store it in a locking gun case. We saw that the cases that were on the table, they had holes where you could put a lock in them.
Yes,
that's another way.
Yes.
You could store it in the small safe. I guess there's a couple different styles of safes. There's the little safe that you showed us earlier, and then there's other bigger safes, correct?
Yeah, there's a variety of gun safes out there, yes.
You could use a cable lock.
Yes.
You could use a trigger lock, which goes in the trigger.
Yes.
You could store the firearm unloaded. Obviously, an unloaded firearm is not inherently dangerous, correct?
I don't want to speculate on whether that would be a safe way to secure a firearm because you don't know whether knowing all the ins and outs of whether someone else has ammunition or magazines or things like that. I can't answer that question.
Sure. I guess my question is actually a lot more simple. I'm not asking you to speculate on anything.
Sure.
Simply having an unloaded firearm, is an unloaded firearm in itself dangerous? Or does it become dangerous when you put ammunition in it?
I would say that the answer to that question really depends on the proficiency with firearms of people in the home. If you have ammunition stored separately and it's just the firearm by itself, if someone clearly knows how to load a magazine and insert it, it's no longer stored safely secured, I would think.
My question is a little bit different though. It's not necessarily talking about, and we can get to the other stuff too. I'm not asking you to avoid that.
I'm really just trying to answer your question. I'm trying to understand what you're trying to ask.
Sure.
Yeah.
What I'm trying to ask is an unloaded firearm in and of itself, no ammunition in it, no magazine in it, is that itself unsafe?
Again, I don't know what else, not knowing what else is in the home, I can't answer that question.
You would agree that keeping a handgun safe depends on a variety of circumstances. And you talked about some of those, not knowing if there's ammunition in the home, right?
Yes, are you talking now again about the same line of it being stored just by itself?
Correct.
I mean, yeah, there's so many factors that would go into whether that would be a secure way to store a firearm, yes.
Where it's stored could also be dependent upon the age of the people in the home.
I think that's one relevant factor, yes.
The home, people who live in the home, their knowledge of firearms. And I think you mentioned proficiency, like whether or not somebody could load a magazine.
Right. I think we're getting into an area that's kind of, I don't know how to answer that question. I'm just really trying my best here. I don't know how to answer that question. There's just too many variables.
There's a number of variables. That's kind of the point that I'm making. There's a number of variables that go into determining whether or not a firearm is stored safely. Is that fair?
Yes. There are a number of variables that come into play when considering how to store a firearm, yes.
One of the ways that we just discussed was a cable lock. Cable locks can be removed in more than one way, correct? It can be removed by using a key and unlocking the cable lock.
Yes, that's the way to unlock the cable lock, yes.
And I think that one of our witnesses previously also testified that you can also cut off a cable lock.
Yes, I'm aware that there are tools you can use to defeat the cable lock, yes.
As for the youth handgun safety pamphlet that the prosecutor showed you, you're aware of federal law, which that ATF handgun safety pamphlet is about federal law, correct?
Yes.
It's not about Michigan laws.
Correct. I believe it references state and local ordinances at one point, but generally speaking, yes, it references the federal law.
Okay. And you're aware that it is legal under federal law for a minor to possess a handgun in certain circumstances?
Yes, that's correct.
That includes going to a shooting range?
So we have to be careful about how we're using the words in that sentence. So there's five specified things in particular about what minors can do alone with firearms with written consent from their parents. It would be hunting, ranching, employment, target practice, and hunting, I believe. But there's specific things you have to do with as far as if they're doing it alone with written consent, the consent has to be on them. There's a variety of things in the actual statute itself. I can't recall all of them off my head, but if I'd have to have a little more information to know that was okay.
Sure. We don't have any evidence, and we haven't looked at any evidence during your testimony, and you've been sitting in court for all the witnesses, correct?
That's correct. Yes.
There's been no evidence presented by Mr. Wagrowski or any other witness to show that Mr. Crumbley's son went to the range by himself.
No, not that I've discovered in this case, no.
So we're talking about going to a shooting range with a parent. That itself is not illegal under federal law.
No.
Learning firearm safety. A minor can handle a firearm while learning firearm safety. Again, assuming they're with a parent.
Right. There's only certain things that are covered by federal law that federal law even touches upon, and it's the transfer of a handgun to a minor. It's not even contemplating those scenarios you're discussing. So there is not a federal law that says a parent can't show their child firearm safety. No.
And during your involvement in this case, you found no evidence that James Crumbley was aware that his son had obtained unsupervised access to any of the firearms in his house.
Can you repeat the question?
Yes. During your involvement in this case, you found no evidence that James Crumbley was aware that his son had obtained access to the firearms in his home.
I don't recall him ever having the videos of his son playing with the firearm or anything like that, just the fact that he was present during the time.
So he was in the home during those times, but you don't have evidence that James was aware that those activities were occurring. Is that fair? And I'm not trying to trick you.
No, I haven't. I understand your question. If I understand it correctly, you're saying that there's not evidence that, he sent a video to his dad saying I was playing with this gun or something to that effect. I never found anything like that, if that's what you're asking.
You've been involved in this case since November 30th of 2021. We heard your testimony about that. You were involved in the search of Mr. Crumbley's home?
Yes.
And that was on November 30th of 2021?
Yes.
And we talked about there were various BB guns found in the home. That's not illegal, correct?
I can't even comment on it. I don't know. I'm sure they are. I have no idea.
No idea. Okay.
I mean, under state law, I have no idea what's legal and not with BB guns.
There were also 2 pistols which were located in the gun safe, which you testified about previously.
Yes, that's correct.
That gun safe with those 2 handguns were located inside of a TV stand or a dresser of some sort?
It was like, I think it was a dresser that had a TV on it, and it was like, had like a couple of drawers and a sliding thing in the middle. Yeah.
So it was located inside of that dresser in a cabinet?
Yes.
There was also an empty Sig Sauer gun case, which we've seen, found in James's bedroom.
That's correct.
Along with an empty box of Patriot Defense 9mm ammunition.
Yes.
Also found in James's bedroom.
Yes.
You learned that Mr. Crumbley purchased 3 handguns between June and November of 2021.
Yes.
We went over those purchases today.
Yes.
With each purchase, you know that Mr. Crumbley signed a trigger lock statement.
That's correct.
And you reviewed those as part of your involvement in the case.
I reviewed the documents from every purchase. Yeah.
Now, you also know that for an FFL dealer to be compliant with federal law, that they also have to provide the ATF safety handgun notice.
Correct.
With each purchase.
Yes.
So, Mr. Crumbley purchasing 3 handguns between June and November, he would have received 3 of those pamphlets.
I believe that's correct, yes.
So, we've talked about one, the one that was found in the Sig Sauer case, but you don't know the location of the other 2.
I do not.
And there's no requirement in that pamphlet or anywhere that Mr. Crumbley display that notice anywhere in his home.
No.
Okay. Federally licensed firearms dealers provide the cable locks to each seller, and typically the cable lock comes with the firearm from the manufacturer. Is that fair?
Correct. With new firearms, that's generally the case, yes.
Used firearms, the cable lock might come from somewhere else. Is that accurate?
Yeah, either the store will have you buy one, or sometimes people throw it in for free. It all just depends, yeah.
And I think Ms. Back testified that the cable lock that we have was from Sig Sauer, correct?
Correct.
Cable locks are not necessarily specific to each firearm. So it's not like a key in a lock, right, which is specific to that lock. Cable locks can be used on other firearms.
Yeah, generally speaking, yes. They can be used on multiple makes and models of firearms, yes.
So assuming that there isn't an issue with the caliber, a .22 caliber we've determined has a smaller a smaller bore, so it's more narrow than a 9mm, which has a wider bore.
Correct.
So a cable lock specific to a 9mm may not fit in a 22 caliber, but a 22 caliber cable lock may fit in a 9mm, if that makes sense.
It depends how you use it. I mean, if you were going to put it through the magazine well and not the actual barrel, there's different recommendations on how to use it. If you were going to put it through the magazine well and lock it, it would fit both.
So that Sig Sauer cable lock isn't necessarily designed just for that Sig Sauer. A Kel-Tec cable lock could have been used on a Sig Sauer, correct?
Kel-Tec, to my knowledge, does not make cable locks. They provide trigger locks, but I get your point. Yes,
Yes.
a different model could work just as well.
Okay. There are also universal cable locks, which we've kind of talked about, which could work on any caliber handgun.
Correct. Semi-automatic handgun, yes.
Semi-automatic, thank you. Again, Mr. Crumbley, we know, received 3 either cable locks or trigger locks in connection with the purchases of the handguns.
Correct. Based on the documentation we have, yes.
Right. You found 1 cable lock in the home.
That's correct.
The keys were still in the lock.
Yes.
You did not find the other 2.
No.
Or their keys.
Not to my knowledge, no.
You don't know where those other 2 cable locks are.
I believe there would have been a trigger lock with the Kel-Tec, but to your point, yes.
Okay. You don't know whether Mr. Crumbley had a cable lock on the SIG or not at the time that it was taken by his son. Based on your
Taken by
investigation.
his son. I would, and based on statements made that we've heard in court and other things like that, I've never heard mention of a cable lock. I've always heard hidden.
Okay. You don't know though. Is that fair based on your investigation?
I know that one wasn't recovered at the school or in the house. So is it a certainty? No, I think it's highly improbable.
You said that 1 was recovered at the school?
I said one was not recovered at the school.
Oh, I'm sorry, I didn't hear you.
So it would, yeah. I found no evidence that a cable lock was ever installed in that firearm.
The prosecutor was asking you about the difference between a 22 caliber round and a 9mm round, and there was something about the size of it, the bigger the round, the bigger the hole, things like that.
I don't know if I said that today, but I know it, yes.
Okay. There's no evidence that you've learned to show that James bought a gun because he wanted more damage. I think that's what you said, more damage.
More damage. Yeah, I don't think I found any evidence that James decided to purchase that firearm. If my understanding is right, based on things, is that the only person who ever researched the purchase of the firearm was the shooter.
We also heard Ms. Back testify that and confirm that when Mr. Crumbley went and purchased the 9mm Sig Sauer, that he had made indications that he had been looking at it for a few days. Do you remember that testimony?
Yeah, I remember it was either a few days or quite some time. I'm not sure the phrasing, but I remember hearing that testimony, yes.
And we know that James Crumbley also has fired a 9mm prior to November 26th of 2021. I believe it was September or October of that year.
Yes, I recall he had at least fired it then and then maybe in July that year too.
We talked about Exhibit 167, which was the small safe.
Yes.
The combination on that was 000.
Yes.
You have no knowledge if anyone other than James knew the combination of that safe?
I do not.
Specifically, you have no knowledge if his son knew the combination of that safe?
I do not know if he knew the combination was 000, no.
You don't know if James was aware if his son had the combination to that safe. Is that fair?
I have found no evidence that he provided the combination or his son knew the combination, but based on the fact that we recovered the firearms in the home in the safe and that we have videos of, at least there's the one video on, was it August 19th and August 20th, the 2 videos of Mr. Crumbley's son playing with the Kel-Tec. There's also a video, I forget the date, of the shooter playing with the Derringer inside the house at one point. So if they were in the safe, I don't know if his father was there or not. I can't answer that question for certain whether his son knew the code to that safe.
Okay. And you talked about August of 21. That was obviously before November 30th of 2021 when you recovered that safe from the cabinet.
Correct.
You testified with the prosecution that you were, I believe you used the word shocked to find the ATF youth handgun pamphlet in the 6 Sauer gun case, right?
Yes.
Now, we just talked about the fact that there were at least, we believe at least, 2 other pamphlets that were provided to Mr. Crumbley. correct? There, because we know that because there were 2 other firearms in the home, and you have no reason to believe that those were not sold in compliance with federal law.
Correct.
You don't know when or how often Mr. Crumbley reviewed those pamphlets with his son
I do not.
prior to November of 2021?
No.
In fact, it would be an assumption that because it was in the Sig Sauer case, that must mean that Mr. Crumbley wasn't reviewing those rules or following the rules with his son. Is that fair?
Can you either rephrase or repeat the question?
Yes. It would be an assumption about whether or not Mr. Crumbley reviewed those pamphlets with his son just because it was found in the Sig Sauer case.
Correct. Yeah, I think that's why I said I was shocked that it was just kind of discarded to the back. Yes.
And we also established that there was no requirement that he post that pamphlet anywhere in his home.
Correct.
Prosecutor asked you about registering handguns. You don't know whether James mailed the pistol sales records, correct?
You mean mailing them into? If they were mailed in process, they would have shown up in the registry. I've actually ran it between or either right before the first trial or this trial, and it still wasn't in there. So it'd be odd if all 3 got lost in the mail.
Even assuming that James didn't mail them or drop them off, the penalty is a civil infraction, correct?
Yes, I was only answering the question that they weren't registered.
It's a fine, correct?
I don't enforce that state law particularly. I generally deal with other parts of state law with firearms offenses. So I'll take your word for it.
Well, and I can show you the exhibit if you'd like. The pistol sales record actually lists the penalty at the top.
Sure.
You talked about Mr. Crumbley's son's stance while at the shooting ranges. And you said that it shows that there's some level of proficiency, that he has some level of proficiency with firearms. Do you remember saying that?
Yes, I believe I was talking about the surveillance video from the school, but yes.
Okay. You would agree that it's important for people in a home where there are firearms present to be familiar with them. And let me clarify that question a little bit.
Sure.
Obviously, if you have a 2-year-old in a home, you are not going to familiarize your 2-year-old with a firearm. Is that fair?
Sure.
Not intentionally.
Correct.
If you have a teenager in the home or other adults in the home, they should be familiar with the firearms if they're going to be in the home. Is that fair?
I think that's obviously a personal decision that it's not something covered by federal law that you're required to do that. I think some people may choose to not do that and just keep them away from their kids and out of view. But, like I said, that's not something I can speak to.
Prosecutor specifically asked you about Exhibit 169, which was the firearm purchase on June 15th of 2021, and that there was a delay. You testified that sometimes the background may take time. That's not a negative or a positive. It's just a fact that sometimes they take time.
Correct.
You heard voices, if you recall, in Exhibits 172 and 173 at the outdoor range, which was where the videos on Mr. Crumbley's cell phone of his son firing the Kel-Tec and the Derringer. Do you remember those videos?
Is that the June videos, June 20th?
Yes, June 20th, yes.
Yes.
And you recall that there were other voices. Do you recall hearing other voices?
I don't recall hearing them. I don't disbelieve you.
Do you recall hearing other firearms being fired? I don't know what they were, but you can hear other firearms being fired.
I don't recall after watching it right now. This time, I was focused on the shooter in this instance. I don't think it's out of the realm of possibility that other people may be shooting at a range as well.
Exhibit 175 is the Instagram post by James Crumbley's wife that both Mr. Crumbley and his son, quote, both got handguns.
That was the Instagram story?
Yes.
Yes, yeah.
And that was, that video is showing Mr. Crumbley's son firing the Kel-Tec.
Yes.
Which was in the safe in his room, in the safe in Mr. Crumbley's room.
On November 30th, yes.
Correct.
Yep.
Exhibits 70 and 71 are the August 19th of 2021 video and text that we just talked about a few minutes ago. That is of the Kel-Tec, correct?
Yes, both of the August 19th and 20th videos were of the Kel-Tec, yes.
So You would agree that these may have been the same night. The August 19th video was about approximately 9:30 p.m. and the second video was about 12:30 a.m. the following morning.
Correct, yeah, it was the same night into the following morning, yes.
Exhibit 70 and 71, you specifically can see that the Kel-Tec is unloaded.
In the 819 video?
Yes.
Yes,
That there's no round in the chamber and that the safety is not engaged.
correct.
Exhibits 72 and 73 are the August 20th of 21 videos. Your testimony was that Mr. Crumbley's son slammed the firearm down onto the magazine and released the slide forward.
Correct, yes.
You testified that the way that Mr. Crumbley's son was handling that firearm was not safe handling.
Correct.
You may have also testified about this, but I wanted to clarify. There was nothing in your investigation that showed that James was aware that his son had made that video.
No, again, just only what I testified to, that he was in the home at the time of the video, but no.
Exhibit 190 is the September 25th, 2021 gun range. There was some 9mm rental, some ammunition purchase, and targets also purchased.
Yes.
There were silhouette targets and also non-silhouette targets purchased, if you recall.
I don't recall, but I take your word for it.
There were also range safety officers present, if you recall.
Yes, I think that's standard at that range in my experience.
You described a little bit and discussed a little bit watching Mr. Crumbley's son, and I don't know if you used the word misfire, but you indicated in your testimony that Mr. Crumbley's son was having an issue with the semi-automatic handgun.
Yes.
That he was struggling and was unable to clear something, correct?
Yeah, I think he thought a round was in the chamber and he thought he cleared it, but there was actually nothing in there, and that's when Mr. Crumbley picks up the magazine and inserts it and makes it operable again. Yes.
And obviously we know that Mr. Crumbley and his son went to the shooting range.
Yes.
And Mr. Crumbley's son handled the handguns. We watched it.
Correct, yes.
You would agree that it's important for a person who fires a firearm or a handgun to know how to properly clear a misfire.
I wouldn't say that it was a misfire. I would say that, what it appeared to me is that he was, being instructed by his father on how to properly deal with any malfunction of the firearm, which is when he racked the slide and then, inserted the magazine.
So same question, but worded a little bit different. It's important for somebody who handles a firearm or who fires a firearm to know how to deal with things that come up while you're firing it. Is that fair?
I would say that's a safe way to, if you're going to be shooting a firearm, that's correct.
And if somebody handling a firearm or shooting a firearm doesn't know how to properly do that, it can have potentially very dangerous consequences.
Yes.
Exhibit 95 is the social media post by Mr. Crumbley's son about the one where there's the multiple photos of this 6 hour. He talks about his new beauty, his 9mm, his 6 hour. That
I recall the post.
Okay.
Yeah.
There was no evidence other than those pictures. Well, let me say this, and I've asked this question before. You've heard it. Based on those photos, you don't know if Mr. Crumbley is standing right outside the frame of the photo, correct?
I do not know.
Okay. You've learned nothing during your investigation to show that Mr. Crumbley wasn't standing there with his son.
On the day he purchased the firearm, when he took those photos?
Yes, November 26th.
Correct.
There's no evidence that Mr. Crumbley gave his son that Sig Sauer and that he had it unsupervised. Is that fair? Other than on November 26th of 2021.
So I recall there being another video that Detective Wogrowski testified to that I've also observed. I believe that was later that night, showing the shooter in possession of that firearm, filming down the barrel of it. I don't recall any other videos or photos of that on the devices.
And along the same lines as I've asked previously, you learned nothing during your investigation that Mr. Crumbley was aware of that video. The one later that night on November 26th of 2021.
Yeah, again, the only thing I believe he was also present in the home for that one, but that's the only thing that I could find. Yes.
In fact, the 6 hour case was found in Mr. Crumbley and Mr. and Mrs. Crumbley's bedroom.
That's correct. It was on the bed it was open next to the box of Patriot defense ammunition.
Exhibit 97 was a photo taken by, I believe, Jennifer Crumbley of the open Sig Sauer box with the Kel-Tec and the Sig Sauer in the case, correct?
Yes,
That has the ATF pamphlet and the cable lock.
correct.
In looking at the Caltech, there's no magazine in the Caltech.
I don't believe so in that picture, no.
You testified about the Exhibit 42, which is the cable lock that was found at the Crumbley home. Your testimony was if it was used regularly, the bag would be damaged. That cable lock was provided 4 days before you found the cable lock in the home, correct?
Correct, yeah. But if you tried to take that in and out of there, the way that the cable lock expands in that bag, it would tear up the edges of it. So there would be more wear and tear on the bag.
Exhibit 95 is the receipt on November 27th of 2021 when Jennifer Crumbley and her son went to the shooting range.
Yes,
I think I've already discussed this. There was Patriot Defense 9mm ammunition purchased that day, 2 boxes.
correct.
Based on your investigation and your involvement, that was the first time after that 6 hour was purchased that ammunition was purchased.
From records we've located, yes, that's correct.
If you recall, and if you don't know the answer to this, please tell me. You reviewed a lot. Did you also review any statements made to law enforcement or the interview from the substation of Mr. Crumbley?
Yes,
Okay. And if you recall, during that interview, James did not know how much ammunition was purchased that day, November 27th of 21.
I recall there being a conversation between him and his wife, and I believe he ends up correcting her, saying it was 50 rounds, but I don't recall the exact words he used.
Okay. They discussed the cost.
I believe so, yeah, because he was, I think she initially thought there was like 200 rounds, and I think he eventually informed her it was 50 rounds.
Okay. Exhibit 196 is the video of Mr. Crumbley's son and Mr. Crumbley's wife at the range. You can see when Mr. Crumbley's son is actually in the booth handling the handgun, the 9mm handgun, the 6 hour, that there's actually a range safety officer standing slightly behind him to the right. He's got like a bright yellow vest on, correct? Yes. And if you know, and I assume that you do know, the purpose of a range safety officer is to ensure that people are handling their firearms correctly.
Yeah, I would say it's in compliance with whatever the rules are for that specific range, yes.
So if that, we would assume, and if you don't want to assume that's okay, but if that range safety officer had seen Mr. Crumbley's son doing something incorrect or inappropriate, it would have been raised as an issue that day.
I would assume so, that's his job, so yes.
The empty box of ammunition that was discovered in the Crumbley home on November 30th of 2021 was Patriot Defense ammunition.
Yes.
And I think you testified earlier that there are 9mm ammunition is more expensive than .22 caliber ammunition, correct?
Generally speaking, yes.
Okay. But within that, there are varying levels of expensive for the 9mm ammunition, correct?
Correct.
And we know that there were 2 different prices on 2 different purchases of 9mm ammunition in 2021 by James Crumbley and by his wife, Jennifer Crumbley.
Yes.
And obviously, if you're going to the shooting range, you need ammunition to shoot, correct?
Yes.
So it's not unheard of for somebody to buy rounds of ammunition at a shooting range.
No.
During your involvement in this case, you saw no information that James Crumbley was aware of the Instagram post by his son. Let me clarify, because I think there were a couple. The Instagram post where his son commented, it was Exhibit 100 about his, quote, new SIG.
I don't recall if he saw that one. I know he saw the social media post by his wife with the firearm, but I don't believe that there was evidence of the him doing that specific post that I found.
You also talked, lastly, you talked about the similarities between the drawing of the handgun on the math that we've seen, the math assignment that we've seen is Exhibit 130. And also, and let me see if I can get back to it, and also the similarity to the handgun, the 6 hour handgun. Do you remember making that comparison?
Yes.
Okay. Let me see if I can pull that up.
Main person that's turning on the TV, guys.
Oh, yeah, there's a button on the back.
There we go. That's fine.
Can you see? Okay.
Yes.
So you talked about the similarities were the striations on the back of the slide.
Yes,
Correct?
that was one of them, yes.
The location of the ejection port,
Yes,
the shape of the trigger guard,
yes.
and for those reasons, you believe that that was the same as the 6-hour handgun.
And also the shape of the floor plate of the magazine. When all those are combined, each one taken in isolation, not the case, but if you put them all together, then yes.
And you're obviously work for the ATF.
Yes.
You have some significant familiarity with handguns.
Yes.
This is the handgun. It's Exhibit 86. The Smith & Wesson handgun. A photo that was sent to James Crumbley by his son prior to the purchase of the 6-hour handgun.
Correct.
There's striations on the back, correct?
Not on the front.
There's striations on the back.
There are striations on the back, but not the front of that firearm.
And that's the ejection port that we can see on the top. Well, the side facing us. Obviously, you can't see what's on the other side.
Correct. There's also a black line that's not, it's a two-tone firearm and there's a black line. There's vast differences between that one and the one that's drawn. There are some similarities like we discussed, but I said again, taken in isolation, it could be a different firearm, but when all put together, it appears to be the same firearm.
And you don't know if anyone who viewed that handgun on the math homework even made the connection between that and the 6-hour. Is that fair? Other than you. We know you did.
I found no evidence that they did it. I know that if you buy a firearm, you generally know what it looks like, but no.
I have no further questions, Your
Honor. Briefly, Special Agent Brandon, Defense Counsel just asked you some questions about other cable locks being used or could have been used. Do you remember that?
Yes.
All right, and she asked you about the other 2 cable locks. Do we have any evidence there were 2 other cable locks ever given to James Crumbley?
No, there were 2 trigger lock forms that could have been trigger locks or cable locks. And honestly, the cable lock for the Derringer probably wouldn't even work because you have to have one small enough to fit through the actual firearm itself, which the SIG one would not.
All right, and you just testified that you believe a trigger lock was what was sold with the Caltech. Did you say that?
Yes, that's correct.
Okay. Did you find any evidence of a trigger lock or another cable lock anywhere in the home?
No.
Anywhere in the school?
I didn't search the school, but I'm not aware that one was ever located.
Okay. She just asked you about the comments at the substation. Do you remember that?
Yes.
Okay. What did James Crumbley say when he was asked where that weapon was?
I believe he said it was in the armoire, hidden in the armoire, and then he said the ammunition was underneath a pair of jeans.
Did he ever say locked?
No.
Was there anything that struck you about his mention of the SIG?
Yes. So when he mentions the 6-hour, he mispronounced sour as Sawyer, which if you purchased that firearm and it was for yourself, you'd be familiar with how to say 6-hour.
Okay. And
Your Honor, I would object to that response and ask for it to be stricken. He's making an assumption about what Mr. Crumbley knows.
I'll move on. Special Agent, last question. You mentioned earlier that you reviewed the cell phone data and web searches that were on the phone of James Crumbley.
Yes.
All right. And did you ever find any searches that he did relating to firearm safety or minors?
I did. There were searches related to that topic. It was after the shooting had occurred.
Okay, so December something, after the shooting occurred.
Yes, I don't recall the exact date, but it was after the shooting.
Anything before?
Regarding firearm safety, not that I recall.
Thank you. Nothing further. May this witness be excused, Your Honor?
Yes, you can.
Okay, now we're going to go over to, let me see, I think she cross-examined this gentleman that was part of the crew that arrested them.
County Jail, what did you do?
We took pictures of both the Crumbleys individually. First, we took pictures of Miss Crumbley first, and then Mr. Crumbley.
Okay. And what's the purpose of that?
The purpose of it was the fact that it showed any injuries that they're in, and the condition when they were arrested.
Okay, thank you very much. Nothing further.
Sorry, I didn't hear the end of your response.
Are there any injuries or their condition when they were arrested?
Thank you. Yes, Your Honor, briefly. Good afternoon.
Good afternoon.
As a forensic technician, your role is to document what you see at a scene, correct?
Yes, ma'am?
Your role is not to investigate what may have occurred prior to your arrival.
No, ma'am.
You testified that when you arrived at 1111 Bellevue, that there were a lot of news cameras.
Yes,
There were a lot of law enforcement, if you recall.
yes.
It was kind of a chaotic scene.
I wouldn't say chaotic, but it was officers and cameras at the scene.
You were told that you were notified, you were not notified what the case was involving before arriving at 1111 Bellevue, is that correct?
Exactly.
You were only told that it was a shooting incident.
We were told that we were collecting for a search warrant.
For a shooting incident.
We were told we were collecting for a search warrant.
Okay, so you weren't told anything.
Again, as my report says on the first page, as you look at the first line, the information received request to process the scene of a search warrant and arrest at the address 1111 Bellevue from District 1 Dispatch.
And I thought that in your direct testimony with the prosecutor that you said that you were notified that the case was involving a shooting incident and that 2 people were arrested.
Your Honor, I just wanted to clear up, I'm not sure at the time of when he was notified at the scene versus before he left. So I just want clarification.
Do you recall testifying in that way?
What I said, if we're talking about this specific time, was when we were informed from District 1 it was search warrant. When we arrived, that's when we understood it was connected to the shooting incident.
So after you arrived at 1111 Bellevue?
Yes, ma'am.
Thank you for clarifying that for me. You said that when you initially get to a scene, you walk through and the officer in charge points out items of interest that he or she wants collected.
Yes, ma'am.
And then you may also walk through with your partner and identify additional things.
Yes, ma'am.
And we saw some of those things today, like the tote that you ended up taking photos of where the purse was. Is that
Yes,
correct? You testified that you collected 14 cigarette butts. And you can look at your report if you'd like.
Thank you, I appreciate it.
I'll stipulate he said 14.
Yeah, 14.
He hasn't left.
And it's your understanding that from your recollection, those cigarette butts were collected next to a Kia we had a photograph of.
Yes, sir.
You testified that inside of the plastic bag in I believe it was exhibit 334, that there was a bank envelope. Looking at the bag now, do you see what that was?
The picture's kind of blurry, but it still looks like a bank envelope.
Okay, it doesn't look like a business card?
To me, it looks like a bank envelope with the black spots on top of it.
Exhibit 339, the prosecutor asked you to look at the inside of a garbage can, if you recall, and there was a whiskey bottle inside the garbage can.
Yes.
You don't know how that whiskey bottle got there?
No.
You have no knowledge of how long it had been there?
No.
You have no information about it whatsoever?
No, all I know is a whiskey bottle garbage can.
And you were just taking a photograph of what was on the scene when you got there?
Yes, ma'am.
In Exhibit 347, you talked about bank envelopes and a search warrant tabulation return, which was on a table.
Yes.
It wasn't hidden anywhere, correct?
The search warrant or
the tabulation was not hidden anywhere. It was just sitting on a table when you took the photograph?
Yes.
And you completed the search that you arrived on scene around 2 a.m. and you were done around 5 a.m.?
Yes.
One moment, Your Honor.
Sure.
And the photographs that you took photographs of cash. You don't know what that cash was for. That's fair. Because again, you were just taking photographs of what was on the scene when you got there.
It was cash in the purse.
Right. Thank you. No further questions, Your Honor.
Just
All right.
one point for clarification. You said you took pictures for, in case they're for document any injuries. Did you?
Objection, Your Honor. I didn't ask anything about those photographs.
She did. I believe that she did. And if not, I'm offering some clarification.
Your Honor, I would object to any questions about the photographs that were taken of my client after he was arrested. I didn't ask anything about that on my cross.
I did see the scope of cross. I'm not gonna talk.
Okay.
Whew.
Is this witness excused?
Yes.
Wow. Okay. So this one, oh, hang on. Okay. Now we're going to go back over to the last day of the trial. And prosecution has rested. I can't think of the word. Something that I need to do. Rest. Now we're getting into his sister's testimony. This should be interesting.
Started with testimony regarding exhibits that were admitted. I won't go through all of them, but I will rely upon the document that I provided counsel as well as the court that these exhibits are in fact admitted.
And we made an extensive record of which exhibits would be admitted last week, correct?
Correct, Your Honor.
That's correct. And the only exceptions that I did want to point out, we have an agreement to exhibit 378. That's a redacted transcript of James and Jennifer Crumbley's in at the Oxford substation. We're in a stipulation to that. That's 378.
Ms. Lane, did you have an opportunity to review the transcript?
I did, Your Honor. I have reviewed it. I have spoken with Mr. Keast about it, and we do have an agreement to admit that as an exhibit.
You believe it's accurate?
I do believe it's accurate, Your Honor, yes.
All right, I will admit number 378.
Thank you, Judge. And the only other two exhibits that are currently noted as exhibits on this list are 373 and 374. Those are not admitted and at this point will be omitted from the exhibit list.
373 and 374 will not be admitted.
Yes, Judge.
And Your Honor, I would like the opportunity, and I believe Mr. Keast will do that, to give me a copy of that list to just ensure that I have the same number of exhibits that he has and to make sure that we agree.
Okay, sure.
And Judge, with that, people rest.
Ms. Lehman.
Yes, Your Honor. At this time, the defense would call Ethan Crumbley.
Good morning. Could you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, so help you God? Okay, and could you hold this sword toward you?
I got it.
And have it step up? And have a seat? And then would you state your name for the record and spell your first and last name?
Karen Crumbley, Karenscrumbley.
All right, I'm gonna ask you to keep your voice up.
Okay.
All right, take a deep breath.
Okay.
Go ahead, Ms. Lehman.
Thank you, Your Honor. Good morning, Ms. Crumbley. Can I call you Karen?
Yes, ma'am.
Thank you. Karen, I am gonna again ask that you keep your voice up. You are a little soft-spoken, so I want to make sure that the jury and the courtroom can hear you, okay?
Okay.
I just have a few questions. How are you feeling today?
Good.
Are you nervous?
Well, I mean, yes, a little. I mean, all right.
I'm gonna take you back. Well, let me start with this. Do you know James Crumbley?
Of course, yes.
How do you know him?
He is my brother.
Do you know his son?
Yes, I do.
I am going to ask that you not say his son's name. We do have some direction from the court not to use his son's name in court.
Okay.
And what is his son's relationship to you?
He is my nephew.
We're going to be fairly specific. Where do you live?
I live in Welaka, Florida.
Tell the court a little bit about yourself.
I was raised in Jacksonville, Florida. I went and graduated high school, and then I got my medical assistant degree and did a few times in New Hampshire at Dartmouth Hitchcock Hospital, and then came back to Florida. And I was in a car accident where I lost my right leg, and now I stay in a town that is peaceful, and I have 4 children and 2 grandchildren.
How old are your kids?
17, 18, 23, and 25.
I'm going to take you back to 2021. Where are you living in 2021?
In Welaka, Florida.
Specifically, I'm going to ask you about April of 2021. Do you recall what was going on in April of 2021?
My mom was in the hospital. My mom passed away April 6th of 2021.
Do you recall if you saw James or his son in April of 2021?
Yes, I did. My brother James was there in the hospital with us when my mom passed. And then my nephew came down, I believe, the day after and stayed for the while we had those services. And then we had like a memorial thing, like get together with everybody, cookout and stuff. And then we had the services, the funeral services and things like that.
You said your mom passed away on April 6th of 2021?
Yes, ma'am.
Do you remember exactly that your nephew came down on the 7th, or are you not sure of the date? And if you don't know, it's okay.
I know that they left when they found out that my mom had passed. I believe my nephew and his mother.
For a second. Who's they?
My nephew and his mother drove down to Florida from Michigan when they find out, and believe they got there maybe around on the 7th that they arrived.
Okay. So you remember that you saw your nephew maybe the 7th. It might have been the next day, or maybe you're not sure.
Right. Yes.
But it was shortly after the 6th.
Yes, it was very shortly.
While your brother and his son were in Florida, did you spend time with them?
Yes, I did. Okay.
Obviously, it was a difficult time with your mom passing away. Do you recall seeing anything concerning about your nephew?
No.
Do you recall him saying anything concerning to you? No. And if I ask you about if you recall if anyone...
Will you keep your voice up? Just
yes.
I want the jury to be able to hear.
Okay, I'm sorry.
Thank you, Judge. When I ask you if you recall hearing anything or anyone saying anything, I don't necessarily want you to say what they said. That's not allowed. But just if you recall hearing anything.
No.
Do you recall having conversations with your brother where he expressed anything concerning to you about his son?
No.
Do you recall your brother expressing any conversations he's had with his son that were concerning to you?
No.
Do you recall how long they were there?
I think I'm not honestly too sure. 1.5 weeks, maybe a week.
Okay.
For sure, for a week.
So it was more than a couple of days?
Of course, yes.
And you saw them more than one time?
Yes.
And when I say them, I mean both your brother James and his son?
Yes, ma'am.
Do you recall seeing James and or your nephew any other time in 2021?
Yes, I went to Michigan with my father and my stepmother to visit. It was actually he knew my father was going, but I was a surprise to my brother. And we went to Michigan. We stayed at their house for about a week.
When you say
3 or 4 days, maybe.
When you say you stayed at their house, whose house did you stay at?
My brother James's house.
And was his son there?
Yes.
And you stayed for a few days?
Yes, ma'am.
Did you spend time with James and your nephew in those few days?
Yes, ma'am.
And I'm going to ask you the same thing. Do you recall seeing anything concerning?
No.
Do you recall your nephew saying anything concerning to you?
No.
Do you recall your brother talking to you about concerning conversations he'd had with his son?
So I just have to object to that question. Honestly, I should object to the last question regarding April as well. She can testify as to what she observed and but not what James said or not said.
Yeah, correct. Yes.
From your observations, did you see anything concerning in June of 2021?
Absolutely not.
And did you speak with your brother after June of 2021?
Yes.
Did you speak with your nephew after June of 2021?
Not directly, no. Heard him in the background, tell him I said hi, you know, he said hi, you know, things like that, but not directly, no.
So based on those interactions, although they weren't direct, they were kind of in the background.
Yes.
Did you observe anything concerning with your nephew between June of 21 and say November 30th of 2021?
No.
If there had been anything concerning that you had observed, what would you have done?
I would have addressed it, and if I would have known anything, I would have talked to him, I would have took him home with me if there was any kind of inclination that anything was wrong.
Would you have made your brother aware of it?
Of course.
Did you ever make your brother aware of anything that you were concerned about?
No, because there was nothing I was concerned about.
I have no further questions, Your Honor.
Ross.
Good morning.
Good morning.
My name's Mark. I'm going to ask you some questions. If anything I ask is confusing or sometimes I kind of go on a little bit, just let me know and I can rephrase the question.
Okay.
Now, James Crumbley is your brother, obviously.
Correct.
And you refer to him as a shooter. He's your nephew.
Yes.
Okay. The last time you actually saw the shooter was June of 2021. Your nephew?
You mean in person?
In person, yeah. The last time you saw him?
I think, Your Honor,
Oh,
but she's hesitating. I think I know what she's hesitating about. Do you want to discuss it at the bench?
can we approach? Yes. I think I know what it is.
All right, go ahead, Mr. Case.
Thank you. Before the shooting on November the 30th, the last time you saw your nephew was in June of 2020.
Correct.
Okay, and the last time you saw him before that was in April of 2021.
Correct.
Okay. And you, from the time of actually, you may not know this, but everybody's phones in this case were seized and analyzed. Did you know that?
Yes, sir.
Okay, including your brothers as well as your nephews?
Yes, sir.
So you're not here to tell us that you had a particularly close relationship with your brother, is that right?
We had a close relationship, but we lived in two different states, so it was mainly, it wasn't like close.
You wouldn't talk very often.
At least maybe once a month.
Well, according to the phone records on your brother's phone, it was far less frequent than that. Does that sound right to you? And I'm not trying to trip you up.
No. We talked on social media as well.
Right. So there's call log, actual device to device.
Right.
Then there's Facebook calls as well.
Correct.
And I show 2 Facebook calls.
Okay.
And then there's instant messaging, and there's 22 instant messages between you and your brother.
Okay.
And that's the entire year of 2021.
Okay.
And then there's some group Facebook messages
Right.
with other members of the family.
Okay.
Now, your nephew never wrote you a note that said, "Help me."
No,
did he?
sir.
And he never drew a picture next to that note with a gun, did he?
No.
Okay. And that would be concerning to you.
Yes.
Okay.
It would
And is
cause-
that what you meant to say, or is that what you meant when you said, what would you have done if you saw something of concerning nature?
I would have brought it up, yes.
Yes, that would be something significant to you as a mother.
To address, yes, of course.
I think it may have glossed over. I want to clarify. On the phone log, there's only 3 actual phone calls between you and your brother in 2021.
Okay.
Does that sound right to you?
Yeah, I
Okay.
guess.
Now, you were interviewed in November of 2023 by an investigator when your name was put on the defense witness list. Do you remember that interview?
Yes, sir.
And you were asked if you knew you were on the witness list, and you said that you didn't know at that point.
Right.
Okay. And then you said you would have nothing to testify on their behalf because you had no knowledge of the incident until after it happened.
Correct, I have no knowledge of the incident.
Okay. Then you said you didn't know that a gun was bought for your nephew prior to the incident.
I did not know about that weapon, no.
And during that interview, you were asked about guns in the family home back when everybody lived in Florida. And you said, well, you know, some firearms is something that wouldn't be out of the ordinary for someone to own back in Florida when you grew up.
Right,
Do
no.
you recall that?
Yes, I do
Okay.
recall that.
But then you said, having guns in the house wouldn't be out of the ordinary, but getting one for your kid would be. At 21 minutes into the interview,
Getting one as in,
giving a gun as a
no,
gift for
not
your
giving,
kid.
but to use at a shooting range or whatnot.
Well, I'm just
I would
reading
not say that.
your words, and again, I'm not
Okay.
trying to trip you up.
Yeah, no,
You
okay.
said getting a gun for your kid, that would be out of the ordinary.
Yes.
Thank you.
Yes, Your Honor, thank you. The prosecutor asked you about guns in the family home. And you were aware, or let me ask you, were you aware in April or June of 2021 if there were firearms in James Crumbley's family home?
Yes.
And what do you know about those firearms, if anything?
I know that there was a Derringer because I saw and held it myself when I was there in June.
And how did you go about seeing and holding it?
He took it out of his room. I had brought it.
Let me stop you. Who's he?
Sorry. My brother,
Okay.
James, took it out of his room to show, because it was, I guess it's maybe like an antique kind of ish gun. I'm not sure. I don't know really too much about them, but and I wanted to see it, and I hold it, and it was very heavy. And then afterwards, he put it back in its case and brought it back into his bedroom.
Okay. You said you're not very familiar with guns, right?
Correct.
The prosecutor asked you about a statement that you made about getting a gun for your kid would be, I don't remember the word he used, odd or something along those lines. Is that right?
Yes, ma'am.
Okay. What did you mean by that? It sounded like you were trying to explain that to the prosecutor, and I don't know if we heard it.
I mean, if you're getting a gun specifically for your child to use at his leisure, that would be wrong. But with adult supervision, and I don't see any problem with it.
I have no further questions.
Just real quick, when you were there in June, here in Michigan in June, I think, right?
Yes.
Okay. And James went and showed you the 22 caliber Derringer, the small gun.
Yes.
Okay. You said he went and where he kept it in his room.
Yes, sir.
And the whole family was there.
Yes, sir.
Okay. I have nothing else. Thank you, Judge.
All right, you can step down and I'll watch the step right there.
Yes.
Thank you.
Okay, so she did cross-examine the detective, their investigator, because he's been on this case forever. See if I can find the spot. This is that investigator.
All right, you may be seated. You are still under oath, right? Go ahead, please.
Thank you. Lieutenant Willis, the video we just saw had some split screens in that. Is that correct?
Yes, sir.
Okay, so just so we're clear, that was Mr. Wobrowski testified to nearly 100 surveillance cameras. He spliced the video together.
Yes, sir.
Okay, so that was just taking the same time, just different angles, the same hallway.
That's correct.
Sir, could you tell us, please, who was wounded on November 30th?
The wounded was Phoebe Arthur, Elijah Mueller, Riley Franz, Callie Osage, Molly Garnell, John Asciutto, and Aiden Watson.
Thank May I approach witness?
Sure.
This is admitted as People's One. Sir, what have I handed you?
This is the autopsy protocol for Hannah St. Juliana.
Sir, who was killed November the 30th, 2021?
That's correct.
This is exhibit 5. Sir, how old was Hannah?
She was 14.
And how did she die?
Your Honor, I'm going to object to the reading of the autopsy protocol into the record.
He's not
It's
reading.
been-
He's not reading the autopsy.
They're admitted as exhibits 1 through 4, correct?
That's correct, Judge.
All right, so I think it was a question.
How did she die?
She died of multiple gunshot wounds.
May I approach the witness?
Sure.
This is exhibit 2. What is that?
This is the autopsy protocol for Madison Baldwin.
And this is a picture of Madison and people 6 on the screen.
Yes.
How did she die, sir?
She had a gunshot wound to the head.
She was 17 years old.
Yes, sir.
This is exhibit 3. So what have I handed you?
Autopsy protocol for Tate Neard, and he was 16 years old.
And how did he die?
He died from multiple gunshot wounds.
This is exhibit 4. That's an autopsy protocol?
Yes, sir. This is for Justin Schilling. He was 17 years old.
And how did he die, sir?
Died of a gunshot wound to the head.
And those are the 4 students who were killed inside Oxford High School on November the 30th, 2021?
That's correct.
Another brother.
Cross.
Yes, Your Honor. Good afternoon, Detective Goodman.
Good afternoon.
Go back to November 30th of 2021, when you were made aware of the shooting at Oxford High School.
Okay.
You testified today that you were at the prosecutor's office,
I was.
and you were advised, you said by the prosecutor and her chief assistant, that was the chief prosecutor, Ms. McDonald.
Correct.
Okay, and her chief assistant came to the office where you were discussing another case.
We were in a conference room in their office and they came, yes.
The prosecutor asked you about these swear-tos that were conducted, both for the charges made against him and the charges alleged against his son as well, the charge made against his son. Do you recall those questions?
I do.
And the prosecutor confirmed with you that the process for the swear-to is open to the public.
That's correct.
You said that both the public and the media were present at the swear-tos for both Mr. Crumbley's son and also Mr. Crumbley.
That's right.
For Mr. Crumbley's son, you made note that Mr. Crumbley was not present in person for the swear-to in the arraignment.
Yes, I stated he was he was there on Zoom.
And if you recall, his son was also on Zoom for the arraignment. Is that correct?
His son was in custody.
Okay.
Yeah,
But he was not there in person in custody, if you recall.
that's correct.
After the Oxford High School shooting on November 30th of 2021, do you recall receiving tips and receiving information and were made aware of concerns for the safety of James and Jennifer Crumbley after their son's name had been made public, if you recall?
I don't recall that.
Do you recall that their residence had been identified publicly?
I don't recall it, but if I can explain, I think I do know that there was media was there, but I don't recall it being released anywhere, if that makes sense.
And I'm not suggesting that law enforcement released that location. Obviously, you talked about the social media posts,
Yes.
that there was a lot of information coming into you and your department. There was a lot of information being made public that wasn't necessarily true. There was a lot going on at the time. on November 30th of 2021, separate from the tragedy at the school.
That's fair.
You said that on December 2nd of 2021, that you and the prosecutor's office were having discussions about possibly charging James and Jennifer Crumbley.
That's correct.
You know that at some point on December 2nd of 2021, not necessarily the nature of the, or I'm sorry, not the content of the discussions, but the nature of the discussions about potentially charging was made public.
I'm not familiar with that.
If you recall, there were media reports and information put out into the media that James and Jennifer may be facing charges.
That may be true. At that point, I was completely involved. Like, there was things that came out in the media that people tell me about today I have no idea about, because I wasn't.
Yes, and you had a lot going on. And obviously, when I ask you a question, I'm just asking you questions
understand.
about what you know about.
I understand.
You knew on December 2nd, you testified today that you knew on December 2nd of 2021 that James and Jennifer Crumbley were not staying at their residence.
Yes.
You knew that they left on November 30th of 2021.
Correct.
And that was before charges had been announced against them,
Yes.
and before there was any sort of information that may have been put into the media that charges may be forthcoming.
Yes.
That was in fact the day of the actual Oxford High School shooting that they stopped staying at their residence.
To my understanding, yes.
The prosecutor showed you Exhibit 362, which is a Holiday Inn Express receipt, correct?
Yes.
And if you recall, the room was registered to Jennifer Crumbley,
I believe you.
if you recall.
I don't recall, but I believe you.
You know that at some point on December 1st, James and Jennifer left. Oh, and before I go past that, you also know that on November 30th that James and Jennifer Crumbley obtained those track phones from the Walmart in Lapeer.
Yes.
And we looked at that receipt as well.
Yes.
And you testified that you learned during your investigation that there was a conversation either with Detective Sergeant Brian or Lieutenant Marsden about James and Jennifer obtaining those phones.
Yes.
And the purpose was because they had given their phones to law enforcement and they didn't have any way to communicate with people, if you recall the information they were given.
They were taken in a search warrant. Whether they gave them to, I guess, is subjective. But yeah, we obtained them, and it's my understanding the advice given to them, which again isn't uncommon, is that purchase some track phones so you could maintain communications.
Exhibit 365, you know that on December 1st of 2021 that James and Jennifer left that Holiday Inn in Lapeer and checked into an extended stay in Auburn Hills.
What day did you say?
December 1st of 2021.
Yes.
Now Lapeer, for those who aren't familiar, is north of Oxford.
It is.
It's north of Auburn Hills.
It is.
So they left the Lapeer area and came down to Auburn Hills, which is 15 minutes south of Oxford. I could be wrong about the time.
But you referenced Lapeer essentially borders Oxford.
Okay.
And
on the north
side, and then you got Rochester. 20 minutes. I don't know.
Okay, I won't lock you into a time. But they came and they came slightly south of, still in Oakland County, correct?
Yes.
Okay. You noted specifically that there was an Auburn Hills Police Department across the street from the extended stay.
Yes.
Now, you know that Jennifer and James Crumbley checked out of the extended stay on December 3rd of 2021.
Yes.
Which was that Friday.
Yes.
You don't know what time they left the hotel, correct?
If the checkout's on the, but do I know? No.
You know what time checkout is?
Yes.
Based on the receipt and the documents, correct?
Yes.
But you don't know what time they left. Whether it was at checkout or before, you have no idea.
That's right.
At some point on Exhibit 368 is the T-Mobile receipts from the T-Mobile in Owasso.
Okay,
Those are dated December 2nd of 2021, if
okay.
you recall.
Yes, I do.
And there was some conversation about the distance that Owasso is from Auburn Hills, because on December 2nd of 2021, James and Jennifer Crumbley had been staying at the extended stay in Auburn Hills.
Yes, and I believe they went to Owasso to get their phones.
Right. They drove to Owasso to get their phones and then went back to the extended stay from.
Yes,
So they didn't stay in Owasso, correct? Overnight, to your knowledge.
no.
Now, you are aware that after the Oxford High School shooting, there were a variety of reactions and emotions to what occurred at Oxford High School. Yes. Terror.
From whom?
Anyone at the school.
More than likely.
There was anger.
Are you
I'm
just
speaking
talking
in general. In general.
I would guess after an incident like that, every emotion imaginable could be
right
put out there.
You're aware that once the identity of the shooter at Oxford High School was made public, you were also made aware during your investigation that a lot of that anger, or some of that anger, was directed toward the parents of the shooter, James and Jennifer Crumbley.
I can't say specifically, no.
Exhibits 371 and 372 were the videos from 1111 Bellevue in Detroit. You noted that there was a difference of 22 minutes on the timestamp on the video from the actual time.
Yeah. Okay. Yes.
So the video was 22 minutes ahead of what the actual clock time was, if you recall.
I think that's right.
The video, I believe it's 371, shows that James and Jennifer arrived at approximately 10:59 a.m. at 1111 Bellevue.
Okay.
And that was prior to the swear-to that you testified was conducted at noon.
That I believe it was around noon, correct?
Okay. And again, I'm not asking you to lock in on the exact time, if it was 12:01 or 12:02 or whatever the time may be, but 10:59 is obviously before around noon.
It is.
And the two videos that you were shown, that Exhibit 372 is after 4 p.m., where it shows that James Crumbley walked out of the building and turned the car around and then went back in the building.
Yes. Was it 417 or something like that?
Correct. So the two clips that you saw, there were actually many, many clips from throughout that day, if you recall, that you've reviewed as part of your investigation.
Yes.
In fact, as part of your investigation, you reviewed those clips and know that one or both of James and or Jennifer Crumbley were in and out of that building on more than one occasion on December 3rd of 2021.
I don't recall.
Do you recall that there was video of James specifically leaving the building to smoke and going back in on more than one time?
I can't say. I don't know.
And we heard, you were in here when Investigator Creer testified.
Yes.
And he talked about finding, I believe he said 14 cigarette butts next to the Kia.
Yes.
In the 1111 Bellevue parking lot.
Mm-hmm. Yes.
So you don't specifically recall whether or not James and Jennifer did leave the building. You don't recall whether they didn't. It's fair to say you just don't recall.
That's right.
You testified that at 4 o'clock, a judge ordered James and his wife to turn themselves in.
Yes.
You don't know whether James had knowledge of that order from the judge.
I mean, it's safe. I mean, there's some evidence in my mind that points to that he was aware.
you did not see anything in your review of the case and of the evidence that you've obtained in this case to suggest that James was not going to turn himself in. And I'm not asking about anything that you've seen that you may or may not be able to talk about, but I'm asking specifically, you haven't seen anything to suggest that they weren't going to turn
Judge, I
themselves
have to object to the form of the question. You can't try to pigeonhole a witness if he has more information and then limit the answer in his base of knowledge.
Well, it was kind of a long question too, so, but you specifically asking him.
Your Honor, I'll rephrase my questions a little bit, because there was multiple questions. You asked, and we heard the testimony, you asked retired Sergeant Hendrick to locate James and Jennifer Crumbley on December 2nd of 2021.
That's correct.
That was on the date that there were discussions about potentially charging James and Jennifer Crumbley.
That's correct.
On December 3rd of 2021, they had not been located at that time, earlier in the day.
What time?
Before dark.
No, they weren't located.
They were
To my
located,
knowledge, they weren't located.
right. To your knowledge, they were located later in the day, and we heard the testimony about that information, correct?
Yes.
You testified about a video, I believe you said it was posted on Twitter, of the shooter, a Molotov cocktail or something?
It was, I believe it was a YouTube video.
Okay. You have no information that James was aware of that video?
No.
Now, Exhibit 16 is a photograph of the backpack and contents in the bathroom that we looked at.
Okay.
The photo shows that the journal that was in the backpack was open, and I believe you testified that that was opened by law enforcement.
To be honest, I'm not, so if I can recap that, the Michigan State Police bomb squad went in there. They arranged the items to my understanding, and that's how, the first time I saw that, that's how it was.
Okay, so you don't have any specific knowledge about how that was opened or who opened it. You just know that when you saw the contents, that's how they were as they were in the photograph.
Right.
You identified the journal as that of the shooter because his name was in it.
Yes. Among other things.
Right. You said also the writing matched homework that you saw and things of that nature. The first date that you have written in the journal you testified was November 9th of 2021.
I believe that's right.
You indicated that there were references to incidents prior to November 9th of 2021, but you don't specifically know what the dates were that those incidents were written about. Is that fair?
I think I might,
Based on reading the journal.
based on everything I've read.
Okay. So based on everything you have about all the knowledge you have about the case that you learned after November 30th of 2021, you may have additional information.
Yes.
But looking at the journal, you can't tell from the dates. There aren't dates other than November 9th of 2021, and I think there might be a couple other ones referenced.
You're correct.
Okay. You testified that the journal appears from back to front. So opening the front cover, there would be no writing, but if you flip to the back, then it's the 22 pages from the back forward that have writing on them.
It seems that way, yes.
And again, I think this is an obvious question, but I'm going to ask you. You have no indication that James Crumbley was aware that that journal existed, correct?
No, I think I know he knew it existed.
That that journal existed.
Yeah, he mentioned it in his counseling session that why didn't you write, you can write in your journal.
Right, and we heard from the counselor and we heard from the dean of students, who both testified that there was a mention of a journal, but that there were no specifics given. It doesn't say the journal in your backpack, the one you always keep with you. He didn't provide colors. He didn't provide any descriptive detail. We saw in the search warrant photos that were taken that there were additional notebooks and, could be journals in the shooter's bedroom. He references a journal. The school counselor and the dean of students mentioned a journal, testified about a journal. They indicated that James Crumbley said, you have a journal. But there's no specifics given about what that journal is. Is that fair?
That was a long question.
It was a very long question.
Can,
Yes, there were no specifics given during that meeting at the school about whether James had any knowledge of what the journal looked like, if he knew what was in it, or anything like that.
no.
Specifically, pages 15 and 22 that we have, that were admitted as Exhibit 359. On page 15, if you recall, the shooter is writing about wanting a 9mm, and then he's mad because he wants to get it because that's what he wants for the school shooting, correct?
Can we put it?
Yes. In fact, I can hand this to you because I don't have it electronically. May I approach, Your Honor?
Sure.
Thank you. It's flipped open to page 15.
Thank you.
You're welcome.
So I'm sorry, what was your question, Counselor?
Page 15.
Okay.
There's some mention about the shooter wanting a 9mm gun. He wants it for the school shooting. And he's mad that he hasn't gotten it yet.
I'm not. Yes.
Okay.
He's pissed.
Pissed is the word he used, correct? Page 15 also includes this statement. He mentions the Caltech and says he has to find where his dad hid it.
Yes, that's what it says.
If you'd like to. Yes. I'm going to go to page 22 next, Mr. Keese. Mr. Keese is going to put them on the screen for you.
Thank you.
May I approach, Hannah? Thank you, Mr. Keese. So that's the page 15 that you just looked at, correct? The portion that I asked you to look at.
Yes.
Page 22. If you could go to page 22, Mr. Keese, thank you.
There's a few 22.
Page 22, the binding.
Which exhibit number is this?
359, Your Honor.
Thank you.
Page 22, and again, we discussed that this was written along the binding, so along the inside edge of the page, correct, in the journal?
Yes.
And it says, I will have to find where my dad hid my 9mm before I can shoot the school, correct?
That is what it says.
Now, we know based on the testimony that you've heard, and you've been sitting in court during the trial, we know that there was a 9mm handgun purchased on November 26th of 2021.
Yes.
That the
correct.
shooting at the high school occurred on November 30th of 2021. That the shooter and his mom went to the shooting range on November 27th of 2021. So this portion would have been written at some point between November 27th of 2021 and arguably the morning of November 30th of 2021.
Well, now you've confused me. I don't.
Well, we know that there was no 9mm handgun in the house until November 26th of 2021, correct? Based on your investigation.
I see the 9mm.
Yes.
Yeah.
Because this specifically references a 9mm.
It does.
This is different than the other on page 15, which specifically references the Caltech.
I got you.
So, although Mr. Crumbley's son says my 9mm, we know that there was a 9mm purchase on November 26th of 2021.
Yes.
That he went to the shooting range on November 27th of
Yes.
2021, and the shooting occurred on November 30th of 2021.
Yes.
So we know, and this page was page 22, which would have been the back cover of the journal. Is that fair? If you recall? If you don't, it's okay. But we can read this and know that it would have been written after definitely November 26th of 2021.
Yes.
On page 3 of the journal, Mr. Keith, if you want to page 3. Thank you. Access. Yes. If you look at the third line of this entry, it says, I have access to the gun and the ammo. Do you see that?
I do see it.
Now, you don't recall seeing anything in this journal or even around this entry that says, my dad told me where the gun and ammo are, correct?
Can you repeat that, please?
Yes. You don't recall reading anything in the journal that says, my dad told me where the gun and ammo are.
I do not.
You don't remember reading anything in the journal. You didn't see anything in the journal that says, my dad showed me where the gun and ammo are.
No, I didn't read that.
So when it says I have access, you don't know how he obtained access. Is that fair? It just says I have access, exactly what the words are.
Can you repeat that? I'm sorry.
Yes. Reading this journal entry and the information that you have that you've read in the journal, this doesn't say how Mr. Crumbley's son had access to the firearm. Is that fair?
That's right. Just simply that he had access.
Simply that he had access.
Understood.
Thank you. I have no further questions, Your Honor. Redirect.
Briefly, thank you, Judge. Starting off with the journal here. You were asked if James Crumbley knew it existed, and you indicated that you believe that the answer was that yes.
Yes.
Okay, so you were here for Mr. Hopkins' testimony as well as Mr. Ejak's testimony. Of course, you're the officer in charge of the investigation. In that meeting with James Crumbley, did he say journals, plural, or journal as in singular?
Just a singular journal.
Okay. And there were notebooks found in the home, 112 East Knox. We saw a picture of that. But were there any other journals found?
There were not.
Okay. And you indicated that you believe that you can tell approximately when the journal entries were written based upon the content?
Yes.
Okay, so I guess we didn't really go over it in direct examination, but there was an incident on November the 4th, 2021 at Oxford High School. Was that referenced in the journal?
It was.
And an incident that occurred November the 11th, 2021. Was that referenced?
Yes.
Did the shooter reference his friend who left the state October 31st?
He did.
Okay. Was there any indication anywhere in the journal that the 9mm was locked up?
No.
And we saw evidence in this case that the shooter obtained access to the Kel-Tec pistol as well.
Yes.
Okay, and that text message was, look what my dad left out.
Correct.
Okay. And what we have on the screen here, page 3, first off, I got my gun. It's an SP-2022 6-hour 9mm. Second, the shooting is tomorrow. We know, of course, the shooting occurred November the 30th, 2021. Can you presume a date on this passage? So this would be November the 21st, presumably?
Presumably.
Okay. Second, shooting is tomorrow. I have access to the gun and ammo. And of course, we know that he did obtain that weapon.
We do.
Okay. And we know that the murder weapon from November the 30th was the weapon purchased by James Crumbley on November the 26th, 2021.
Absolutely.
Nothing further.
Brief request or brief question? Very brief. And I don't mean to belabor the issue, but when it comes to journals or notebooks, you don't know what James calls a notebook, what he calls a journal. You have no idea. Is that fair?
That's not fair. I do know what he calls a journal because he called it a journal in the meeting with Mr. Hopkins.
Right. He said something about a journal.
He did.
You don't know if he's talking about a notebook. You don't know if he's talking about a journal, like a diary with a lock on it. You have no idea what he's talking about.
I got a pretty good idea he's talking about a journal. That's what I can say.
Right. A journal.
A journal.
The reference to the Kel-Tec that Mr. Keith just asked you about was in August of 2021, correct? He asked about the video that we saw, the text that Mr. Crumbley's son sent to his friend about my dad left it out, LOL, or something along those lines.
Yeah.
That was in August of 21.
Can you show me?
If you recall.
I don't recall.
You don't recall seeing anything from November of 21 in the journal or otherwise saying that Mr. Crumbley's son had access because Mr. Crumbley left a gun out in November of 21 or in the journal, correct?
Ask that again, please.
Sure. You don't recall seeing anything during your investigation from November of 21 that Mr. Crumbley had allegedly left a firearm out in the house and his son talked about it.
This is beyond the scope of my redirect.
I still don't understand the question.
Sure, Your Honor. Mr. Keese asked about the text that was sent from Mr. Crumbley's son to his friend about his dad allegedly leaving the Caltech out.
Okay,
And he filmed a video of himself.
okay.
I'm trying to clarify that that video was in August of 21. I mean, if I need to, I'll pull up the exhibit, but I was just trying to clarify with the detective lieutenant.
Okay, I think if you show them the exhibit, you'll be able to decide, but do you stipulate that that was from August of 21?
Were we talking about the Caltech?
Yes.
Sorry, yes, August 18th, 21, and August 20, I'm sorry.
August 9th.
I did it again. August 19th of 21 and August 20th of 21.
Okay, tell you what it's in the box.
Your Honor, they stipulated to the date, so I don't need to ask again.
Okay.
Thank you, Your Honor.
I just, based on that, there was evidence that we introduced in this case that the shooter filmed a video of himself holding the 6-hour 9mm handgun November 26, 2021.
Yes.
Okay. And there were also Instagram posts of him holding that same firearm on the 27th.
That is correct.
Okay. And I think I misspoke earlier. I said November 21st as far as this passage being written. This would actually be November the 29th of 2021.
Yes, sir.
Thank you. I'm sorry about that. Thank you, Judge.
All right, can he be excused?
Yes, sir.
All right,
All right, you can
let's
step
move
down.
over to this one. And now we are going to watch what happens when they ask James if he wants to get up and testify. And you guys probably already know the answer to this by now, but
The jury instructions.
I'm going to play it anyway.
No, Your Honor.
I'm going to give you a set of them to make sure that you agree with them before closings.
Thank you, Your Honor.
And Ms. Lehman, would you like to inquire of your client?
I would, Your Honor. Mr. Crumbley, will you please stand up? Thank you.
Mr. Crumbley, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth so help you God?
I do.
All right, you can put your hand down. And would you state your name?
James Robert Crumbley.
All right, go ahead, Ms. Lehman.
Thank you, Your Honor. Good morning, James.
Good morning.
You know that you and I have talked about your trial. Is that right?
That is correct.
We have talked about how the trial will go.
That is correct.
You know that when you were accused and charged with these offenses, that you have the right to remain silent.
That is correct.
We discussed that that right carries through the trial.
That is correct.
You and I have discussed the whether or not you would testify during your trial.
That is correct.
We talked about the benefits of you testifying.
That is correct.
We talked about the risks of you testifying.
That is correct.
And we've talked extensively about whether or not you would testify.
That is correct.
And knowing all of that, is it your decision to testify or is your decision to remain silent?
It is my decision to remain silent.
Mr. Crumbley, do you have any questions for me or do you need any further discussion with your attorney?
No, I don't believe so. Thank you, Your Honor.
Okay. All right. I think we're releasing the jury right now. I want to caution everyone that's here to be cautious about interacting with anyone in the courthouse. If someone were to say something or do something in front of one of the jurors, it could be devastating.
She is a stickler about that. I don't blame her, though. I do not blame her. All right, now let's go up to the closings. Let's close this out. We'll start with the prosecution.
You know what my least favorite part of the trial is? It isn't listening to the defense argue that her client is not guilty. She has a right to do that. It isn't even listening to what I believe, and I'm going to tell you what I think is inaccurate. My least favorite part of the trial is that even when we're standing here and our criminal justice system provides for justice for victims, and my job is to advocate for them, and I'm standing up here and I'm doing that. I've been doing that all week and several weeks before, and I'll keep doing it. You know what my least favorite part is? It doesn't take away any of the suffering. Doesn't take it away. So don't deliver a verdict thinking that it will, because it doesn't. Your job is to follow the law and use your common sense when you consider the evidence. I embrace the high burden of beyond a reasonable doubt. I believe in it wholeheartedly, devoted my whole life to it. I embrace it. It's what we use for every prosecution in this country, every single day of every year, for decades and decades and decades. That's the burden we have. And it is not, despite what the argument is always, any possible doubt. You have to be 100% sure. If you're 100% sure, we probably don't need criminal trials. And you can't be. We can't be. That doesn't make any sense, does it? We can't get inside the head of people who commit violent crimes or any crime and decide what they knew and what they wanted and if they loved their kid. I hope he did. I hope he does, by the way. I assume he does. We all do. We all love our kids. That's not my job. It's not my burden. So I embrace my burden, but I'm not going to embrace something that's just not true, because it is not true that I have to prove, and the people of the state of Michigan have to prove, what James Crumbley knew. It is not true that the people of the state of Michigan have to prove that he knew his son was going to kill somebody. We've talked about this before. If that were the case, he'd be charged with murder. That's not my burden. That is not what I have to prove. The judge is going to instruct you what burden. It's a reasonable burden, and it's as to the elements that I have to prove. Only the elements. Beyond a reasonable doubt, using your common sense and your reason. The elements. And what are the elements? You're not going to hear that the elements of this crime are that I have to prove what he knew, what he actually knew. That's not the law, ladies and gentlemen. That is not the law. The law is I have to prove beyond a reasonable doubt what a reasonable person would do using ordinary care. That's what I have to prove. There's a couple things I have to correct. The questions defense counsel asks witnesses are not evidence. It's the answers that are evidence, and you have to decide whether that's credible. But Special Agent Brandon did not testify that it was safe. He would call that secure if an unloaded gun was stored separately. In fact, that's not what he testified. What he testified to was that it wasn't storing the firearm or ammunition wouldn't make it secure if you had a 15-year-old who knew how to load and shoot that gun. That was his testimony. You did not hear from people at the school that they were not concerned. That was not the testimony. You did not hear that James Crumbley went home because he was trying to check on his son and he was worried. None of that happened. You heard the 911 call. You have to rely on what you heard, not the questions that were asked. Defense counsel put up a statement from the Journal about my gun and where my dad hid it. And she's urging you to find that credible. But if you do, and we argue you should find, it's all credible. You don't get to pick one statement from a journal and say he was telling the truth there. But all the stuff about how he asked his dad for help, that wasn't the truth. You have to use common sense. And I'm not gonna go through every single thing that Ms. Lane told you, because I know that you were all taking notes and you all listened to it. And I laid out, and I know you remember the testimony. But the one thing I'm just gonna ask you one more time is, I embrace my burden, but you have to hold me to the law and what I actually have to prove and what the judge tells you I have to prove, which comes down to common sense and reasonableness. Let's step back. We have a person, we have a father who purchased a gun as a gift. He has it. He knows how to use it. He knows he's in the house by himself after it's purchased. He gets called to the school. He gets called to the school, and the words on the paper, the drawing on the paper is of that gun. You heard Special Agent Brandon. The testimony speaks for itself, and so does the drawing. Words, blood everywhere. He saw the image on the paper with the bullets and the person bleeding. He understands exactly, because the image there, and you saw it, that's exactly where those bullets landed. The thoughts won't stop. Help me. I want help, but my parents don't listen to me, so I can't get any help. And then that day, just hours before, help me. Use common sense. It doesn't make any sense to stand here and say someone had no idea that he needed help when he saw on the page, help me. It doesn't make any sense, because any reasonable person, which is the standard you have to use, using ordinary care, would know that, because it actually says, help me. The world is dead. My life is useless. Those messages you saw, that's exactly what he thought. We know what was going on because of the messages in his journal. And then we know there was a cable lock. You did not hear any testimony about who owned that gun and whether that lock was used or another lock was used. But you do know that whoever purchased that gun had to be 21 years old. You do know that. We've been telling you since this case started, it would take tragically small things to prevent these deaths. And you're hearing a lot about how to store a weapon. And the truth is, this has nothing to do with a safe storage lock, and you don't have to lock a weapon up to make it secure. There's lots of ways to make it secure. But what isn't secure is leaving it around, which we know he did with his other weapon, leaving it around. My dad left it out, LOL. I thought, why not? Loaded, knowing that your ammo is right there. We know that is not secure. But let's talk about one of the ways that we can prevent access to minors. This is the murder weapon. This is the gun. We know we presented evidence of this. I'm going to put it right on the table. This is a cable lock. This little piece of cord. This is me inserting the cable lock. We know that a cable lock was in the home. We know it was provided. This is me inserting a cable lock. That takes less than 10 seconds. It takes less than 10 seconds. 10 seconds. You don't have to go find it. You don't have to go buy it. It was provided. It was right there. You just watched me do it. 10 seconds of the easiest, simplest thing. One of which, by the way, not the only way. Locking was not the only way to prevent this, but it was one way, and it took less than 10 seconds. Let's talk about the gun being hidden. Let's talk about that. You heard the defendant's sister say, yeah, he went and got the gun from his bedroom. These are the other two guns. Ladies and gentlemen, The guns were kept in the bedroom. The family was there when she was told that, and everyone knew the guns were kept in the bedroom. This is where he says he hid the gun, the armoire. This is what it looked like that day. Wet towels folded over it. It wasn't even closed. He says it was in the armoire under some jeans. This is not hiding a weapon. This is just where you kept it. It is not reasonable to conclude that a 15-year-old who spends all kinds of time in the house alone would not know where it was, because it wasn't hidden. This isn't a case where we have a parent who hides a weapon far out of reach from a child who couldn't get to it, doesn't know it exists, ammunition in a totally separate spot. The kid, that's not this case. It's reason and common sense is what we have to use. We know that James Crumbley went home and looked for a gun when he heard there was an active shooter. And we know he referenced there was that meeting at the school. That's foreseeability. And that's a person who suspects their own son. And that is what I have to prove. Foreseeability to an ordinary, a reasonable person using ordinary care. This case is not a statement about guns. It's not a statement about parental responsibility. It's not about kids doing kids things. The kids on November 30th in that building were doing kids things. Hannah, Madison, Tate, Justin, they were going to class. They were talking to their friends. They were dancing in the hallway. Those are kid things. Parenting is the hardest job that we'll ever do. The hardest job and one of the most important ones, but it's exhilarating and joyful and the best experience of our lives. We look at our kids when they're born and we see hope. But they can break your heart. They're supposed to. They have to leave someday. They don't come with a set of instructions. I'm not here to tell you that this case is about somebody who didn't follow the instructions to be a perfect parent. But we do have a guide. We do have a basic standard for ordinary care. We all have doubts about our kids. We all worry every minute of every day that they're going to do something or something's going to happen to them, and then it might be because of something we did or we didn't do. We are not responsible for everything our kids do. This prosecution in this case is not inconsistent with that. It just isn't. This is a very egregious and rare set of facts. We do have a measuring stick, ladies and gentlemen, and it's the law. And it requires us to use ordinary care. And there is a consequence if we don't, in a very limited way that the law allows a parent to be charged. Your job now is to go back there and use your reason and common sense and follow the law. That's what your job is. You listen to all the evidence, and at the end, you will conclude that James Crumbley failed. He might love his kid, I hope he does. But stick to what I have to prove. Stick to what I have to prove. And remember that he didn't just fail in his duty to his son. He failed in his duty to protect Hannah and Justin and Madison and Tate. And I don't say their names to evoke sympathy. I say their names because they matter. They matter. And that is why we are here. We are absolutely here about what happened in that school that day, because if James Crumbley had done even the smallest of things, like the 10-second cable lock, or gone home, or took responsibility for his kid who was in trouble, those kids wouldn't have been shot and killed in that school on that day. I have met my burden. Mr. Keast and I, the people of the state of Michigan, have met the burden to find James Crumbley guilty of 4 counts of involuntary manslaughter. And I ask you to return that verdict. Thank you.
Thank you, prosecutor.
There were a variety of emotions following the shooting on November 30th of 2021 at Oxford High School. Terror, anger, and devastation. There's an epidemic of mass shootings in our country. School shootings in particular have devastated our communities. There have been social and political groups formed to address these issues, but so far they've been unable to do so. However, on December 3rd of 2021, the parents of a school shooter were charged with involuntary manslaughter for the first time. When we started this trial, I said that the events of November 30th of 2021 undeniably changed people's lives in ways that most of us will never understand. We know that 4 children were killed, multiple families were devastated, and communities were terrorized. And ladies and gentlemen, James Crumbley and I do not dispute any of that. We heard from people who were at Oxford High School on November 30th of 2021. We not only heard what they had to say, we saw the impact that that day had on them. Multiple people told you what that day was like. They told you what they felt, they told you what they saw, and they told you what they experienced. You were also shown videos of what happened inside of the school on November 30th of 2021. We can agree that you all heard a lot about what happened inside of Oxford High School on November 30th of 2021 through videos and testimony. This case is not about what happened inside of Oxford High School. This case is about what happened outside of Oxford High School. This case is about what James Crumbley knew on and before November 30th of 2021. James Crumbley was charged on December 3rd, 2021 for the deaths of Hannah St. Juliana, Madison Baldwin, Tate Meir, and Justin Schilling. As you've seen throughout this trial, the charges and allegations against James were based on assumptions and hindsight about James and his knowledge about his son, who we've referred to as either his son or the shooter. The prosecution is asking you to second guess the decisions made by James Crumbley on November 30th of 2021 and before those days. And as Sean Hopkins told you, it's easy to look at things in hindsight. But we aren't here to look at things in hindsight. We are here to look at what James Crumbley knew prior to and on November 30th of 2021 before the shooting began. You heard no testimony and you saw no evidence that James had any knowledge that his son was a danger to anyone. You heard no testimony and saw no evidence that James Crumbley knew what his son was planning. You heard no testimony and saw no evidence that James Crumbley was aware that his son knew where the firearms in the home were hidden. You heard no testimony and saw no evidence that James Crumbley was aware that his son had obtained access to those firearms and had handled them unsupervised. Still, the prosecution wants you to find that James could foresee that his son was a danger to others, and that James acted in a grossly negligent manner or breached a duty that he owed to other people, despite having no information at the time. You obviously know that the defense has no duty to present a defense. We talked about that during jury selection. The judge will give you instructions on that and the law on that. But we did bring out more information so that you all had a more full picture, a more complete picture of what happened in the days leading up to November 30th of 2021, and even on November 30th of 2021. But in the end, if you have any questions, if there's anything that you're unsure of, if there's anything that you're wondering about, the prosecution was the only one that had a burden of proof. When it comes to burdens of proof in this country, beyond a reasonable doubt is a very, very high burden. In civil cases where people sue each other for money, the burden of proof is 50-50. Preponderance of the evidence, whether or not somebody gets money and somebody has to pay money. In cases where the state wants to take your child due to abuse and neglect, it's clear and convincing evidence, a little bit higher. Beyond a reasonable doubt is the highest burden in our country, the highest burden of proof as it relates to criminal prosecutions. Judge Matthews is going to instruct you that reasonable doubt is just that, a doubt based on reason and common sense. It can be based on the evidence, or it can be based on the lack of evidence. When it comes to reasonable doubts, you can have one or you can have 10. You don't have to have the same reasonable doubt as your neighbor. What matters is that if a juror has a reasonable doubt, then they must vote not guilty. You can believe that if the prosecution had evidence that James Crumbley knew that his son was a danger to others, you would have seen it. Especially if James knew what was inside of that journal. We've heard about the journal. If James knew what was in that journal, the prosecution would have told you that. If James knew that his son had gained access to his firearms, the prosecution would have told you that. You definitely would have seen it. And the fact that you have not seen any of that evidence can be your reasonable doubt. You can also believe that if the prosecution knew that James Crumbley knew that his son knew where the firearms were stored, the prosecution would have told you that. You would have heard about it, but you didn't because James didn't know. He didn't know that his son knew where those firearms were. Absence of evidence that James knew that his son had learned where those firearms were can be your reasonable doubt. Also, if James had violated any laws as it relates to storage, specifically gun storage, you would have heard about that, but you didn't. In fact, you heard from ATF agent Brandon, who told you there are multiple ways to store a firearm. Multiple ways. You can use a safe. You can use a cable lock. You can use a trigger lock. You can store it unloaded with the ammo separately. You can store a firearm in any number of ways. That came from ATF agent Brandon. Those were his words. If the prosecution had evidence that James knew that his son was accessing firearms without his permission, not that his son was accessing them without his permission, that James knew that his son was accessing them without his permission, the prosecution would have shown you that. But you didn't see it because it isn't true. James didn't know. This can be your reasonable doubt. Mr. Wagrowski testified that James would have heard his son handling the firearm, the Kel-Tec that you saw the video of, where he sets the Kel-Tec on the table and loads the magazine. He slides the slide forward. He releases the slide forward. Mr. Wagrowski testified from this chair that James would have heard that because of the volume of the sound and because of the size of the home. You all have observed James throughout this trial. You've seen him. Judge Matthews instructed you at the beginning, James is wearing headphones. James is hard of hearing. He needs a hearing assisted device to hear, even in this courtroom. And if you watched, there were points where he had to push the headphones into his ears so he could hear better because he still couldn't hear well enough.
Your Honor, I hate objecting in a closing, but that is not evidence, and that her client didn't testify. And so it's just not evidence what he was doing. And it's just not, and his headphones are not evidence.
There's evidence that he needs a hearing device, as I explained to you in the beginning of the trial why he was wearing those headphones. Go ahead.
Thank you, Your Honor. Mr. Wagrowski also testified that he could not indicate and could not say with certainty where James was at the time that his son made that video. He knew that James was likely at the home. He didn't know if he was outside in the very large backyard that Detective Stoyak told you about. He didn't know if he was in the home. He didn't know if he was standing next to him. He didn't know if he was standing outside. He didn't know if he was in another room. He didn't know if he was sleeping. Mr. Wagrowski couldn't tell you what was going on other than James Crumbley's son handling that firearm. Was it unsupervised? We don't know. Was it supervised? We don't know. We don't know. So any statement by Mr. Wagrowski that James had to have heard that is an assumption. It's not based on fact, and it's not based on evidence. If the prosecution had evidence that James was concerned about his son's mental stability, or if his son had asked him for mental health treatment and it was denied by James, you would have seen that. Not a statement by his son to a friend or a writing in a journal, a statement by James that he acknowledges that his son was having issues, that his son was having a hard time, that his son needed help. None of you saw that. None of you saw that because it's not true. James had no idea that his son was having a hard time. Instead, you saw text between James's son and his friend in April of 2021, where his son says he's going to tell his parents about the issues he's having. You also heard testimony from James's sister who said she saw him within a day or two, maybe 3 days, of those texts being sent to his friend in Florida after their mother passed away. James and his sister's mother passed away. She spent a week or a week and a half and saw James and his son, and saw no concerns, not worried, didn't hear anything, didn't see anything, wasn't made aware of anything, no concerns. You heard that on November 30th of 2021, James drove his son to school. You saw the video of James dropping his son off. You heard that later when James went to the school with his wife to meet with his son and the school counselor, Sean Hopkins, and the dean of students, Nick Ejak, that James had told them, or that James had had a conversation that he had talked to his son that morning, told his son he loved him. We just want you to do your schoolwork. We want you to do your best. There was never a conversation about, Dad, I'm having a really hard time. Dad, I really need some help. In fact, there were no concerns expressed whatsoever. James had no knowledge that there was an issue. You also heard Sean Hopkins and Nick Ejak both testify that in the office, sitting in the office, that James sat next to his son, right in front of Sean Hopkins' desk, sat next to him, went over the piece of the math assignment with him, the drawings, what was on there, that he was caring, that he told his son, you can talk to me. You can talk to other people. There was some reference to a journal. There was no indication that James knew what the journal looked like, whether or not his son was even writing in a journal, where it was, how often he used it. No indication. Got there or after he arrived, from James's son to the school counselor or the dean of students saying, I really want some help. I'm really having a hard time. I really need to see someone. I've been trying to talk to my parents and they haven't been listening to me, and I need you to tell them. That didn't happen. Instead, Mr. Hopkins testified that he had concerns about the level of although appropriate, the level of sadness that James's son was experiencing. Sadness associated with the losses that he'd had that year. He lost his grandmother. He lost their Great Pyrenees dog. His friend moved away. He had a hard time with COVID. He struggled with virtual school. Mr. Hopkins was concerned about the sadness and wanted James's son to see someone to ensure that it didn't get any worse. Not that he had to see someone right now. It's an emergency. He has to see someone right now. That's not what was said. In fact, if you recall Mr. Hopkins' testimony, and I believe Mr. Ejak said the same thing, that James and his wife were told that the school was going to follow up with them within 48 hours. Now, in Mr. Hopkins' head, he testified he was thinking it was going to be the next morning, but he told them 48 hours. You heard Mr. Hopkins testify that James's son said he wanted to stay in school. In fact, he even asked for his homework while sitting in the office waiting for his parents. He asked for them to go get his homework. So they went and got his backpack. They brought it back. He started working on schoolwork. His attendance wasn't bad. There's some question about whether or not he missed one or more days of school that year, but his attendance wasn't bad. His grades weren't terrible. They were average, according to Sean Hopkins. There were no concerns, even by Sean Hopkins and Nick Ejak, beyond the sadness that they saw James's son was experiencing. The absence of evidence that James knew about the struggles that his son was having can be your reasonable doubt. You heard from James himself more than once. You heard him tell the police that there weren't any issues with his son. Within an hour of the shooting at Oxford High School, James was at the police station with his wife, interviewing with law enforcement, talking to them, saying, my son was a great kid. I think he used the word perfect. That his grades were mediocre, again, although Sean Hopkins said they were average. But that he'd never had any disciplinary issues. Sean Hopkins and Nick Ejak confirmed that. They had no disciplinary history with James's son. And even if you have a question about how great of a kid James thought his son was, Christy Gibson Marshall said the same thing to you. We'll talk a little bit more about that. But Christy Gibson Marshall also said that James's son was a good kid. Christy said that her testimony was that she was standing in the hallway. She had spotted the shooter coming down the hall with a firearm, with a gun in his hand. She saw that there was an injured student in the hallway. She walked up to the student, was standing next to it. You saw the video. She's standing next to the student who's injured on the floor. The shooter gets closer and she realizes that it's James's son. And her first thought was that it couldn't be right. With a gun in his hand, an injured student in front of her, smelling cap gun, she didn't think that was right. Even in those moments. Going back to Sean Hopkins and Nick Ejak, two people who met with and talked to James's son on November 30th of 2021, at one point for over an hour without James and his wife there. They talked about a variety of topics. This was 2 hours before the shooting began. They said that based on the explanations that they were given about the drawings on the math assignment, that they weren't concerned. Kids draw violent things. Kids draw guns and bullets. That the confirmation combined with the confirmation from James and his wife about what was going on in their son's life, in combination with the explanations that they were given by James and his wife's son, that they weren't concerned. There was an explanation about interest in video game design. They looked a little bit about video game design. Sean Hopkins and Nick Ejak weren't concerned on November 30th of 2021, 2 hours before the shooting started. Both Sean Hopkins and Nick Ejak told you that guns are not uncommon in homes in Oxford. It's a hunting community. That it's not uncommon for students to handle guns in their homes or to go to the shooting range. That they knew that James's son had gone to the shooting range the weekend before with his mom and that he had access to a firearm. They didn't ask any more about this, about access to a firearm or having a firearm in the home, because they weren't concerned that James's son was a danger to anyone. They weren't concerned. Sean Hopkins and Nick Ejak testified that they had concerns related to the effects of the losses that James's son had experienced in that year. There was testimony that James's son's level of sadness was appropriate given various factors, but that it wasn't concerning. They just wanted to address it to ensure it didn't get any worse, because they'd seen sadness get worse and have issues with other students, according to Sean Hopkins' testimony. We talked about Sean Hopkins and what he said about wanting James's son to see someone within 48 hours. You also heard testimony from Sean Hopkins and Nick Ejak that they didn't believe that, or they believed that James and his wife were going to get their son help, that they had no reason to believe that they weren't going to. And if they did, they would have done things differently. If they had concerns that it had to happen right now, they would have done things differently. But they didn't. Sean Hopkins and Nick Ejak testified that they didn't ask if there were guns in the home. They didn't ask because they weren't concerned that James's son was a danger to anyone. Despite the information and the concerns that they had, they made decisions with the information that they had at the time and based on their education and training, which we can all probably agree, a school counselor and a dean of students has more education and training than the average parent. And even with all of that and the experience with teenagers and what they had in front of him, they still didn't believe that there was a reason to be concerned that James's son was a danger to anyone. In fact, they didn't even feel that he was in immediate danger to himself, because if they had, they testified, they would have done things differently. James worked. You heard the testimony. He left the school at approximately 10:57, and if you want, you can go back through the exhibits. Logged on to the app for DoorDash and started working within 3 minutes. The prosecution is focusing on James not going home in the time from leaving the school and when the shooting started. Why would he? He didn't know. He didn't know what was going on with his son. He didn't know what his son was planning. He didn't know that his son knew where the guns were. And he didn't know that his son had somehow obtained access to those guns or a gun. He didn't know. So why would he go home? There was no reason to. You heard about James's actions following learning of the school shooting, or following the school shooting. You heard that he went to the Meijer, which was the reunification point on Ray Road. You heard that he saw the police lights. He saw multiple police cars. He followed them. He actually tried to go to the high school first, and he couldn't, so he went to the Meijer. And it was there that he learned that there was a shooting at the school, that there was an active shooter at the school. There's evidence and exhibits showing James's movements while at the Meijer. He was there for approximately 6 to 7 minutes. In that time, he texted his son. You can see that on exhibit 375. He called his son to see if his son was okay. He texted his son again. He called his wife. He talked to his wife for about a minute, and he left the school. Then he called his son 2 more times. 2 more times in less than a minute to find out if his son was okay. He talked to his wife again for about 10 minutes. You saw a text during that phone call from James's wife to one of her coworkers where she says that their son was the school shooter. Contrary to Detective Lieutenant Willis's testimony that James said his son was the school shooter, he didn't. James didn't say that. You heard the 911 call a few minutes ago. That's not what James said. James called 911 at 1:34 p.m. and said that his son was a student at Oxford High School, and that after he'd learned about the school shooting, that even during the shooting at the school, even after the meeting that morning with James's son and James and his wife, even in those moments, they did not suspect that James's son was the school shooter. Sean Hopkins testified that he didn't even think that it was James's son who was the school shooter until after he checked attendance, after the shooting had ended, and after James's son had been arrested. You heard James say on the 911 call that he was really freaking out. You've heard that a couple of times from James. And you can listen to that call yourself. It's Exhibit 154. You can almost hear, as James is talking to the dispatcher, how he's looking back at what had happened that morning and trying to piece things together and figure out what's going on. You heard from James 2 more times within hours of the shooting at Oxford High School, once at the substation and once while in the backseat of a patrol car. At the substation, James learned that his son was the school shooter, that he was not injured or anything, that he was in fact the school shooter. You heard James say he was freaking out. He asked for a water. His mouth was dry. He was freaking out. James was emotional. I believe that Detective Sergeant Bryan testified that James was sobbing, that he was crying. You can watch it. You can see how James was reacting in that interview. Detective Bryan said that James was forthcoming, that he was willing to speak with them, even after James's wife suggested, maybe we should get a lawyer. Maybe we should stop talking. James said, no, let's keep talking. I want to keep talking. It's okay. We can keep talking. And he does. He told the police how many guns were in the home, where they were located, that the handgun that was used by James's son in the shooting was a 9mm Sig Sauer. He mispronounced it. We've all heard that. That it was hidden in an armoire. No one in that interview, neither of those 2 law enforcement officers in that interview said, well, you shouldn't have had it there. Was it locked? How did your son get it? You didn't hear those questions. You heard James tell the police that the handgun was stored unloaded and that the ammunition was stored somewhere else. It was stored separately under some jeans. Again, those 2 officers didn't say, well, you shouldn't have done that. That wasn't right. Well, you did that the wrong way. Well, that was really irresponsible of you, Mr. Crumbley. They didn't say any of that. The police didn't ask if the gun was locked or in a safe. James clearly told them that that 9mm was hidden. And the police moved on. James talked about what a great kid his son was, about his mediocre grades, but overall he didn't get in any trouble. You watched as James saw his son for the first time after that school shooting. It was a very brief encounter. And you saw as James was leaving that he repeatedly told his son he loved him. Ladies and gentlemen, you can watch that for yourself. It is Exhibit 301. He repeatedly told his son he loved him. And then after, as he walks back into the first interview room, you can hear him audibly crying, sobbing at what was going on. And what does he say? He asks the police if he can find out where his son is going to be. And they say, yes, the court will tell you. In that interview, you also heard James Crumbley say, I wish we had taken him home. In hindsight, looking back, I wish we had taken him home. James had no knowledge that his son had access to any of the handguns in the home. You saw his son's own words sometime after November 27th of 2021 and before November 30th of 2021. And we know that because in Exhibit 359 on page 22, his son specifically writes 9mm. And we know that there was no 9mm in that home prior to November 26th of 2021. We know that James's son went to the shooting range on November 27th of 2021 with his mom. So we know that that had to have been written sometime between November 27th and November 30th of 2021. We talked quite a bit about this during jury selection. Most, if not all of you, agreed that there's a difference between having access and giving access. We talked about car examples. We talked about the responsibility in different scenarios, a parent's responsibility in different scenarios. This case is like the first car scenario, where the child takes the car without parents knowing, takes it out and something happens. This is the first scenario. This isn't the second scenario, where the parents might have suspected that their child might do something. This wasn't the third scenario, where James knew his son was going to do something and just handed him whatever it was he was going to do it with and said, here, take it. This is the first scenario, where James Crumbley had no idea what his son was capable of. He had no idea what his son was planning, and he had absolutely no idea that his son had access to those firearms. Also, as an aside, if it really were his son's gun, why was it hidden in James's bedroom? If it really were, why was it hidden? Not only in the bedroom, but in a location that James's son was not aware of. Sometime before November 26th of 2021, James's son wrote this in that journal notebook that was found. Exhibit 359, page 15. We know that it was before November 26th of 2021 because of some of the other statements that are around that journal entry, which you can look at if you'd like, but they reference a 9mm and a .22 caliber. And we know that there was not a 9mm in the house before November 26th of 2021. And even here, I don't know where my dad hid it, is a reference to .22 Cal-Tech. Even before November 26th of 2021, well before November 30th of 2021, James Crumbley's son didn't know where those firearms were. He told you he didn't, in his own words, in his own handwriting, which was verified by law enforcement. There's no evidence that James Crumbley had reason to believe his son would hurt anybody. I went over this a few minutes ago. Christy Gibson Marshall's testimony was that she had known James Crumbley and his son since approximately 4th grade. She told a story about James emailing her and asking about getting his son's report card or grades or something along those lines. And she responded and said, give him a hug for me. She testified about everything she saw, heard, and felt on November 30th of 2021. And as I said, she talked about seeing the shooter walking toward her with a gun in their hand. That as the shooter got closer, she recognized that it was James's son. And in those moments, she thought to herself, this can't be right. He's always been such a sweet kid. She was in such disbelief that was his son that she even tried to talk to him. As he's walking through the school with a firearm in his hand, she is trying to talk to him because she just can't believe that James's son was the shooter. And it was when he wouldn't respond that she realized it must be him. ATF agent Brandon testified there were no laws governing the storage of firearms. We went over this a little while ago. We talked about the various ways that you can store firearms. I outlined a few of them. He testified that people store firearms unloaded and unlocked, which in and of itself is not irresponsible or dangerous in 2021. Not putting a gun in a safe or using a trigger lock alone does not mean that that person is irresponsible. Now, ATF agent Brandon gave you his opinion about what he saw on that math homework. That opinion was given within the last couple of days. And with all due respect to Agent Brandon, his opinion on what he saw is irrelevant. It doesn't matter in this case. What matters in this case is what people thought that math homework showed on November 30th of 2021. And those people weren't concerned. They didn't see what Agent Brandon saw. They saw images that weren't concerning, that are common, that other kids write and draw about. The concern was that he was sad and needed to talk to someone. On November 26th of 2021, we saw evidence and heard testimony that James Crumbley went and bought the Sig Sauer at the gun store. James had been to that gun store on multiple occasions. We heard that testimony from Miss Back, who told you that she recognized him because he'd been there before. There were at least 2 other handgun purchases from that store, which we heard about, the .22 Derringer and the .22 Kel-Tec. James indicated, per Miss Back, that he'd been looking at the Sig Sauer for a few days or a while. She couldn't really remember which one it was. She testified to both. That he knew that that was the one he wanted to purchase. So he did. You also heard Agent Brandon testify about the cable lock that was found in that Sig Sauer gun case. That the sleeve that the cable lock came in was essentially in pristine condition, that the keys were still inside the lock. Now, if you recall, that Sig Sauer was used. James bought that used. That sleeve being in pristine condition means that the person before him didn't use it either. You also heard that James did not purchase ammunition on November 26th of 2021 or at any point prior to November 30th of 2021 for that 9mm. There were purchases for ammunition when you would go to the gun range for the .22s, but James didn't purchase ammunition before November 30th of 2021. Tammy Back told you that she had, that James didn't even talk to his son while they were standing there in the gun store. She didn't see any of that. She had no reason to believe that James was buying that gun for anyone but himself. And if she had, she couldn't have sold it. So obviously she didn't think that. On November 3rd of 2021, James Crumbley and his wife left a hotel that they had been staying in. Well, they had stayed in a couple different hotels, but they left the hotel that they had stayed in after the shooting on November 30th. You heard some testimony, or you heard some information that their residence had been made public, or there was media there, or there were things going on. And you can imagine, I mean, you all can imagine what that was like in the days following the shooting at Oxford High School. You heard Agent Brandon testify today that James and his wife were in and out of that building throughout the day on December 3rd of 2021. You heard testimony yesterday from Detective Willis that they arrived at approximately 11 a.m. and that they were there for the day. They were obviously arrested later that night. But you heard testimony that Luke Kirtley saw at least James Crumbley. You heard that James and Jennifer had both gone in and out of the building. Jennifer is his wife, had both gone in and out of the building throughout the day, various times to smoke, walk out to the car. Sometimes one of them went, sometimes both of them went. December 3rd, 2021 was a Friday. It was a work day. They were in and out. You heard that there were at least 14 cigarette butts found near their vehicle. You saw over 300 exhibits during this trial. You heard testimony from over a dozen witnesses. None of them told you that James knew what his son was planning. None of them told you that James knew that his son was a danger to anyone. None of them told you that James knew that his son knew where those firearms were hidden. None of them told you that James knew that his son had somehow obtained access to the firearms that he had been hiding. None of them told you that. Because on November 30th of 2021, James Crumbley had no knowledge about any of that. He had no knowledge, and he had no reason to suspect what his son was planning to do later that morning on November 30th of 2021. Now, every time I do a trial, I have somebody tell me that they think of a reasonable doubt that I may not have thought of. So think of your own. You don't have to agree with all of mine. You don't have to agree with any of mine. You can come up with your own reasonable doubt based on the evidence that you've seen, the testimony that you've heard, your collective memories. You can come up with your own. You're not limited to what I've come up with, and you can certainly reach your own reasonable doubt conclusions on your own. And as you deliberate, think about the things you did not hear during this trial. Think about the things that you were told you would hear during the opening statements, that you would hear how the shooter gained access to that gun. You didn't hear that. That you will hear from school officials regarding their concerns about the math worksheet. You heard that they were concerned about sadness, not about danger to others. That you will hear that the need for immediate parental intervention was necessary. You didn't hear that. In fact, you heard the opposite. You heard that Sean Hopkins said that James and his wife, that they wanted James and his wife to have their son talk to someone or to at least make arrangements within 48 hours. No one testified that immediate parental intervention was necessary on November 30th of 2021 during the meeting with Sean Hopkins and Nick Ejak. No one testified that there was a need for immediate intervention of any kind, discipline, mental health, or otherwise. You did not hear testimony detailing how the shooter obtained access to the 6 hour. You just saw in his journal that he said he had access, but you don't know how that happened. No one testified that the shooter knew that there was any sort of code to open the gun safe. There's been some talk about the code that was used on the gun safe with the Keltec and the 6 hour. There was no testimony that the shooter even knew about that code or what it was. You did not hear any mutual concern for the shooter's well-being from his best friend's dad, who you saw text with between James and his friend's dad, who obviously has experience with mental health with his own child, from what you can see in the texts. And even that man didn't express any concern for James's son. In fact, on November 30th of 2021, he texted James, said, "I hope everyone's okay." No one told you that James Crumbley was aware of the texts or videos that were sent to his son's friend. In fact, they all testified, all of the witnesses testified they couldn't tell you that. They couldn't tell you that he was aware. You don't know if the shooter ever actually did do what he told his friend he was going to do. He was going to tell his parents about this, that, and the other. You heard no evidence that he actually did. You heard no evidence that he actually told James any of that. And when you go back for deliberations, think about everything that James Crumbley did not know. He did not know he had to protect others from his son. He did not know he wasn't exercising ordinary care in the way he was storing his firearm because he didn't know that his son was planning what he was planning. He did not know that it was reasonably foreseeable that his son would commit these offenses. He had taught his son firearm safety. He had taught his son to be familiar with those firearms because they were in the house. He had no idea what his son was planning to do. In fact, no one that interacted with James Crumbley's son on November 30th of 2021 knew what was going to happen a short time later. No one. And this is the part of the trial that I dislike the most. The prosecution gets to stand up and make a rebuttal statement, and I have to sit down and I don't get an opportunity to respond. That's how trial rules work. The court has told you that. That's just how it works. But the hard part for me is that every time I hear a rebuttal from the prosecution, I think of all these things that I want to say. Think of all these responses that I can give. So what I'm going to ask you to do, we've gotten to know each other over the last couple of weeks. You've seen how I am in court. You've heard the questions that I ask. So when you go back to deliberate, think to yourselves, what would Marielle say? What would she say about this? What would she say about that? Because unfortunately, I can't tell you. I join with the prosecution in thanking you all for the time and attention that you've paid to this case. You have heard some of the most emotional testimony and seen some of the most difficult things that I can imagine a juror could see. And you likely may not be able to forget it. But what you're all doing in these chairs is of the utmost importance, and I thank you for the time and attention that you've paid. Early on in this case, during our opening statements, the prosecution and I both asked you to follow the law. And I'm going to ask you again, follow the law. The judge will instruct you on what the law is. She will give you very clear instructions. Please follow the law. Review the evidence, review the instructions, and follow the law. Because I'm confident that if you do that, each of you will have at least one reasonable doubt, and your vote will be not guilty. And your vote should be not guilty, not just because you have reasonable doubts, but because James Crumbley is not guilty. Thank you.
So there you have it, everyone. Now, let's compare it to what we had with the Jennifer trial. Jennifer was found guilty. We're still waiting on her sentencing. We did not, in this trial, we did not have an extramarital affair that made the defendant look really bad. We didn't have the messages, the social media connection with Ethan and the discussions of him saying he saw demons. Remember, there was the text messages between him and Jennifer. We didn't have direct incriminating text messages with Ethan that said stuff like, well, just don't get caught next time. We didn't have a negative testimony from someone who we thought was our friend, such as the barn owner, who said that Jennifer was not really the great person that her attorney was making her out to be. But what we did have, we had a sympathetic father versus that cold mother that got a guilty sentence. And he also had a character witness in his sister, which is something that Jennifer did not have. So not that that's going to kill the case or anything, but those were the main differences to me in what I saw in all of this. So today, right now it's 4:20 p.m. Eastern Standard Time on Thursday, March the 14th. The jury has been in deliberation for over 7 hours now. From my understanding, they've come back with 1 or 2 questions that were all taken care of in private in the judge's chambers with the attorneys. So we all are sitting back and waiting. Okay, well, it is now 8:54 p.m. I am just now coming back. I had to go run some errands, and sure enough, there's been a verdict. Can't believe it. So let's go ahead. I'm going to add this to this full recap. I wasn't planning on it, but here we go. We'll watch it together. Bruiser says hi. Talked about pulling a late one or something. So this was streamed about 6 or 7 p.m. Eastern Standard Time on Thursday, March the 14th.
All rise. Court is now in session. The Honorable Shirley Matthews presiding. Your Honor, calling People versus James Crumbley, case number 22279-989 F8.
Thank you, Mark Keys, on behalf of people.
Kerry McDonald, on behalf.
Excuse me, Your Honor, Marielle Lehman on behalf of James Crumbley.
Mr. Crumbley, can you hear us?
Yes, I can. Thank you.
All right, you can be seated. I want to indicate, first of all, there was a question the media was dying to know about. I'm going to read that into the record. I consulted with the attorneys who answered the question, and so then I sent the question back in. They agreed on the answer. The jury asked, please define Article 16.13, bullet number 4, define willfully neglected and grossly negligent. The lawyers agreed to answer the question. Please see jury instruction 16.18 for the definition of gross negligence. All other definitions are contained within jury instruction 16.13. I also want to point out that there's a request by the media to ask the jury members if they would be willing to remain in the courthouse and be questioned off camera. Because there would be a verdict and no other defendant pending trial, I would have been willing to do that. But the courthouse closes at 4:30, and I have continually imposed on the courthouse for the sake of this trial and the other one. I cannot impose on the staff for the deputies any further. I also want to indicate that with regard to case number 22-279990 FH, the People versus Jennifer Crumbley, there is an order restricting pretrial publicity. It was entered on July 14th, 2022. That order will be set aside as soon as the verdict is read. I will also be issuing an order that will obviously not be made public in the courthouse until tomorrow morning. In addition, case number 22-279989 FH, the People versus James Crumbley, the same thing. The order restricting pretrial publicity was entered on July 14th, 2022, and that order will also be set aside as of the reading of the verdict. Are you ready for the jury?
Yes, Ron.
Yes, Ron.
I was just talking, and it was this was about 7:38 p.m. Eastern Standard Time when they came back with the verdict. So I want to say they were in deliberations about 11 hours. 11, 12, 11, yeah. I think that's right.
Good evening. Good evening. Seated. Ladies and gentlemen, I know you've worked very hard. We're all going to wait in your decision. I know this is a very intense decision for you all to make. I believe you've selected a foreperson. Was it foreperson? You're the foreperson. Could you read the verdict, please?
Each count?
Sure.
Count 1, involuntary manslaughter as to Madison Baldwin. Guilty of involuntary manslaughter as to Madison Baldwin. Count 2, involuntary manslaughter as to Tate Meir. Guilty of involuntary manslaughter as to Tate Meir. Count 3, involuntary manslaughter as to Hannah St. Juliana. Guilty of involuntary manslaughter as to Hannah St. Juliana. Count 4, involuntary manslaughter as to Justin Schilling. Guilty of involuntary manslaughter as to Justin Schilling.
Thank you, foreperson. I'm going to ask Ms. Williams to pull the jury. So she's going to ask you each.
Jury in seat number 1, was that and is that your verdict?
It is.
Jury in seat number 2, was that and is that your verdict?
It is.
Jury in seat number 3, was that and is that your verdict?
It is.
Jury in seat number 4, was that and is that your verdict?
It is.
Jury in seat number 6, was that and is that your verdict?
It is.
Jury in seat number 7, was that and is that your verdict?
It is.
Jury in seat number 8, was that and is that your verdict?
It is.
Jury in seat number 9, was that and is that your verdict?
It is.
Jury in seat number 11, was that and is that your verdict?
It is.
Jury in seat number 12, was that and is that your verdict?
Yes, it is.
Jury in seat number 13, was that and is that your verdict?
It is.
Jury in seat number 14, was that and is that your verdict?
It is. Thank you, ladies and gentlemen. I know how hard this has been on all of you, just by reading your face. I know this has been a very hard decision. We appreciate your time. I'm going to ask you to return to the jury room, and I'll be there with you in a few minutes, all right?
All rise for the jury.
So he faces up to 15 years per count. So 60 years total. I feel like
All right, you may be seated.
the judge is not going to give him a very high sentence.
Bond is revoked. Sentencing will be April 9th at 9 o'clock in the morning.
April 9th.
I'll allow both sides to speak to the jury if they're interested.
Oh, she's going to sentence him at the same time.
If everyone can just remain seated.
Does she have to do separate sentencing things, or can she sentence them together at the same hearing? Well, that was a short and sweet appearance. It's over for the families. Now they can have a sigh of relief. And I know that one of the victims' fathers was speaking earlier today while they were in verdict watch. So let me see if I can pull up some kind of pre-verdict conference if they have one. I don't know if they will or not. It might be so late that they decided to do it at another time. It's a lot of deputies. They had to have a lot of deputies there in case someone in the gallery decided to take matters into their own hands, I guess. Okay, they did hold a news conference shortly after this. This was recorded, or this happened about an hour and a half ago. Again, I'm uploading this, or I'm recording this about 9:15 p.m. on Thursday evening, March 14th, 2024. Let's hear it.
Crumbley came in just about an hour ago in Oakland County Court, and now we're going to hear from the prosecutor.
Yeah, she's alongside families of the victims. Let's go ahead and listen in. Here's Karen McDonald.
Good evening. My name is Karen McDonald. I'm the Oakland County Prosecutor. I want to briefly thank Mark Keast, who was our lead trial attorney. Really, he was. So many individuals in my office, the entire office for 2.5 years. We had assistant prosecutors and victim advocates and investigators standing in line to help us bring justice to these families. And I am forever grateful for all of these people who work in this office and serve our county and our state, because we would not be here without them. So thank you. I want to thank Lieutenant Tim Willis of the Oakland County Sheriff's Office and Special Agent Brett Brandon of the ATF. They were instrumental in this prosecution and conviction. They were devoted, they were dedicated, and I couldn't ask for 2 more law enforcement partners that were as dedicated to victims as these 2 men. Most of all, I'd like to thank the mothers and fathers standing to the right and left of me. It has taken unwavering courage. I will forever remain in awe of their strength and perseverance that they have shown in the last 2.5 years. This verdict does not bring back their children, but it does mark a moment of accountability and will hopefully be another step to address and end and prevent gun violence. These were egregious facts in this case. These parents could have prevented this tragedy that was foreseeable with just the smallest of efforts. They could have prevented this shooting and saved these kids' lives and protected the hundreds of kids in the school that day and all of the members of the Oxford community that it devastated. With just basic, reasonable, ordinary care. This prosecution is important. The 3 prosecutions and convictions are critical, but we will not solve gun violence with these 3 prosecutions. Gun violence is the #1 cause of death for children in this country, and it is a public health crisis. And we will not be able to address it until we start treating it like a public health crisis. And yes, access to guns is a critical piece of that, but it's not the only piece. We have to focus on prevention, and that's going to require us to understand and accept that it's not just one thing. It's the #1 cause of death for children in this country. So I refuse to take a victory lap with these prosecutions. It will not bring back these kids. We have a lot more work to do. I've started the commission to address gun violence, and we are working towards a comprehensive approach, and we have hundreds of dedicated people in all different fields to do this. And I hope that this attention that you focused on this case, one, I hope it is always about victims. I hope the constant naming of these people and photos of them will shift to focus on the people standing here, the victims, the kids in that school, the hundreds of kids with not one mark on them that will forever be changed. Let's focus on those people. Let's focus on what we can do to prevent this from happening again. That's where we should be focusing. That's where we should be working. That's my focus. That's my office's focus. And it will be far after I leave this office, which I'm not planning on doing anytime soon. So
I'm glad they put the photos up of the kids that lost their lives.
And finally, I want to introduce the parents who are standing beside me. This is one small step of accountability, but they want more accountability. And I am proud to stand with them in that endeavor. I'm not going to say their names. I'm going to tell them who you are, tell you who they are. Madison Baldwin's mother, Tate Mears' father, Hannah's father, and Justin's father. They're standing here with me today, and I invite them to make remarks if they want to. But first, if Lieutenant Tim Willis would like to make some remarks. Would you like to make some remarks?
No, thank you.
Okay.
Okay. Sorry, I wanted to refresh the screen to make it nicer. Okay, here we go.
He does not want to make remarks.
No, thank you.
Who would like to speak? Steve? Nicole?
So first of all, I just want to thank Prosecutor McDonald and Prosecutor Keese for the marvelous job that they've done, putting in the long hours, them and their team, as well as Lieutenant Willis, Agent Brandon, and the whole law enforcement team that got us to this point. But we're not done. As Ms. McDonald said, these are just the beginning steps. There is so much more that absolutely must be done. It's crazy the way that our society is currently reacting to this. Our children are dying on a daily basis in mass murders. And we do very little about it. We complain about Second Amendment rights, or we say, oh, there's not enough money to put again for mental health issues. You name it, there'll be an argument against it. It's the number one killer of our kids, folks. We can put people on the moon. We can build skyscrapers, huge monuments like the Hoover Dam, and we can't keep our kids safe in schools. I think people just need to wake up and take action. Stop accepting the excuses. Stop buying the rhetoric. It is not a Democratic or a Republican issue. It's nonpartisan. Do not accept any excuse from any of the politicians. This needs to be solved, and it needs to be solved now. We do not want any other parents to go through what we've gone through. It's as simple as that. That's all I have to say. Thank you.
Buckmeyer, Tate's dad, first of all, I want to thank Karen and Mark, Lieutenant Willis, Special Agent Brandon. We met a couple folks that did some work behind the scenes. You guys obviously busted your tails, and we appreciate it. And I kind of want to echo what Steve was saying here. This is a deep issue, and it's not going to be an easy one to solve. And it's more than the gun. Our kids are not doing well these days. We're in a mental health crisis. So the gun is just a tool. So we got to look at other things other than the gun. We got to see what we can do to support these kids better. And that both parties should be looking at that. This is a nonpartisan issue. We need to solve this because no parent should go through the hell we're going through. And lastly, we've taken care of 3 legs of November 30th. And there's still a 4th leg, and that's the school. And it's time for the school to pony up. It's time to break up that administration country club. And it's time for change.
Ooh, See, those all everybody was
We've got
covering their
4
own
kids
butt.
here dead. And nobody wants to take any accountability.
I felt like
That
everybody
needs to start tomorrow.
everybody at that school was covering
Thank
their
you very
butts,
much.
their own butts, and throwing each other under the bus when they were doing testimony.
My name's Nicole Beausoleil. I'm Madison's mom. And I will echo what Steve and Buck has mentioned. I do want to thank the prosecution team, Karen, David, Mark, the advocates, everybody that worked on the case. They have really been that piece that's kind of held us together and really pushed for us and made sure that every step we took, we kept continuing forward. But what I really want to thank is the 3 families that stand with me. This has been a really hard road. And the friendships that I've made with these families are friendships that I wish I didn't have to make the way I did. But these people are some of my best friends, and I thank them more than they will ever know.
Bless their hearts.
What I want to say mostly is, yeah, we have a verdict now. We have a guilty verdict for both parents. We have crossed those 3 lines of getting accountability on that end. But right now we have a verdict. We have to execute that verdict. We have to plan for change. We have to reinforce it. This is not just a verdict for attention or media. This is a verdict that actually needs to be put to the platform that it is. How are we gonna use this verdict to actually make that change that needs? We need to start focusing on the school and its failures, the things that they don't want to admit to. That's going to be our next plan for change. They are going to see these families rise up against it. And we will be here fighting every second for our children because they are not allowed to forget any of them. Thank you.
Good evening, everybody. Craig Schilling, I'm Justin's father. I'd like to start out addressing Karen and the prosecuting team. Thank you so much for your hard work. I can't thank you enough for your efforts in all of this. I'm humbled to be in your presence. Thank you. My heart's beating out of my chest. I'm shaking and so nervous to be here, and I appreciate all of you for your time here. And I really can't say enough about the importance of what we just went through. It's a monumental decision, and the verdict was the same. And I believe that moving forward, it's very important as a society to set the right example for our children and future generations, and come together and use our power of thought and our power of emotion and everything. We can change. We can push forward. We can get through the difficulties of life together if we try. We can't turn our heads to these kind of problems that we face today. It's so important to emphasize the necessity of going after and holding those accountable for their insufficiencies, so to speak. That's where we're at. We have to move forward. We've put much behind us. but there's still so much there in front of us. And I stand with everybody, with these families here, and with Karen and the prosecution, and hopefully with many others, to work on that change that we need, and to go that extra mile and put forth that extra effort to address these problems. I can never imagine being here, and I don't ever want anybody else to have to be here like this. This is a very difficult thing to go through. But I'm happy to have these people here helping me, and all the advocates, all the community members, everybody that has given so much and helped out so much. I thank you all, and I look forward to the future. Hopefully it's a brighter one. Thank you.
We have time for some brief questions.
Karen,
Yes.
is there a message to parents because of these verdicts?
I think it's the message that every single one of us would have before these prosecutions started. You're obligated to use ordinary and reasonable care, and you owe a duty to other kids in that school, in the community, and you're required to exercise ordinary care. It's an egregious set of facts, And, I stood here 2.5 years ago, and I said, this started with one question: where did he get that gun? Where did he get it? And how did he get it? And that is a question that every single one of us as mothers and fathers asked. And that's what has led to the last 2.5 years.
Adrian Broadus from NBC News. Thank you for your time. Really quickly, now that we have a guilty verdict, how will you use this to create change? And what message do you have to other prosecutors around the country who are looking at what happened here, the history made in Michigan?
I started, and my team started the commission to address gun violence because I just simply couldn't stomach leaving this endeavor with 3 prosecutions and then calling it a day, knowing that we have done so little as a country to address the #1 cause of death for children in this country. So I implore everybody listening to this, this is preventable. And access to guns is absolutely a critical part of that, but it's not the only part. It's not the only part. Up until recently, the #1 cause of death for children was automobile accidents. And we have lowered that. How? We've educated the public. We require people to provide car seats. We've made cars safer. We've made roads safer. We know kids, you can't get in a car without your kids saying, put your seatbelt on, don't text and drive. What if we taught kids about guns? What if we taught kids about how to navigate emotional adversity? Programs like that Buck has started, like 42 Strong, where you're making connections with kids and mentoring them and reaching out way before somebody gets into the moment of crisis. And there are good models, which we're going to roll out in our recommendations for threat assessment and crisis intervention. I absolutely applaud these parents for saying what's true. One of these terrible events happens and all we're talking about is the shooter or the people we're prosecuting, but there's so much more. There's so much more. So that's what I'm doing. And I guess the only message I have for other prosecutors is be brave, ask tough questions. And if they don't answer, then keep trying. Because I asked the question, where did he get the gun? And that led to a lot more questions. And that led to disturbing, upsetting, and egregious facts. And I could not stand by and tell these parents that what happened and what we know happened and say, there's nothing I can do about it.
Do you believe that? Did the jury give any indication about what drove it home for them? Did they tell you anything, that we can share?
No, and we didn't ask. They've worked hard. It's been a long week. They're tired. So no, they didn't.
Do you believe that the gun storage law that we now have, that we didn't have before, do you believe that could facilitate bringing this type of case when necessary, given that there's this new legal duty created?
It wasn't in place when I charged the case. But I think any action by our legislature or communities or schools or employers or organizations that recognizes that we have to use common sense when you're handling a deadly weapon. I grew up with guns in my home. Everyone has a right to own a gun, but with that right, of course, you have to secure it. Nobody with looking at this rationally would say that this set of facts is okay. They just wouldn't. The smallest, littlest of things could have prevented these deaths. And as gun owners and those are the peers, they take that responsibility seriously. But all we really require is basic ordinary care, and it wasn't done here.
Prosecutor, along those lines, you ended up using that cable lock during the rebuttal. How much of a lasting impression do you think that made on the jury?
It made a lasting impression on me when I installed that lock for the first time, and my team. We were all sitting around, and it was just very upsetting when I demonstrated that, and it was 10 to 12 seconds. 10 to 12 seconds, and I'm not a police officer, and I'm not an expert in firearms. It's 10 to 12 seconds. And I'm not sure what impact it had on the jury, but it has an impact on me, and I think any parent, and I think for sure these parents standing next to me.
Any idea how many hours your team spent working on the Crumbley cases?
It's been 2.5 years. It was many legal proceedings. I am forever just grateful and impressed with the people. By the way, there's still so many of them. I'm looking at their faces standing here. Investigators, advocates, assistant prosecutors. We're public servants. We don't make any more money because we stay late, but I'm here, and I probably don't focus on that enough, because my first thought is this isn't hardship. This is hardship. This is hardship for these families. So I'm standing in front of a long line of dedicated assistant prosecutors and people in this office who do not complain. We are, it's a privilege to do this, and we know that it can't take the pain away, but it's one small step towards accountability.
Time for one more question.
I have one more question.
Any chances we'll see charges against any school officials?
We want to hold everyone accountable, but at this time, we just worked for two and a half years, and you were all had sideline view. It wasn't easy, so we're going to work with. I've made a commitment to these parents, and I'm going to keep it. And it really doesn't matter what letters after your name, and nobody cares about that. Most of all, me. I'm going to look at the facts and work with them to get the accountability they deserve. But most importantly, they're not here because they're angry. They're here because they want to prevent someone else being in that position. Thank you so much.
Can you talk a little bit about the differences between the two cases?
Kerry McDonald, Oakland County
All right, there we
prosecutor,
have it.
with her.
Okay, so here's the down low. And you know what? I think I was wrong, because I think Jennifer's trial, I had stated that they threw the lawsuit out, but they filed they filed a lawsuit against the Oxford High School administration. And then in March, a Michigan judge dismissed it. It was actually, I think there were several lawsuits that were filed. But then in May, on May 12th of 2023, AP News, a group of families won a key court victory in an effort to pin some responsibility on the on a Michigan school district. And then they came up with on October 31st of 2023, they came up with a 600-page independent investigation. And let me pull that up really quick, because I know that after that happened, around the same time on October the 5th, Hannah St. Juliana's parents filed a lawsuit, a separate lawsuit. Let me show you guys this. This is from CBS, and it says that a nearly 600 investigation report finds that the Oxford High School shooting could have been prevented if proper training and guidelines had been in place. Oh gosh, I can't pronounce her name, but the mother of Madison Baldwin, one of the 4 students who was killed in the November 30th, 2021, said she was shocked but not surprised after examining the report outlining what investigators discovered on the days leading up to and the day of the shooting that took place and took the lives of Baldwin, Tate Meyer, Hannah St. Juliana, and Justin Schilling. She said, honestly, I am enraged with it. I knew that there was preventable measures. I knew there were things that were failures. I knew that there were a lot of missteps. I didn't know the severity of them. She said it was a slap in the face to the victim's family that some of the Oxford School District employees did not fully cooperate with the company that the district paid to conduct the investigation that took nearly 2 years. Because I know when I was doing the report from Jennifer Crumbley's trial, can't talk. It did say that one of the guys, I think it was the counselor, he was on like leave or something from the school district. The report conducted by Guidepost Solutions says the district failed to adhere to its threats assessment policies on the day of the shooting, when 4 students were killed and 7 others were injured, including 1 teacher. The parents are part of a civil lawsuit against the school district. The suit is aimed at holding the district accountable. Regardless of what the investigation revealed, the parents question how those involved can sleep at night knowing they could have prevented this tragedy. So this is out. This report is out. You can't hide it behind us, and you can't hide it from us. We're going to continue to fight, so be ready. Currently, Oxford Community Schools is protected by governmental immunity. It is unclear whether or not this new report will have any impact on the district's ability to be protected by this defense. All right, so that was dated, again, October 31st of 2023. Now, according to Detroit News, it says Oxford school shooting victim's family sues Michigan State Police in latest legal challenge, saying that the Michigan State Police officials failed to aggressively intervene and prevent the Oxford High School mass shooting, according to a lawsuit filed by the family of a slain student. That alleged failure, including neglect to make a timely risk assessment and intervene after receiving tips about threats and disturbing behavior by high school students, including Ethan Crumbley, the Oxford High School student who would go on to kill 4 classmates at the school in November of 2021 and injure 7 others. The allegations emerged in a lawsuit filed in the Michigan Court Claims by Steve St. Juliana, the father of slain student Hannah St. Juliana, who was 14 at the time of the shooting, a claim that represents the latest attempt to hold officials accountable for the mass shooting. In this case, the Michigan State Police failed to follow the statutory required policy and practice of making a timely risk assessment and failed to aggressively intervene to prevent the November 30th mass shooting from occurring. That's what the lawsuit says, or what he says in the lawsuit. And the family is seeking an unspecified amount of damages for Hannah's wrongful death. State police officials acted promptly. State police officials act promptly on all tips reported through the agency's okay to say. It's literally okay, the number 2, and then the word say. Confidential programs and share credible information with school officials and law enforcement partners. Oh, I'm fixing to sneeze. Hang on. I'm having a sneezing fit. Against agency spokeswoman Shannon Banner. I lost my spot, so I'm just going to start here. Okay, so the state police officials acted promptly on the tips reported through the agency, and they share credible information with school officials and law enforcement partners. Out of respect for the families, we will not, this is what they said in the lawsuit, out of respect for the families, we will not publicly dispute the allegations made in the lawsuit, except to say that okay to say, which is okay to the number 2 and the word say, did not receive any tips related to the violence carried out at Oxford High School or the individual who committed this crime. The lawsuit described a series of tips before the shooting that included a report about a senior throwing a severed deer head from the high school roof, and that Crumbley had brought a severed bird's head in a jar to school. Michigan State Police also received a tip days before the shooting about a planned school attack. This is all in the lawsuit. The tip was forwarded to an assistant principal and an Oakland County Sheriff's deputy who reported, quotes, "We've looked at all of those already. I still do not see an actual threat in any of these." That was the deputy's response, or that was what he said, according to the lawsuit. Minimally enhanced security measures triggered by the escalating incidents of the school violence, if timely mandated by the Michigan State Police, would have been effective in deterring further escalation of the risk of school violence, or would have prevented the November 30th shooting from occurring. Steve St. Juliana is also suing Oxford schools in a federal court. That case is on hold. Okay, so I'm going to open that up and reread that in a minute. While the district appeals a federal judge's ruling that civil claims against an Oxford High School counselor and the dean of students, both who testified in both the trials, can proceed against them for their alleged actions before the shooting. Crumbley has pled guilty to 1 count of terrorism, causing death, 4 counts of first-degree murder, 7 counts of attempted murder, and 12 counts of using a gun during a felony. Now, obviously, we know that he's already been sentenced and everything. Now, the parents will stand, and that's old news. Okay, so here's a picture of the high school. All right, now that report was dated in October. That news report was published October 5th. Okay, now let's go over to this other one that was published that says, this is also the Detroit News. It says Michigan State Police officials failed to aggressively intervene and prevent the Oxford High School mass shooting, according to a lawsuit filed by the family of a slain student. That alleged failure included an... Am I not on the same damn thing? Y'all, I am. Hang on. Losing my mind. God bless me. Here it is. This is by the Detroit Free Press. Okay, this is the one I wanted to look at. And this is dated May 12th of 2023. It says a federal judge ruled Friday that a lawsuit from family members of victims in the November 2021 Oxford High School shooting can proceed against Oxford Community Schools and 2 of the school's staff members, while also dismissing 7 former and current staff members from the case. I see. Okay, so I guess what they did was because that was my question. What about the teachers that were involved in all this? I mean, I couldn't believe they only listed just those 2 people from the school administration. But I guess all the teachers have been pulled out of the suit. Judge Mark Goldsmith in the U.S. District Court in Detroit ruled against requests to dismiss the school district, along with Sean Hopkins, the counselor, and Nicholas Ejak, then school's dean of students. So I guess he no longer works there. Goldsmith wrote that the attorneys for the victims' families have plausibly argued that Hopkins and Ejak knew shooter Ethan Crumbley posed a risk to Oxford and failed to address that risk. I still think that they should have checked his backpack. That should probably be a rule. And maybe, if anything, that's what's brought in by some of these lawsuits, is that there's some kind of act that goes into place that says any student that has any kind of threat brought upon them, automatically the schools should be made to check their belongings, their lockers, their backpacks, their cars, whatever is on school property at the time. But I think I know that for a fact, I saw something where one attorney had said that the school has a right to check the backpack, but the police do not have a right to check the backpack. So it goes to both sides. The parents or anyone from the school could have said, let's open this backpack and just make sure that we're okay here, because they were freaking carrying it around. EJAC was. It says the ruling does not mean the district or the staff members have been found liable. It means that the attorneys on both sides can move forward in finding more information, the process of discovery, to try to prove or disprove their case further. Goldsmith dismissed 7 Oxford staff members from the claim, which was the former district superintendent, okay, there's 2, the former principal, a restorative practice coordinator, and the teachers. There's 3 teachers involved. The ruling comes on the heels of a third-party safety report that found Oxford High staff are not consistently asking students being assessed as possible threats whether they have access to firearms. Attorney Ben Johnson called the ruling a monumental win in the case against the district. It's a battle, one of many battles in a very long, difficult war, but we're very proud. Johnson said he expects the district to appeal the decision next, but also hopes to begin taking depositions in the federal case. We are very, very confident that once we have that ability, it will be even more clear than it is already, is that this entire shooting could have been avoided because of all the knowledge that they had at the school. A spokesman for the Oxford County Community School did not immediately return a request for comment. All of the families of the students killed in the mass shooting, Hannah St. Juliana, Tate Meyer, Madison Baldwin, and Justin Schilling, have filed suit in federal and Oakland County Circuit Court. Injured students and students struggling with the trauma from the attack have also filed various suits, and the claims in the state court suits in the county suffered a setback in March. However, when Judge Mary Ellen Brennan ruled that school district employees are immune from civil litigation in the shooting under Michigan's governmental immunity law. But the report released Monday examines that the high school's current threat and suicide assessment procedures, as well as safety and security policies. The report found that the Oxford policies largely follow leading national best practices, but pointed out some improvements, including an inconsistency in how often staff asked students assessed for threats about access to weapons. According to Guidepost, this was just the first report to be released in what will be a series, and an independent investigation of the events leading up to and during the shooting is still forthcoming. But that assurance has done little to ease frustration among former board members and parents who have, for more than a year, demanded increased transparency from the district. Former board president Tom Donnelly, who resigned from the board in 2022 out of frustration over how the district was handling the aftermath of the shooting, said in an interview with the Free Press on Tuesday that Guidepost's initial report was thorough, but not the one that the community wants. The community still hasn't gotten the third-party independent review of what took place in the month preceding and in the days and then the days up. Okay. And here we are going almost a year and a half later. So now it's 2 years because this was done in October. Corey Bailey, a former board treasurer who resigned around the same time as Donnelly for similar reasons, wrote in an email response to reporter questions that he was not surprised to see gaps in threat assessment procedures and felt that the district did not take threat assessment training before the shooting either. The report found many elements of Oxford's threat assessment procedures to be working, including an established centralized reporting system, defined procedures, and defined conduct considered possibly threatening. However, the report also found that Oxford may be conducting too many assessments, 300% more than a district of its size, creating a difficult workload for some counselors, and that the district needed to include school station law enforcement officers in every assessment. The teachers already have such a huge weight on their shoulders for the pay that they get. And then to have something like this come on, I don't know. I want to hear more about this, what's going on here. And it is going to impact what goes forward. Now, remember, I did a report recently on the July 4th attacker. His dad helped him procure a gun because he was, I think, under the age of 18. And he pled guilty to charges. It was in a different state. What state was that in? Was it Ohio? Now, that gentleman, that attacker is actually, I got to look that up because I think he had already gone back into court, and I wanted to check on that. That was this month in March of 2024. Andrea Jones, a parent in Oxford and part of the parent-led group Oxford for Change, formed after the shooting, said that the report did not answer many lingering questions, and for her and other parents, including pressing questions about how the shooting unfolded. Well, I think a lot has been answered now that the trial has come out. Let me remove that. Well, I want to thank you guys. I know this was a very long video. I actually did it in a couple of different pieces, and I thank you for your patience, and I thank you for, if you've gotten this far, thank you for being here with me. I hope that I've helped bring some insight into what's going on because, again, remember, this case is setting the precedence for what's going to happen in the future. Will it help? It might. It just might. It might take, had more measures been in place, maybe Jennifer and James Crumbley would have said, oh, we can't let him do that because now we can be held accountable. Well, you should be held accountable for your child's actions. But I think there's a limit. And again, I kind of talked about that earlier in the video, but I'm not going to go on my rant with that. We'll just watch how this all plays out. And I'm sure this isn't the end of the story. I will stay on it. And I will come back with whatever updates we have. Well, first of all, April 9th, their sentencing. We'll be back for that. Y'all have a blessed evening, and I will talk to you very soon.